Thank you, Pam. We are on day 13 of the hearing in the Clean Fuels Transportation Program. Pursuant to general agreement last night, we're beginning at 8 o'clock this morning. We will still have a 1 o'clock public comment period, and we'll see what the end of the day looks like. In the meantime, I think by agreement, we have Dr. Schubert coming up first.
We do, Madam Hearing Officer.
Mr. Trujillo, go ahead.
Good morning, Madam Hearing Officer, members of the board. We will be calling Dr. Adam Schubert. Is he on?
He's on.
Yes.
All right. Dr. Schubert, can you unmute?
Yes. Good morning.
Oh, good morning. Would you spell your first and last name for the transcript, please?
It's ADAMSCHUBERT.
Thank you. And do you swear or affirm to tell the truth?
Yes.
Thank you so much. I'll just keep it slow.
Okay.
Good morning, Dr. Schubert.
Good morning.
Dr. Schubert, did you provide testimony on behalf of NMOGA and API previously in this matter?
Yes.
As a part of that testimony, you described your qualifications, including your education and work experience, correct?
Yes.
Did you provide a SIR rebuttal testimony for this matter?
Yes, I have.
That SIR rebuttal is marked as NMOGA API Exhibit 20, correct?
That's correct.
Do you have any changes or corrections to NMOGA API Exhibit 20, the testimony itself? I think, I'm going to pause right there. I think you have a change to your PowerPoint, if I recall correctly, is what my co-counsel told me.
That's correct. No changes to the written testimony. I do add edits to the demonstrative.
And what were those changes to the demonstrative evidence?
They are wording changes on the last bullet on slide 6 and on slide 7.
Thank you. Do you adopt your NMOGA Exhibit 20 as your rebuttal testimony?
I do.
Dr. Schubert, can you go ahead and provide us a summary of your rebuttal testimony?
Madam Hearing Officer,
Ms. Sona.
Given the Foundation Council just laid, I believe it's now appropriate time for me to raise 2 brief matters, if I may.
All right.
The first matter is regarding the PowerPoint that Dr. Schubert intends to use. That PowerPoint came unexpectedly. There was no request to use a demonstrative with this SIR rebuttal. Additionally, in review of that PowerPoint, it contains information that is not in the testimony, and I believe it is prejudicial to present the PowerPoint. Additionally, wording changes undisclosed are unhelpful now to me in preparing my cross-examination, having no idea what Dr. Schubert is going to share in a demonstrative that could be different than his testimony. Additionally, in that PowerPoint, Dr. Schubert claims his testimony, in his testimony, Dr. Schubert claims it is reliable, necessary, and appropriate for regulatory use in this board's considerations. However, his PowerPoint now explicitly disclaims the suitability of his testimony, and that creates a credibility conflict that either must be waived or I'd assert that there's no reason for Dr. Schubert to testify today because you will not be allowed to rely on his testimony based on that disclaimer. Additionally, to make my record, as demonstrated in prior voir dire and cross-examination, Dr. Schubert's not a lawyer and has never held the role as a government regulator. Based on his prior testimony, he's not qualified to offer economic opinions because he has no degree in economics or any supporting evidence. Moreover, the nature of his work is proprietary, and his testimony should only be given the weight of a point of view rather than as factual evidence. Thank you.
Thank you. Mr. Trujillo, do you have a response?
Madam Hearing Officer, to see if I can catch all of the, the comments there. I'll do it briefly as I can. With respect to the demonstrative evidence, I believe there's no prejudice to the other side. There are minor wording corrections. If we want to take the time to go through and have Dr. Schubert explain the changes in the demonstrative evidence, we're more than happy to do that at this juncture, so you can make a determination as to whether it's prejudicial or not. I'm being familiar with the changes. I don't believe there's any prejudice whatsoever. Again, it's nothing more than a demonstrative evidence for him to summarize his testimony. With respect to the objections that she raised on the background and qualifications, I believe those are ruled on previously by you. Same objection as previously raised as a part of his direct testimony. With respect to the credibility conflicts, I believe, I'm unsure as to what counsel is talking about. We can take the time to go through that. I believe, again, it was just a disclaimer or some wording that Dr. Schubert used as a part of his testimony to clarify his perspective on things.
All right, thank you. What I'd like to do, because we can have the conversation once or twice, it sounds like, is to go through it and then revisit the discussion, so we're not having the discussion twice, so that we hear what the corrections are through his testimony. And then there may be some cautions necessary for the board. Ms. Sima.
Thank you, Madam Hearing Officer. For clarification, when I begin my cross-examination, would you like me to point out where I see those problems potentially?
Exactly. Thank
Okay,
you.
thank you.
All right, go ahead, Mr. Trujillo.
Dr. Schubert, when you do get to your PowerPoint on the particular changes, I'd ask you to pause and explain those changes as you're going through what those changes were. So
Very well.
With that instruction, would you go ahead and summarize your direct testimony or rebuttal testimony?
Thank you. Let me get that on the screen.
Sorry for the interruption, Mr. Trujillo. I don't think we were sent the demonstrative exhibit. Were we? Okay. Pam, would you look for that and send it to the board members or post it on the web, please? Okay, thank you. Go ahead, sorry.
Go ahead, Dr. Schubert.
Thank you. Good morning, Madam Hearing Officer, Madam Chair, and members. Thank you for the opportunity to testify this morning. In rebuttal, I'm with Stillwater Associates and testifying on behalf of NMOGA and API. My rebuttal testimony today focuses on the so-called ZRP scenario, as was offered by NMED in their rebuttal testimony. Key points in my testimony today are the significance of the ZRP cases, why I believe that the ZRP modeling understates the program costs, provide some additional context on how I look at credit pricing and the implications for CTFP program feasibility. So I've been in this business for over 40 years now, and I have yet to see a 15-year period such as between now and 2040 where there haven't been significant changes in federal regulations, let alone state policy changes. And that's true for both the BCA case, which was presented in direct testimony, as well as the ZPR scenario, which has been offered in rebuttal. Nonetheless, the CPR scenario plays a very useful role in furthering the information available to the board, I believe, in representing a more close approximation to what the current state of the regulations are. While we can debate what may happen in the next 15 years, what's not debatable is what has occurred within the past year and between the time that the BCA case was prepared and today. Reviewing that briefly, the federal government has terminated all EV purchase incentives. The Congress has acted to rescind the California waiver, which enables the NMVES, while New Mexico and California and other states are contesting the legality of that action. My understanding, as not a lawyer, which I am not, is that that rescission is law unless and until the courts rule otherwise. And I have offered no view on the likelihood or the timeline for that to occur. Just a matter of, I think the board needs to keep in their minds, and I'm sure they are. The last change is an item that currently is unsettled, and that's the EPA's action to rescind their GHG endangerment finding, and their intention to withdraw the GHG provisions of vehicle emission standards. That has gone out in proposal earlier this year. The public comment period is closed, and sometime in the near future, we can likely before July of next year, when the CTFP takes effect, we'll probably have an answer to that. On that basis, I think the ZPR scenario is a very valid scenario for the board to be considering and understanding the potential operation and feasibility of the CTFP as established in legislation.
Dr. Schubert, pardon the interruption real quick, but just for purposes of the record, can you please explain what ZPA and BCA are?
Okay,
ZPR.
Yes, so BCA is the benefits cost analysis as prepared by NMED in their direct testimony, as the benefits cost analysis as required for, as I understand, under New Mexico's regulatory process. The ZPR, which I don't remember exactly what that acronym is the case that they've scenario they've modeled as part of the rebuttal, or where the ZEV provisions that I've just discussed were not in effect, to see that alternate scenario.
Dr. Schubert, real quick, for just to refresh your memory, does zero emissions vehicle sound familiar? Is that the ZEV and then the ZPR? I think it's explained in your testimony here.
Yes.
Go ahead and proceed. I'm sorry.
Okay, thank you. So the data, the data presented in this chart are taken directly from NMED Exhibit 136, presented in rebuttal. Looking first at the yellow bars in this chart, this is the annual credit bank balance that comes out of their model in millions of metric tons each year. And the numbers next to it are the CI reduction standards as proposed for those years. Key point I want to make here is that they model the credit bank balance is rapidly increasing through 2029, when we have the 11% proposed CI reduction standard. And so this industry is significantly over complying in order to build this credit bank. And then every single year after that, the credit bank declines. In other words, industry is not meeting the standard each year and merely drawing down banked credits. If the CTFP were to terminate after 2040, that would be a reasonable case. But my understanding of the law is that that is not the case. There is no sunset in the legislation. So what happens after 2040 matters, and the market would not, in my opinion, operate this way. This drawdown in the credit bank would would result in a severe increase in credit prices because there's no credits because of the very limited liquidity. The measure of market liquidity, which I like to use, is the credit bank to quarterly deficits ratio, or I'll abbreviate that as the B to D ratio, which is shown by the red line. Again, this is calculated from the data presented in NMED Exhibit 136. This is a parameter that's not unique to me. This is widely used in the amongst folks that look at LCF programs. It's actually one of the two parameters that California uses in their automated acceleration mechanism, which is in their current regulations, as a measure of the size of the credit bank. And we see that rapidly decrease. But looking over credit prices in the other existing markets over time is that when the B to D ratio goes up, credit prices go down, and the reverse is true. When it goes down, prices go up. For example, in Oregon at the end of 2024, the B to D ratio was greater than 2 and credit prices were 50. Today, the ratio is 1 and credit prices have tripled to around $150. California, in their automated acceleration mechanism, sets a threshold. If the B to D ratio goes above 3 is when they accelerate because there's too many credits in the market. And historically, when the credit ratio goes down below around 1 or so, credit prices greatly accelerate. And so that's why that gets me to a B to D ratio of around 2 would probably be a stable market based on my experience. Credit ratios below that, in order for the market to get to stay at a 2 B to D ratio out to 2040 would require that deficit generators have to acquire more credits than what was modeled, and that would come at additional cost to the market. We've discussed.
Are you saying B2D as in David?
Yes, Baker/David.
Thank you.
So I talk a lot about renewable diesel as does NMED in this scenario, in this ZRP scenario. Reminder why renewable diesel is important is because of all the fuels that are potentially present in the market in New Mexico under the CTFP. It is the one fuel that deficit generators have the freedom to vary between 0 and 100% of the diesel fuel in short order and be compatible with all of the diesel vehicles on the road. As such, it is the marginal source of compliance in my experience. Going forward, California has chosen to, in the near future, to restrict the soy and canola-based renewable diesel and biodiesel. And so in the future, the Oregon and Washington prices will be most relevant for where we expect New Mexico to be competing for supplies of renewable diesel. Key factors that we see in setting credit prices, and I perform one of my job functions for Stillwater is to do our credit price outlook for California. The volume of renewable diesel and biodiesel, the CI reduction standard, the B to D ratio, and the cap and another item that I haven't mentioned previously today, cap and invest credit prices. The NMED rebuttal testimony talks a lot about the credit prices in Washington and how low they are, and that is correct. Of the 3 existing markets, Washington does have the lowest credit price. and they put together this chart to help us understand where California, Oregon, and Washington are today on these parameters, and where New Mexico is projected to be in 2030 and 2040 in the in NMED's ZRP CTFP case. Renewable diesel content varies significantly. Oregon and Washington were much higher than that in last year, but that's dropped considerably with the changes in federal tax credits. Percent CI reductions are very different between these markets. Washington currently has a very high B to D ratio, and that's what one reason. And these reasons combined, along with the cap and invest, lead to Washington's very low credit prices today. Cap and invest in California and in Washington provide an additional source of value for renewable diesel. That's part of their any renewable diesel used is not subject to the cap at the rack cost, which is the cost of those states' programs, and so creates additional value that is not replicated in Oregon and will not be replicated in New Mexico. And that adds substantial value to renewable diesel, which would have to be made up for by a higher credit price, both in Oregon today and in New Mexico in the future. I'd like to move on now to the logistics investments required for the 91.9% renewable diesel content that was modeled in the NMED's case, and that I should say renewable diesel plus biodiesel. For some perspective here, the HF Sinclair renewable diesel plant currently has a production capacity that's, I believe, is roughly 20% of New Mexico's current diesel demand. And I'm in agreement with NMED that the additional supply is likely to come from out of state by rail. NMED, expects that this would occur by rail transloading. So we need to put in additional rail transloading capacity to be able to handle that additional volume. There is some rail transloading capacity today where rail cars loads of ethanol are transferred to truck for delivery to terminals that don't have rail access. Addition to move renewable diesel by the same route requires additional facilities. It also requires additional rail cars, which is not mentioned in NMED's analysis. Production of new rail cars is severely backlogged as of last year. The rail car industry reported a backlog of approximately 18 months, so over 240,000 rail cars, and that's gotten more difficult this year with the imposition of steel tariffs for the steel that's required to build those rail cars. Another key impact is the increased truck traffic around and inside of the terminals that this will generate. Currently, terminals have very little inbound truck traffic. They do get ethanol by truck, 1 truckload of ethanol roughly for every 10 truckloads of gasoline going out of the terminal. In order to blend 90% renewable diesel and supply it by truck, that means 9 truckloads of renewable diesel going into the terminal for every 10 truckloads of blended diesel going out of the terminal. And so there is an impact for the roads, intersections, and neighborhoods around those terminals that would need to be addressed in order to supply terminals with renewable diesel at that level of volumes. Additionally, some terminals may require new tanks in order to store renewable diesel and blend it into the diesel product. all of,
Dr. Schubert, real quick, we're getting close to time, so if you could wrap up, that would be greatly appreciated.
yes, this is my second to last slide. So the last bullet on this slide is one of the slides that I mentioned. I adjusted the editing towards editing the wording of to reflect a better understanding what NMED has proposed with regard to the startup of the program and the extension of the initial compliance period. So I had to adjust the wording to accommodate that, and so that was my error. And the key point being that time period at the start of the program will be critical, as NMED has modeled for industry to build up a credit bank, but their ability to build up that credit bank by blending rapidly increasing volumes of renewable diesel will be constrained by the logistics that are required in order to deliver that renewable diesel. And my final slide just summarizes the takeaways from what I presented earlier. The ZRP scenario is a very good representation of where the current federal regulatory landscape is. But it does, in my opinion, understate the compliance costs because it allows the credit bank to go to zero at the end of the time period. I discussed the the variables that need to be considered in comparing current credit prices in California, Oregon, and Washington to what may be expected in New Mexico with the adoption of the CTFP regulations, and the need for time for the renewable diesel logistics investments to be put in place in order for industry to be able to blend the levels of renewable diesel that have been modeled. And that concludes my presentation, and I'm happy to take questions.
Thank you, Madam Hearing Officer. We offer Mr. Schubert for questioning.
Thank you very much, Mr. Trujillo. Mr. Noyes, do you have questions? Oh, Ms. Sona.
Madam Hearing Officer, I believe before we turn to cross-examination, it would be an appropriate time to address some of the inconsistencies. I'd like to note that, and this may be a little rough, they're just from my notes. I'd like to note that Dr. Schubert skipped the slide number 2 in his presentation, which is the disclaimer that I stated, which states at the bottom an implied warranty that you all cannot rely on his testimony. And that's a direct contradiction. As I stated in my motion, you can't have it both ways. It's not fair to use up this board's time to provide information that's merely points of view that could be provided in writing as a perspective from NMOGA and API, where here, this cannot be evidence. This disclaimer was the same disclaimer that was in his report the first time around, to which we objected to. It was demonstrated again that that testimony was unreliable. So, we're getting, of all my motions, Madam Hearing Officer, we are really getting to the extreme line of prejudice here. We're getting to surprise in the information being presented to us. The considerations and analyses for the B/D ratio is nowhere in the testimony. There was no indication of the thought process that Dr. Schubert was going to be presenting today. PowerPoint slides are not evidence. I shouldn't be expected to have to cross-examine him on new information in slides disclosed 14 hours after the testimony. It's appearing that he continued his analysis after providing the testimony and is just trying to shoehorn more information into this hearing. I believe my last point would be that this is not surrebuttal. This is additional analysis on perspectives regarding credit generation in other states, what that means for credit generation here in New Mexico. It's new perspective about renewable diesel infrastructure. This is not responding to what was in what we affectionately call the Zephyr analysis. There's additional testimony about things like the endangerment finding, conclusory statements about the state of the law that are nowhere within this SIR rebuttal. All of this is a surprise. And so I would, object now to having heard all of this, to having read all of this. This was not what was represented by NMOGA and API Council when they saw our concurrence to allow SIR rebuttal. So for that reason, Madam Hearing Officer, I do believe it's appropriate to strike from the record all of the oral testimony that Dr. Schubert just provided, not admit as evidence the written testimony that was filed in the docket, and for us to move forward without any additional cross-examination of Dr. Schubert. Thank you.
So hold on, Ms. Sona. I thought when I read Dr. Schubert's this SIR rebuttal, the written SIR rebuttal, not the slides, that he did point to the testimony by the department about the unlikelihood of the bookend scenario, and was pointing out, I think, what a lot of us know from the news, the rapidly evolving federal landscape.
And Madam Hearing Officer, today he testified to the direct opposite of that, which was that the bookend scenario in the Zephyr analysis is a very likely scenario. That is the quote that I wrote down.
Okay. But I mean, to your point that none of it was SIR rebuttal, that part looked like SIR rebuttal to me. Or
of any of it, that would be the closest, would be maybe that first page.
yeah, okay.
And in his oral, he went above and beyond what was shared in that first page and a half.
Okay. I am curious, so thank you for that, Mr. Trujillo, about this BD business, because I wasn't. Can you explain either where he talks about it in his written testimony or how it is SIR rebuttal? Okay, yeah.
Madam Mayor, now, sir, I think the important point to start with this set of objections is the fact that we got a very complex model literally about a week and a half ago. And I think the remedy really, if anything that you need to look at is the potential prejudice. We're responding to a very complex model at this juncture that was just recently disclosed. It wasn't in the beginning, wasn't in the middle, or at the very end of the entire proceeding. So I'd make that comment as the overall comment as the starting point. With respect to the BD issue, we can ask him and continue to ask him questions to lay an additional foundation for it. I will say this, that the essence of the new information that was contained in the new modeling, this is an expansion as he presented in his testimony and his analysis that was critiquing exactly what came out, what he was able to discern from the modeling that did occur. Again, we can go through and have Dr. Schubert lay a foundation if necessary. And finally, the objections on the credit issues. The department itself argued that the board should consider Washington or look to Washington. That's exactly what I'm sorry, NMAC argued that the board should look at Washington. It's exactly what Dr. Schubert was addressing as a part of his testimony during SIR rebuttal.
All right, so I think I'm going to turn to Dr. Schubert first and just ask about this BD business and whether, in fact, because we up here on the dais have done a word search and we just don't find it anywhere else. And why that is only now part of his testimony.
Dr. Schubert, can you explain to the hearing officer and the board how the BD analysis fits into your testimony?
Yes. So you are correct that I do not, talk about B over D in my written testimony. And I apologize for that. I do discuss the comparison between the Washington and New Mexico credit prices, and the B to D ratio is an important element in explaining that difference.
Sounds as though that was testimony that could have been offered earlier.
And again, Madam Hearing Officer, I would go back to the fact that we just got the model as he's looking at it and so forth. And we can figure out a way to relate it to the exact testimony. But again, there's several comments that come in during oral testimony. Is it necessarily completely germane and relate to his underlying testimony they did submit? I would say yes, as you go through it, as he's comparing the credit prices and taking a look at it, and doing an analysis on the underlying model that we just recently got at this juncture.
Okay. Ms. Sona, do you have a reply here?
Can I have just one moment?
Yeah. Ms. Sona.
Thank you, Madam Hearing Officer. Respectfully, I heard no basis in the response or in the explanation from Dr. Schubert to allow him to continue with his analysis, except for anything potentially he might be able to continue with the discussion about ZEVs and federal policy changes. The helpfulness of that, though, it's the state of the law. Law is not evidence. We don't need to explore that with a witness who's not an economist, who's not a lawyer. It's not helpful. We explored that extensively at the beginning of the hearing. It's very thoughtfully laid out in the department's Zephyr analysis. I don't believe the SIR rebuttal is necessary when counsel will have opportunities to cross-examine two witnesses, actually three witnesses that were involved in that analysis to be able to draw out any information. As was stated, Dr. Schubert's SIR rebuttal is an expansion analysis. That's not SIR rebuttal. SIR rebuttal is a very discrete mechanism to respond to something. We knew this modeling was coming. It was testified about by our witnesses during the direct. They recognized the concerns that were coming up from the questions, and we disclosed on the record very early on that this modeling was coming. Our folks have been working literally day and night on this work, and to have this 11th hour testimony that's just not responsive, it's prejudicial, Madam Hearing Officer. And so, I'd move that we just don't move forward with this. Thank you.
Okay, no, I understand. It's,
And
yes.
as an alternative relief, if you do decide to move forward, similar to how Dr. Rasso is going to be given an opportunity to respond orally to the SIR rebuttal of Dr. Laskowski, Mr. Ford would like to just have an opportunity after his testimony to to just briefly talk expert to expert about what this means.
All right, thank you very much. So as you can imagine, Ms. Sona, I'm trying to walk this line between not wasting time, if you will, on things that the board can't rely on, but also wanting to not feel later as though we need to reopen the record to take something in order to allow everyone to present their views and arguments and data. So what I'd like to do with the board members clearly understand what it means for a witness to caveat, right, his or her testimony to say, well, I'm not sure you can rely on this. The board and I certainly understand what it means to have a non-lawyer talking about developments in the federal legal landscape, which is, I think we all agree, rapidly evolving and would be hard to rely on any particular snapshot there either. Having said that, I'm not inclined to strike what he's saying, and to the extent Mr. Trujillo has tied this back to the department's evolving modeling, it might be useful to have that perspective in response to it. So with all of that, perhaps we could do the kind of cross-examination that seeks to understand what it is he's offering and focuses less on the issues you've already raised, which is whether the board can or should rely on it. So with that, Mr. Noyes, do you have questions of Dr. Schubert? Oh, he's flying this morning. Ms. Menard, I don't know if you're on or not. Okay. Ms. Menard, do you have questions of Dr. Schubert?
Not. Thank you, Madam Hearing Officer.
I didn't hear that.
Can you hear me?
Oh, now I can hear you, yes.
No questions.
Oh, thank you. Mr. Nasco, I don't know if you're on the line. Okay. Mr. Duff? Mr. Smith? Mr. DeSalen?
Yes, thank you, Madam Hearing Officer. I just want to say, we do not have any questions for this witness on behalf of CCAE, but I do want to state that we share many of the concerns that Ms. Sona has expressed about the reliability of this testimony. Thank you.
Thank you for that, Mr. DeSalen. Mr. Lobdell? Mr. Sorayas?
No questions. Thank you.
Thank you. Ms. Vercruz? Ms. Tremblay? Mr. Maxwell?
No questions.
Thank you. Mr. Weatherby?
Madam Hearing Officer. First of all, I think Ms. Sona raised an important issue, and maybe it can be clarified from my perspective, but I didn't catch slide 2, and I've been looking for it. I understand that it's probably part of the record, but is there any chance that slide 2 of Dr. Schubert's presentation could be posted again on the screen? And that's the only question I have.
Dr. Schubert, can you display slide 2?
Yes, just a moment.
Thank you, Mr. Weatherby. Mr. Harris? No questions. He said no questions. Mr. Tucker? He said no questions. Ms. Olson? No questions. She said no questions. And Ms. Sona?
Thank you. Good morning, Dr. Schubert. You get to see the back of my head, but I can see you in front of me. I know last time you were with us, you got to converse with my co-counsel, Jessica Nixon. You get me today, though. I want to start us. Also, just so you know, you may have realized already, but there can be some delay between what's happening inside here in the hearing room and what comes across on the platform. I'm going to do my best not to cut you off, but if you could listen to my questions, some of them might be yes or no. That will help us get through this in the time that I have allotted. Okay?
Understood. Thank you.
Okay, thank you. In your SIR rebuttal, you advocate for a credit-only initial compliance period in the CTFP, right?
Yes.
And one of the main stated purposes for that proposal is to ensure regulated parties have time to build a credit bank before any compliance deficits must be covered, right?
That's correct.
And so you reviewed NMED's ZEV policy rollback, ZPR, or what we affectionately call Zephyr, that modeling scenario in Exhibit 134 as the basis of your SIR rebuttal testimony, correct?
Yes.
So you would agree that the Zephyr's assumptions included the immediate and permanent rollback of NMBES and federal greenhouse gas tailpipe emission standards, right?
Yes.
And based on the Zephyr modeling, you're aware that the CTFP bank balance at the end of 2027 is modeled to have over 500,000 cumulative banked credits, correct?
Yes.
So it's correct to state that under the department's reduction targets, which do not have a credit-only year, the program still generates surplus credits in 2026 and 2027, correct?
Yes.
And you're not expressing a concern in your testimony that the regulated parties will be unable to generate sufficient credits in 2026 or 2027 to offset compliance deficits, correct?
I do not state that.
Thank you.
It,
And now in your SIR rebuttal, you state that the carbon intensity reduction curve in the first 2 years of the program affects the number of surplus credits generated to be used for compliance in later years, right?
that's correct.
Okay. And so nothing in your modeling or your analysis that you shared in the SIR rebuttal, nothing in NMED's Zephyr modeling, and nothing in your testimony establishes that a credit-only first year is necessary for the program to function, correct?
No, not correct.
So previously, your admission on the record was that you could not break the program, even when testing extreme cases. So you would agree that the system is capable of generating sufficient banked credits without a credit-only grace year, correct?
No.
So your testimony today is different than your testimony several weeks ago.
Madam Mayor, so I would object.
Sir, Mr. Trujillo? Okay, yeah, we need you in the mic.
Oh, there we go. Sorry about that, Madam Hearing Officer. I would object, mischaracterizes the previous testimony.
All right, so
Madam?
Ms. Sona, you're just asking him, is your testimony different from earlier? And Dr. Schubert can say yes or no to that question. Dr. Schubert?
And actually, Madam Hearing Officer, if council would like me to read the direct quote and transcript citation into the record for this purpose, I'm happy to do so.
All right, Dr. Schubert, can you answer the question as posed, or do you need Ms. Sona to refer to your earlier testimony?
In my earlier testimony, was a different, I did model the proposed CI reduction curve. However, my rate of credit generation is different than what NMED modeled in their ZPR scenario. What NMED modeled in their scenario requires a much more rapid growth in renewable diesel usage in the early years of the program than what I had modeled previously. And my concern, which I'm expressing in my rebuttal testimony, rests on the time required to build out infrastructure needed in order to accommodate that, as I discussed in my presentation earlier.
Madam Hearing Officer, unfortunately, that answer was not responsive to my question.
Yeah. Dr. Schubert, would you answer the question as directly as you can, please?
Will you please restate the question?
Yes, my question was, your testimony previously was that you could not break the program. And your testimony today is now different, correct?
That is correct, based on different models by different parties.
Dr. Schubert, you agree that the Zephyr analysis is a even more extreme scenario than the BCA benefit cost analysis, correct?
I agree.
And so when you were looking at extreme scenarios and stated, I was trying to represent an extreme case to see if I could break the program, and the answer is I could not break it. You would agree that previously you looked at an extreme case, correct?
I did characterize it as an extreme case, and both cases that we're talking about here, my earlier case and the ZPR case, are different from each other. They have, my focus in my earlier work was on the end years and not on the early years, and there are different constraints present in different years.
So I'm a little confused now, respectfully, Dr. Schubert, with that answer. Is it your testimony that your rebuttal is not about the initial years of compliance? Or is it that your testimony is about the 15 years leading up to 2040 has feasibility concerns?
My rebuttal testimony concerns all of the years that are covered in the ZPR case, and that includes the early years and the late years.
In that testimony, you share opinions regarding why ZEV policies will be terminated, right?
In my testimony, I state what is, facts concerning what's happening in federal policy.
And the federal policies that you're talking about relate to ZEVs and rollbacks or restrictions or terminations of different incentives and changes, correct?
Yes.
Dr. Schubert, if you're speaking, we can't hear you.
Yes.
Okay, thank you. You agree, though, that New Mexico can still reach its carbon reduction goals with a far lower rate of EVs than than the BCA scenario assumed, correct?
Yes.
On page 3 of your Sir rebuttal testimony, you state that NMED's analysis, quote, errs in assuming the availability of federal EV purchase incentives, end quote, because they were terminated under the One Big Beautiful Bill Act, correct?
Yes.
And was it your goal with that testimony to state that EV purchasers in New Mexico will lack equivalent purchase incentives moving forward? And I should clarify, you may have had multiple goals, but was that one of your goals with that testimony?
That is correct.
Are you aware that New Mexico has enacted statewide clean car and clean car unit tax credits?
No.
If I represent to you that that is true, would you have any reason to disagree with me?
No.
Okay. If I told you that the New Mexico incentive is $3,000 available through 2027, and that my lawyer math says that is roughly 4/5 of the $3,750 federal credit, would you have any reason to dispute that?
I believe the federal credit is that recently terminated for new EVs was $7,500.
If there were credits for $3,750, would you have any reason to dispute my math?
No.
Okay. Turning to the rule, are you familiar with Section 305, which is the portion of the rule that includes requirements tied to how revenue for utilities associated with residential EV charging credits must be used?
I am.
Okay. So you would agree the rule requires electric distribution utilities and OEMs generating certain EV charging credits to reinvest those funds into projects that support transportation electrification and decarbonization, correct?
Yes.
Your testimony does not evaluate the effect of those reinvestment requirements in forming your conclusions about the availability of future EV incentives in New Mexico, correct?
Correct.
And you're aware that those investments could function as consumer-facing incentives, including point of sale or cash on the hood rebates, correct?
Yes.
During your direct testimony, you testified that the analysis and reporting Stillwater does for clients are proprietary studies. Is it fair for me to conclude in considering your Sir rebuttal testimony that that work also relies on proprietary business information to support your analyses?
No, it is not.
So it's your position on infrastructure in your Sir rebuttal that those conclusions were not reached using any information available only to you and to industry.
That is correct. It is information that was in my written testimony.
In your, can you clarify, Dr. Schubert, you stated that was information in your direct testimony. Can you clarify, did you mean to say direct testimony, or did you mean to say it was information in your Sir rebuttal testimony?
I'm sorry, both of those are in error. They are The information on renewable diesel logistics was presented in the written report that we submitted with my direct testimony as a separate exhibit, I believe.
Okay, and your position during the direct case was that information in that written report was proprietary, was based on proprietary business information, correct?
Not the information relevant to renewable diesel logistics. That was all based on public domain data.
For the record, I'd just like to let it reflect the citation to transcript volume VI, page 2073 to 2074, discussing proprietary information. Dr. Schubert, in your rebuttal testimony, you do not have any footnotes or citations to information regarding your renewable diesel conclusions, correct?
I believe that's correct.
And so you've asked NMED and this board to somehow put together your direct testimony positions based on proprietary information, apply those to your understandings without any explanation or analysis in your rebuttal, and somehow take your word without being able to verify or evaluate any of those conclusions.
Madam Hearing Officer,
Is that a summary of how your testimony is laid out?
Madam Hearing Officer, I object. It mischaracterizes his previous testimony.
All right, thank you. Dr. Schubert, can you answer the question as it's posed?
I will attempt to. As I previously stated, the information with regard to renewable diesel infrastructure is not proprietary. Some elements of my direct testimony was based on proprietary information. Only one of several footnotes in my direct testimony was to a proprietary document. Other footnotes that referenced Stillwater data were to public domain documents, as stated, I believe, in my direct testimony. With respect to my rebuttal testimony, counsel is correct that I did not footnote my statements with regard to renewable diesel infrastructure.
Thank you, Madam Hearing Officer. That concludes my questioning. I'd just like the record to reflect regarding our concerns about renewable diesel being not responsive to rebuttal. The answers on cross-examination were that these were based directly on direct testimony.
Thank you for persisting, Ms. Sona. Mr. Trujillo, do you have redirect?
Madam Hearing Officer, if I could defer counsel real quick.
Yes.
Dr. Schubert, there was one point during your testimony that counsel cut you short and it sounded like you wanted to add on. Do you recall that particular point in your testimony?
No, I don't at the moment.
Okay, no worries. I was just following up in case you had some additional information that you wanted to provide. Just a couple more questions for you, Dr. Schubert. The disclaimer that's been referenced and was at page 2 of your testimony. Is that a disclaimer for Stillwater's business purposes? Is that your information you stick in there, or is that part of your company's business practice?
That's correct. That is our standard disclaimer language.
And their attorneys advising Stillwater are the ones that included that in. So you won't be able to testify or give any reasons as to why that's included?
Correct. That is that is a standard part of our reports and presentations based on advice of Stillwater's counsel.
Thank you, Dr. Schubert. Dr. Schubert, while New Mexico could hypothetically meet the carbon reduction goals, does New Mexico have the infrastructure to meet these goals?
Objection, Madam Hearing Officer. The question posed by counsel was not a hypothetical. Sorry, let me clarify. The premise of counsel's question presumes that my question was a hypothetical. That question was not a hypothetical. It was directly related to something that Dr. Schubert had testified to.
All right, rephrase it, Mr. Trujillo.
Certainly. While New Mexico could meet the carbon reduction goals, does New Mexico have the infrastructure to meet them?
As I stated earlier, New Mexico needs significant investments in infrastructure in order to be able to deliver the rate of renewable diesel usage, which is modeled by NMAC in their ZPR scenario.
Dr. Schubert, one last question for you, just to clarify a little bit more for the board's understanding. Is it true that the BD we were referencing earlier and had a discussion on is inherent to NMAC's calculations, the new calculations?
Objection, Madam Hearing Officer. I don't recall that I asked any cross-examination questions on BD, so I do not believe that this is appropriate for redirect.
Okay, you did though as part of your challenge to his testimony, raise that question. So go ahead, Mr. Trujillo.
Dr. Schubert, do you need me to repeat the question?
Yes, please.
Dr. Schubert, isn't it true that BD is inherent to NMAC's calculations?
It is, yeah. B over D is a simple calculation directly from data which they report. It is a ratio of two numbers that they report. It is a figure that is used as I testified in other applications in low carbon fuel standards and similar regulations.
Thank you, Dr. Schubert. I have no more questions.
Thank you, Mr. Trujillo. Member Ely, do you have questions?
I have no questions.
Thank you. Madam Chair.
I have no questions. Thank you.
Thank you. On the platform, Member Honker.
No questions. Thank you.
Thank you. Member Bitzer. I know I saw Member Bitzer on the platform earlier. He may have stepped away. And I believe Member Garcia will be joining us in a little bit. Oh, she's on. Member Garcia, do you have questions?
I do not. Thank you very much.
All right. Thank you very much. Is there any reason not to excuse Dr. Schubert? All right. Thank you, Dr. Schubert, for your testimony.
Thank you.
Do I understand, Ms. Sona, that we would go next to the first NMAC panel?
Yes, Madam Hearing Officer. And if we may take a brief break to set them up.
That's why I was asking. All right, let's come back at 9:25. Ms. Menard?
Thank you, Madam Hearing Officer. I just wanted to let you and the board know that Infinium will not put on a witness this afternoon. So that's one less witness between NMAC's case.
Thank you very much for that. Ms. Sona? I believe you have your first panel.
Thank you, Madam Hearing Officer. Since I believe you swore these folks in last time, I'll just have them state and spell their name for the record when I begin each one. Mr. Ford, let's begin with you. Can you please state and spell your name for the record?
Yes, the first name is Michael. That's Michael. Last name Ford, like the car, Ford.
And Mr. Ford, did you previously testify in this proceeding on September 25th and 26th, 2025?
I did.
I'd like the record to reflect that Mr. Ford's qualifications to testify were previously established on the record, and exhibits 73 to 75 with his direct testimony, resume, and his supporting exhibit were admitted. Mr. Ford, is NMED Exhibit 112 corrected, a clean copy of NMED rule language being proposed?
It is.
And Exhibit 113 corrected is the red line copy?
It is the red line copy, yes.
Is NMED Exhibit 133 a written narrative of your rebuttal testimony?
It is.
And do you adopt NMED Exhibit 133 under oath as your testimony?
I do.
Do you have any corrections to your testimony that we need to go through?
I do not.
Okay. Have you prepared a written summary of your testimony?
I have.
Okay. Please go ahead and share that.
Chair Sweeney, members of the board, I submitted my original direct testimony to the EIB as NMED Exhibit 73. My testimony included a detailed discussion of the Clean Transportation Fuel Program, CTFP, costs modeled in the Benefit Cost Analysis, BCA. I discussed the program costs and how they translated between wholesale and retail fuel markets. Then I put this discussion into context, comparing these costs to the multiple benefits that the CTFP provided to New Mexicans by diversifying the state's fuel mix, creating new jobs in the clean energy economy, solidifying our state's prominence across the entire energy sector, shielding our consumers from reliance on global energy price fluctuations, stimulating new innovations, and improving our air quality and health. Regarding the CTFP's equity impacts, I detailed how low-income and underserved households throughout the state would most benefit from these rule impacts, the protections offered from its cost containment mechanisms, and its targeting of credit revenue to accelerate zero-emission vehicle, or ZEV, availability in neighborhoods and towns that would most benefit from the environmental, health, and financial effects of having cleaner transportation options. After my testimony, much of the cross-examination from rebuttal parties focused on how the BCA's cost and feasibility findings would change if federal efforts proved successful to dismantle our state's prevailing laws. Such efforts target parallel policies to the CTFP that support ZEV uptake, like our state's new motor vehicle emission standards, NMVES, and nationwide federal measures like the 2024 multi-pollutant rule for light-duty vehicles and the 2024 Phase 3 rule for medium and heavy-duty vehicles. Of these, NMVES, as prevailing law under 20.2.91 New Mexico Administrative Code, is the binding policy because it sets more ambitious goals for reducing greenhouse gas tailpipe emissions of new vehicles delivered for sale in New Mexico than do the nationwide federal measures. Numerous questions surround the legality and applicability of federal actions to overturn NMVES and other Section 177 waiver rules via the Congressional Review Act. Questions similarly surround the U.S. Environmental Protection Agency's decision to rescind the 2009 endangerment finding for greenhouse gases, which would nullify portions of the 2024 multi-pollutant and Phase 3 rules. As NMED Environmental Protection Division Director Michelle Miano testified, no court has stayed NMVES, and it remains effective law. NMED thus remains fully justified in its decision to model the CTFP in the Notice of Intent testimony under the assumption that these policies, particularly NMVES, remain in effect. I will address those issues not from a legal perspective, but in terms of how we integrate them into our modeling and only as they apply to our modeling efforts. To address concerns raised by this novel situation and to allow the EIB to fully gauge the CTFP's feasibility, NMED committed financial and human resources to break with common practice and produce a rebuttal sensitivity analysis, or RSA. The RSA under NMED Exhibit 134 assumes the rollback of the ZEV policy, the ZEV supporting policies that I've noted. The ZEV policy rollback, or ZPR, affectionately known as Zephyr, in the RSA assumes that these measures not only succeed but remain in place through 2040, despite the salient questions over their legality and the ever-changing federal landscape. As Dr. Schubert notes in his rebuttal testimony, any such policy represents a bookend case, given the constantly evolving nature of federal and state vehicle, fuel, and greenhouse gas reduction policies over the past 50 years. It is an opposite bookend assumption to that of the BCA, which assumes NMVES remains in place through 2040. However, unlike the RSA, the RSA, unlike the BCA, requires a specific set of outcomes occurring across multiple points of contention and succeeding with near immediate effect before remaining on the books for the next 14 years. This very specific set of uncertain outcomes, all breaking in the same direction needed for the Zephyr in the RSA, undergirds our initial decision to stick with common modeling practice in the BCA. Regardless, the RSA allows for consideration of the CTFP's impact should this parallel universe materialize with its impact under our current policy framework. This comparison yields helpful insights into 1. Whether the CTFP is feasible under Zephyr assumptions. 2. What New Mexico's transportation sector environmental and economic realities look like should the Zephyr occur. And 3. The greater role that the CTFP must play to drive decarbonization and improve economic and environmental outcomes in a Zephyr world. I will let my fellow panel members, Mr. Matthew Drews and Mr. John Kupal, further discuss how BRG staff and ERG modeled outcomes under a Zephyr counterfactual. Based upon their respective rebuttal testimonies in NMED Exhibits 135 and 138. I will point here to conclusions of our modeling efforts. Specifically, 1. For feasibility, the RSA finds that regulated parties comply with the CTFP's decadal targets under Zephyr assumptions by blending renewable diesel, or RD, into New Mexico's fossil diesel pool at a maximum rate of 91.9% in 2029. This is higher than the current blend rate in states with CTFP-like policies, but is similar to the maximum rates in California and less than 100% of our total diesel consumption thus remaining within feasible limits. 2. With regards to outcomes under Zephyr policies, the rollback of ZEV supporting policies under the Zephyr does lead to greater projected use in New Mexico of gasoline, diesel, and their substitutes, specifically of the fossil variety, to serve its relatively larger fleet of internal combustion engine vehicles or ICE vehicles. New Mexico's hampered transition from ICE vehicles to ZEVs under Zephyr assumptions thus make decarbonization more challenging than under the BCA. This rollback also has a harmful impact on New Mexico's air quality, health outcomes, and ability to create new employment in the growing clean energy sector. 3. For the CTFP's effect under Zephyr. Under Zephyr assumptions, regulated parties must do more to comply with the CTFP. However, this augments the program's importance in a Zephyr reality. It leads to greenhouse gas reductions that reach nearly 4 million metric tons of carbon dioxide equivalent, or MMTCO2e, per year by 2040. The RSA finds that cumulative CTFP-driven emissions reductions under Zephyr nearly quadruple compared to those in the BCA, while total program costs rise by about double, 1.94 versus 0.96 billion. However, because there are more gallons of gasoline and diesel fuel across which to divide CTFP program costs in the Zephyr, the program's cost per gallon of gasoline equivalent, or GGE, peaks in 2030 when assuming 100% pass-through at 23.7 and 24.1 cents per gallon of gasoline per GGE for gasoline and diesel, respectively. These are 41% and 43% higher than in the BCA, but far below the twofold overall increase in program costs. As a result of these changes and additional employment, air quality, and health benefits, the CTFP generates benefits for New Mexicans under the Zephyr that are 4.54 times higher than program costs. This benefit to cost ratio reflects a 2/3 improvement over the 2.73 benefits cost ratio found in the BCA. Much opposition testimony during the initial hearings focused on whether it would be feasible for NMED to implement the CTFP under a full rollback of key ZEV supporting policies. The RSA found that under Zephyr assumptions, the CTFP is not only feasible through 2040, but plays a more prominent and critical role to pushing decarbonization ahead in New Mexico. It produces more benefits relative to costs than under BCA assumptions. These findings have only deepened my conviction that the CTFP is paramount to achieving the state's climate reduction goals. With the balance of my time, I can respond to a couple of rebuttal points, if that's okay with the board. Okay. My rebuttal testimony highlights key findings in response to questions during this panel's testimony. These include the balance that our current carbon intensity curve successfully achieves between a near-term decarbonization and CTFP feasibility. To the point about feasibility, I find that even under Zephyr assumptions, New Mexico does have the infrastructure to meet its near-term blending targets. I find that the program does so with minimal impact to New Mexico's gasoline and diesel tax revenues and to the state's oil and gas industry. I underscore that the importance of the program to New Mexico's role as a leader in the fight against global greenhouse gas emissions, as well as the conscientious measurements we have taken to achieve this leadership role while minimizing program costs and not only protecting but improving the pocketbooks of consumers and commuters throughout the state. Of these, the question of infrastructure needed for near-term CTFP credit generation and compliance under Zephyr assumptions is of greatest relevance to this panel's RSA discussion. I will highlight 3 key findings. The first key point is although New Mexico blends almost no RD into its fossil diesel pool at present, Dr. Schubert correctly notes in his SIR rebuttal that having an in-state refinery producing RD could facilitate blending up to nearly 20% of the state's diesel pool. This would cover with some cushion the state's anticipated blending under Zephyr assumptions of just over 15% through the end of 2027. After that, Dr. Schubert and I agree that the additional volumes may need to be delivered by rail, requiring upgrades to terminal transloading facilities. In the meantime, depending on credits from other sources not considered based on our conservative assumptions, there may need to be some truck delivery, as is currently sent into West Coast states at present. And I will note, and this is the last and important point, that such delivery costs are implicitly included in both the BCA and RSA, given that both of these studies use the Environmental Protection Agency's regulatory impact analysis of the U.S. Renewable Fuel Standard. And lastly, I will point out that the program provides needed price signals for such infrastructure builds. As I've seen analyzing natural gas pipeline infrastructure buildouts during my time at the U.S. Energy Information Administration, such signals offer regulated parties an opportunity for arbitrage between different prices in different locations that provides an economic incentive to build out the new infrastructure that this program needs by the timeline that renewable diesel from Artesia offers up until 2028. And I will lastly add that those price signals are complemented by numerous provisions in the program itself that I would be happy to discuss, but those provide the very opportunities to support the build out that will make this program a sustained success for all New Mexicans. Thank you. And with that, I am prepared to answer your questions on the infrastructure topic or any others as noted.
Thank you, Dr. Ford, or Mr. Ford, giving you that.
That would have been cool.
I cannot hear you, Miss Sona.
Thank you, Mr. Lee. I turned the microphone back on. I stated, thank you, Dr. Ford, and joked that I gave him his doctor title ahead of his degree. So, Mr. Ford, it's safe to say that with your rebuttal sensitivity analysis, we are still a go. Yes?
Absolutely, yes.
Okay. Madam Hearing Officer, I'd like to move for admission into the record NMED Exhibit 133, Mr. Ford's rebuttal testimony, the supporting Exhibit 134, the Zephyr analysis, as well as the corrected NMED Exhibits 112 and 113.
I'll pause for a moment in the event there are objections. Those exhibits are admitted.
Thank you. And we are presenting our witnesses as a panel. So if I may move to Mr. Drews.
Please.
Okay. Mr. Drews, can you unmute yourself?
I am unmuted.
All right, thank you. Can you please state and spell your name for the record?
Yes, it's Matthew Drews, MATTHEWDREWS.
And Mr. Drews, did you previously testify in this proceeding on September 25th and 26th, 2025?
I did.
I'd like the record to reflect that Mr. Drews' qualifications to testify were previously established on the record and Exhibits 76 to 79 with his direct testimony, resume, and supporting exhibits were admitted. Mr. Drews, is Exhibit 135 a written narrative of your rebuttal testimony?
It is.
Do you adopt NMED Exhibit 135 under oath as your testimony?
I do.
And have you prepared a summary of your written testimony?
I have.
Okay, please go ahead and read your summary, and remember to go slow.
I will do so. Thank you. Good morning, Chair Sweeney and members of the board. My name is Matthew Drews, and I am a director in the Energy and Climate Practice at Berkeley Research Group, or BRG. My original direct testimony in this matter discussed NMED's projections for the impact of the CTFP on New Mexico's fuel markets, the functioning of CTFP credit markets, and the benefits and costs of the CTFP as detailed in the benefit cost analysis, which I authored. As with my direct testimony, I will be discussing the same topics in the ZEV policy rollback, ZPR or Zephyr scenario described by Mr. Ford as laid out in the Rebuttal Sensitivity Analysis, or RSA. I co-authored this analysis with Mr. Ford and Eastern Research Group staff, the latter represented here by Mr. Capel. As with my direct testimony, however, I will begin by providing a brief regulatory context. As detailed in my written rebuttal testimony, a number of federal and state regulatory developments have been proposed or adopted alongside the federal actions leading to our consideration of the Zephyr scenario. These include proposed amendments to the Federal Renewable Fuel Standard, or RFS, adjustments to federal tax credits for biofuels, and developments in the California Low Carbon Fuel Standard, or LCFS, among others I outline in my written testimony. The net impact of these changes is an increase in both New Mexico's available supply and federal pricing support for biofuels derived from higher carbon intensity feedstocks like soybean or canola oil, alongside a reduction in New Mexico's available supply and federal pricing support for biofuels derived from lower carbon intensity feedstocks like tallow and used cooking oil. To maintain conservative assumptions in our analysis, we prepared the RSA assuming that New Mexico only has access to higher carbon intensity biodiesel and renewable diesel derived from soybean oil. We performed the same modeling process that we did in our original NOI in the ZEV policy rollback scenario to assess the impact of the sensitivities with respect to ZEV policy support, detailed by my co-panelists, and the changes in biofuel policy support that I outlined. This modeling shows that CTFP remains viable in this scenario, and that its importance is substantially increased in achieving New Mexico's climate goals. Greenhouse gas emission reductions through 2040 attributable to CTFP are between 3 and 4 times higher than in our previous modeling with NMBES in place, largely because the latter is not supporting New Mexico's emissions reductions, and the CTFP has to make up the difference. New Mexico greenhouse gas emission reductions through 2040 attributable to CTFP total 39.1 million metric tons of CO2 equivalent without NMBES in place, compared to 10.5 million metric tons attributable to CTFP with NMBES in place, highlighting the increased importance of CTFP without NMBES. The assumptions in the Zephyr scenario substantially increase the amount of renewable diesel blending required to meet CTFP targets, rising to 92% of diesel pool demand in New Mexico by the late 2020s, but the program remains feasible. I will note that these findings are extremely close to the volumetric projections put together by Dr. Adam Schubert, a witness for NMOGA and API in NMOGA API Exhibit 8, though we made some different assumptions. I will also note that despite the high volumetric blending rates in this bookend scenario, as I outline in greater detail in my written testimony, recent federal and California policy changes should substantially increase the availability as well as the federal support for the biodiesel and renewable diesel that we forecast in this scenario to achieve these targets. Credit generation trends are largely consistent with the modeling that we performed with NMVES, with the major changes being that electricity credit generation is down but remains substantial, especially later in the program, and that renewable diesel credit generation is up. Credit banking grows in importance in this scenario as the rate of electricity credit growth slows without NMVES. More credits are required to be banked during the 2020s to achieve the statutory 2030 target. Overall, costs of the program do increase absent NMVES, largely due to the increase in imported biofuels, but the benefits increase even more, both in absolute and percentage terms, due to the far greater greenhouse gas emissions reductions attributable to the policy absent NMVES, alongside proportionally greater health benefits, as my co-panelist John Coupel will expand upon. I want to briefly discuss a proposal raised by the Coalition for Clean Affordable Energy to use palm oil ILUC values for lipid-based feedstocks derived from certain crops, such as soy and canola. This policy recommendation has not been adopted by any other state with a comparable policy to CTFP. While I am not weighing in on the scientific merits of this proposal, which were discussed by Dr. Murphy, I do want to discuss how the proposal would impact New Mexico credit markets. This policy would, in effect, prevent biodiesel and renewable diesel derived from crop-based feedstocks from entering the New Mexico market. As discussed in the RSA, the use of low CI feedstocks like used cooking oil has fallen in 2025, likely due to trade challenges with nations like China, which had been a surging source of waste oil imports prior to this year. While producers have been able to backfill much of these losses with lower CI feedstocks like tallow, overall waste oil feedstock availability has declined year over year. As I discussed earlier today, this has occurred simultaneously with proposed or enacted federal policy, which generally increase volumetric and price support for biomass-based diesel derived from crop-based feedstocks, while reducing financial support for biomass-based diesel derived from certain waste oils. Also simultaneously, California has put in place limitations on credit generation from the same crop-based feedstocks covered in CCAE's proposal and reduced its CI curve by approximately 10% in 2025, which will put upward pressure on demand for these fuels in California, even as supply has tightened. As we have discussed throughout this proceeding, there is substantial federal policy uncertainty right now affecting zero-emission vehicle adoption and other clean fuels policies. If Section 177 is upheld, enabling NMVES and comparable policies in other states with CTFP policies, and if no other states accept the logic underpinning CCAE's proposal and amend their policies, I believe that there is a reasonable probability that CCAE's proposal would not put New Mexico's credit markets at risk. However, if CCAE's proposal is adopted and policy outcomes closer to those contemplated in the Zephyr scenario occur, which would both remove the authority for NMVES and California's comparable policies, I believe that there is a very high likelihood that there would not be sufficient credits to meet CTFP targets, and the program would enter a relatively near-term and long-lasting deferral and fail to deliver any benefits to New Mexicans. Throughout this proceeding, different parties besides NMED have raised concerns about potential undersupply or oversupply of credits. Within certain ranges, to some degree, the concept of oversupply or undersupply is a normative judgment. Credit bank inventories can be higher with lower credit prices or vice versa, but there is a wide range of market outcomes which would still lead to efficient market clearing prices to deliver the emissions reductions targeted by the program. I think it is also important to consider that any change to the rule made specifically to mitigate one set of parties' concerns about conditions of credit undersupply or oversupply could potentially exacerbate the concerns of the other set of parties with respect to the opposite market outcome. I believe that the fact that NMED's proposed rule has drawn opposite concerns from different parties about the supply and demand balance of credits in the credit market reinforces the idea that the rule is a balanced implementation of the legislative directive. Regarding the risk of potential conditions of low credit availability and high credit prices, which have been raised by parties in the oil and gas industry, I believe that the Zephyr modeling discussed by myself and my co-panelists shows that credit markets are robust to even less favorable bookend scenarios for electric vehicle penetration. As discussed extensively in this panel's original and rebuttal testimony and reports, we strove to make conservative assumptions in our modeling when reasonable uncertainty existed to mitigate the risk of our modeling showing understating the risk of credit market tightness. In spite of this, the Zephyr scenario modeling showed that the program was able to meet targets even with very conservative assumptions for electric vehicle policy support. I will note for the board that this finding was also echoed in the Stillwater testimony for the American Petroleum Institute and NMOGA. I will further note that the program has safeguards in place to prevent these credit market shortage conditions, as Mr. Ford outlined in his direct testimony. I also want to briefly discuss the opposite scenario, where credit inventories become high and prices low due to relatively more credits than deficits in the market. My modeling in the original benefit cost analysis scenario indeed shows that there is a risk of this occurring. By the mid-2030s in that analysis, there were structurally more credits than deficits generated in the market. I also acknowledge that these concerns have been raised at times in other states, including in both Washington and California earlier in 2025. But I also want to point out that in both of those cases, the respective states' legislatures and regulatory departments and boards were able to adjust the rules of their programs after these conditions materialized, and this year have taken concrete steps which will reduce these concerns. As I discussed earlier, the shape of New Mexico's compliance curve, derived from legislative targets, both mitigates the risks of credit market oversaturation and increases the affirmative importance of building a healthy credit bank during the 2020s. And I do not believe that the risk of early year credit oversaturation is sufficient to deny the New Mexico legislature or the board time to address such conditions until they become more apparent, as both California and Washington were able to do when regulators acted upon similar concerns. Thank you again for the opportunity to present rebuttal testimony. I appreciate the time and attention you have given to consideration of adopting the CTFP and want to highlight a few key points. First, while I agree with some other witnesses that there is a longer-term risk of credit market saturation in certain scenarios, these are unlikely to materialize in the near term, and the legislature and the board will have time to address any such conditions as they arise. Second, the CTFP policy goals are still achievable with sufficient credit supply to meet demand, even with a substantial rollback of ZEV policy support and without an MVES. Third, the CTFP's importance in achieving New Mexico's greenhouse gas emission reduction goals is enhanced without complementary policies like NMVES, as CTFP must be responsible for a greater share of the activity to achieve the state's greenhouse gas emission reduction objectives. I believe that the CTFP provides flexible, cost-effective, and critical support to New Mexico in achieving its greenhouse gas emission reduction goals. Its design will allow it to respond to policy and market uncertainties as they materialize to economically and cost-effectively support transportation sector decarbonizations. In our base projections, we showed that it was one of the policy cornerstones in achieving New Mexico's transportation emissions reduction goals, And in the event of any challenges to other policies, it becomes all the more critical to delivering emission reduction benefits to all New Mexicans. Thank you again for the opportunity to testify.
Thank you very much, Mr. Drews. Madam Hearing Officer, I'd now like to move for admission of NMED Exhibit 135, Mr. Drews' rebuttal testimony, and the supporting exhibits, NMED Exhibits 136 to 137.
We'll pause for a moment in the event anyone would like to state an objection. Okay, they're admitted. Thank you.
I'd now like to turn to our third and final witness for this panel, Mr. Kupal. Are you able to get your PowerPoint up and going?
I will try now.
While Mr. Kupal is doing that, I just want to remind the parties and the board that Mr. Drews does have a 3 p.m. stop time today. Should we be unable to finish cross-examination or board questions specifically of him as a witness, we're more than happy to bring him back when he's available Thursday afternoon.
Thank you.
Mr. Kupal, can you please state and spell your name for the record?
John Coupal, Koupal, first name John.
Did you previously testify in this proceeding on September 25th and 26th, 2025?
I did.
I'd like the record to reflect that Mr. Kupal's qualifications to testify were previously established on the record, and exhibits 80 to 111 with his direct testimony, resume, and supporting exhibits were admitted. Is NMED Exhibit 138 a written narrative of your rebuttal testimony?
Yes.
Do you adopt NMED Exhibit 138 under oath as your testimony?
Yes.
Have you prepared a summary of your written testimony?
I have.
And do you have a PowerPoint to accompany it?
I do.
Okay, please go ahead and read your summary slowly and share your PowerPoint.
Thank you. Mr. Lee, can you hear me okay? Okay.
Yes, sir.
I promise mercy in the speed of my delivery. Good morning, Chair Sweeney and members of the board. My name is John Coupal, a Vice President with Eastern Research Group, or ERG, and I'm pleased to have a chance to follow up on the direct testimony I provided to the board in September. At that time, I testified on ERG's development of carbon intensity, or CI values, used in CTFP, and on the benefits and costs of the CTFP program. My testimony today focuses on updates made to these analyses to address comments received on the initial filing. These updates are documented in 2 reports. The first is the revised regulatory analysis for New Mexico's Clean Transportation Fuel Program, NMED Exhibit 139, with a summary of specific updates provided in NMED Exhibit 140 for quick reference. Updates made to this report center on CIs that are the basis of tables 1 through 5 in the Rebuttal Revised Proposed New Rule, or Rebuttal Rule. The second report my testimony draws from is the Rebuttal Sensitivity Analysis Report co-authored by NMED, BRG, and ERG, NMED Exhibit 134. This report presents benefits and costs of the CTFP from new modeling on a sensitivity case based on rollbacks of NMVES and current federal emission standards referred to as the Zephyr scenario. I will give a brief overview of the updates and key results and direct you to these reports for additional detail. We've made updates to the NM-GREET model, NMED Exhibit 148 and 149, which led to the revised CIs in the rebuttal rule. These updates include addressing calculation issues raised in comments in the NOI filings related to base year, clear gasoline, LPG pathway, and liquefaction energy intensity. Updating OPG modeling for 2022 using 2022 import volumes, which reduces well to refinery gate petroleum emissions from 2018, and adding CIs for sorghum ethanol and renewable naphtha. Our report also provides additional detail on why using data from the OPG model improves the accuracy of emissions for petroleum extraction and production for New Mexico over R&D GREET, why the generic counterfactual analysis for 45V GREET supports broader applicability of avoided methane emissions for temporary animal waste pathways. I'm getting the look. And why California's indirect land use change, or ILUC estimates, are an appropriate choice for NM GREET at this time. I invite you to review ERG's revised regulatory analysis report and my written testimony for further detail on these updates and why, as acknowledged by its developers, unmodified R&D GREET is unsuitable for supporting regulatory programs such as New Mexico's CTFP. To help the board see firsthand what we mean by NM GREET and how and why it differs from R&D GREET, my colleague from ERG's Lifecycle Services Group and lead developer of NM GREET, Andrew Beck, has created a video walkthrough of the model, NMED Exhibit 141. In this video, Mr. Beck demonstrates how NM GREET begins with the foundation of R&D GREET, but adapts the model for regulatory application in New Mexico's CTFP through select parameter choices and integration of results from external models to improve the accuracy of carbon intensity values for New Mexico. Our team also analyzed the benefits and costs of the CTFP under the Zephyr scenario. The purpose of this is to conduct a stress test on CTFP credit markets, benefits, and costs for a scenario where NMVES and federal rollbacks dramatically reduce the number of EVs sold. The scenario we modeled was based on the Annual Energy Outlook, or AEO, 2025 Alternative Transportation Scenario, which assumes a rollback of federal GHG standards passed in 2024, known as the 2027 Multi-Pollutant Rule and the Phase 3 Heavy-Duty Truck Rule, California Advanced Clean Cars 2, or ACC2, and Advanced Clean Trucks, or ACT. This scenario represents what will happen with EV growth, absent policy drivers, but accounting for market trends, including continued expansion of manufacturer product lines, financial incentives to replace repealed tax credits, and fleet commitments driven by corporate sustainability goals. We considered other EV sales projections for a similar policy scenario, primarily AEO 2023, which was the basis of the analysis performed by Stillwater Associates. However, we chose the AEO 2025 alternative case because it is the latest available, taking into account more recent EV manufacturing and market trends, including a shift to PHEVs. Light-duty EV sales fractions by model year, not including PHEVs, are shown in this chart for the NMVES case at the top, the federal 2024 rules in red, the AEO 2025 alternative case in green with the arrow pointing to it, and the AEO 2023 case in purple. For the Zephyr scenario, we combined car and light truck EV sales estimates in AEO 2025 alternative case to apply the same EV sales rates of cars and light trucks, since vehicles classified as light trucks, including Tesla Model Y and Jeep Wrangler PHEV, are among the top-selling EVs in the state. As shown in this figure, light-duty BEV sales stabilized between 25 and 30% for Zephyr compared to just under 80% for NMVES. Our team followed the same process for estimating costs and benefits for the Zephyr scenario that I described in detail during September's hearing. BRG estimated how Zephyr would reduce the population and electricity demand of EVs while increasing the population and fuel demand of gasoline and diesel vehicles. Of note is that under Zephyr, total energy delivered in New Mexico would increase. This is because it takes more energy delivered in the form of liquid fuel to move an ICE-heavy or internal combustion engine heavy fleet relative to an EV heavy fleet to compensate for the energy wasted by ICE vehicles. This is a real consequence of keeping lower efficiency ICE vehicles on the road and is the basis of EER adjustments. The difference in liquid fuel volumes between NMVES and the Zephyr baselines are shown in this chart. BRG predicts a significantly higher uptake of renewable diesel to meet program targets under Zephyr. The increase in CTFP fuel volumes for the Zephyr scenario leads to larger emission reductions from the program. As shown here, GHG reductions total 39.1 million metric tons cumulatively through 2040, compared to 10.5 million metric tons for the NMVES baseline, which translates to a monetized benefit of $8.7 billion. The criteria pollutant emission reductions shown on the right also increased substantially due to the large volume of RD, though still on the legacy fleet, as I testified in September. Through 2040, we project NOx reductions over 1,200 tons, VOC reductions over 800 tons, and PM reductions over 600 tons. We then ran EPA's COBRA model to quantify the health benefits of these criteria pollutant reductions from reduced mortality, serious disease, and reduced sick days, with monetized health benefits between $41 and $75 million. These emission reductions and health outcomes will directly benefit disadvantaged communities in New Mexico, where several census tracts in the state, including many in Albuquerque and Las Cruces, are in the worst 5% or 95th percentile in the entire US for diesel PM Environmental Justice Index, according to EPA's EJ Screen model. This index represents diesel PM exposure in census blocks with a high percentage of low-income residents and people of color. I want to spend a little more time on the implications of CTFP criteria pollutant reductions in the context of where New Mexico stands with attainment of the National Ambient Air Quality Standards, or NACs. I should note CTFP authority is per the Environmental Improvement Act, not the Air Quality Control Act, and Bernalillo County does not have authority related to CTFP. CTFP is a carbon intensity-based rule, not an air quality regulation. Nonetheless, the co-benefits of a statewide CTFP will help local air quality. The Las Cruces area is already classified as a marginal non-attainment area for ozone and a moderate non-attainment area for PM10. Of additional concern is how close Bernalillo County is to ozone non-attainment status. Getting bumped up to non-attainment status can trigger federal requirements mandating implementation plans with additional local controls. As shown here, the city of Albuquerque recently submitted a report to EPA showing that ozone design values, the value used to determine attainment status, have been at or above the current 70 part per billion ozone standard since 2018. The city's report specifies the local measures that are being taken proactively as part of EPA's Ozone Advanced Program to avoid non-attainment designation. The short-term emission reductions provided by the CTFP will help with this effort. Finally, as laid out in the rebuttal sensitivity analysis report, we compared benefits and costs for CTFP for the ZPR baseline to assess if benefits still outweigh costs of the program under a very different policy landscape. Costs and savings of the program were again estimated using the in-plan model run with fuel volumes, direct jobs, and health benefits calculated for the Zephyr scenario. Bounding scenarios of 0% pass-through and 100% pass-through of fuel market costs were run, as with our original analysis. Using the 50% pass-through average of these two extremes, this slide shows our summary of direct, indirect, and induced fuel market costs compared to program benefits via improved health, monetized GHG reductions, and direct jobs from fuel supply equipment or FSE credits. With the Zephyr baseline, both the benefits and the costs of the CTFP are higher than they are relative to the NMVES baseline. However, both the net benefits through 2040 and the ratio of benefits to cost are higher with the Zephyr baseline compared to the NMVES baseline as shown. This indicates the robustness of the CTFP program to uncertainties in the federal policy landscape. In closing, I want to revisit the conclusions from my prior testimony. that from the NMVES baseline, the CTFP would result in substantial reductions of greenhouse gas emissions in support of New Mexico's climate goals, would reduce particulate matter and ozone precursors from motor vehicles, and has benefits that outweigh costs more than 2 to 1. Our updated analysis of CTFP benefits and costs for a scenario which rolls back NMVES and federal rules further reinforces these conclusions. CTFP would make up some, but not all, of benefits lost from repealing NMVES by generating additional reductions in GHGs, criteria pollutants, and adverse health outcomes, and with a benefit to cost ratio of more than 4 to 1. Under this scenario, the need to adopt CTFP is even more critical for making progress towards New Mexico's climate goals. Thank you for your time and attention today.
Thank you, Mr. Kupal. Madam Hearing Officer, I would now like to move for admission of NMED Exhibit 138, which is Mr. Kupal's rebuttal testimony, and the supporting NMED Exhibits 139 to 152.
I'll pause for a moment in the event there are objections.
Madam Hearing Officer.
Mr. Melenberg.
One objection, and that's to Exhibit 141, which is the video. I think it's appropriate to come into the record as a demonstrative exhibit, but that essentially it's a narrative similar to testimony, and it's not sworn testimony. I think it's appropriate to consider it as a demonstrative exhibit as opposed to technical testimony. And I would add, I think accepting it as technical testimony would set potentially a precedent for introduction into rulemaking of testimony through similar videos. Thank you.
All right. Ms. Sona?
Thank you, Madam Hearing Officer. I would object to the characterization of this as a demonstrative in the sense of how we use that word in these hearings. We disclosed it with our technical testimony. We disclosed in our NOI that should there be concern or objection regarding this, that we would bring Mr. Beck into the hearing to swear to the accuracy and truthfulness of his video. For efficiency purposes, we didn't believe it was necessary to do that, given that Mr. Beck works with Mr. Kupal, is part of ERG, and Mr. Kupal is capable of testifying to all of the content in the video, the same as he could testify to the content in a report or something like that. Given the unique nature of what we're dealing with here in a model that has been highly criticized, a video was the most efficient means to do this rather than bring Mr. Beck sitting here at a witness table to walk the board through it in person. So we would ask for this to be a unique consideration given the nature of the testimony, the rule that's being brought, and would ask that if you would like Mr. Beck to come and introduce this, that we do it after this panel and Mr. Kupal be allowed to testify to the video just for efficiency purposes so we're not breaking and resetting up.
All right. So, Mr. Mullenberg, I do remember their NOI and their rebuttal NOI identified Mr. Beck as a potential witness. So if you need to hear from him, we can do that, or we can have Mr. Kupal speak to it now, or Mr. Beck later. What is your preference?
Madam Hearing Officer, I think it's up to the department whether they want to introduce Mr. Beck to further substantiate the video. Again, I'm happy just noting my point for the record at this point and leaving it to you to decide how to handle that particular exhibit.
All right. So thank you. Your objection is noted. It's overruled. The exhibits, including 141, are admitted, and I'll ask the board members at some point, perhaps after the cross-examination of this panel, if they would like to hear from Mr. Beck.
Okay.
All right.
Thank you, Madam Hearing Officer.
Thank you.
And then as a last point, I would just like to note that although these three panelists have a lot of overlapping testimony, I'd ask for their cross-examinations that council stick to the 15 minutes and not just treat the panel as a robust 45 minutes exploration of everything. By my math, if we do that, we're going to be here for 8 hours again with this panel. So thank you.
Yes, Ms. Olson.
I object to Ms. Sona's proposal. She's presenting these witnesses as a panel, and the witnesses frequently refer to each other's testimonies throughout their testimony, and it's difficult to understand completely which witness sponsors which exhibit. Subject to several disruptions throughout the cross-examination, I don't expect to take 45 minutes, but I request not to be held to a 15-minute examination of each witness and be allowed to conduct examination of the panel.
So we did talk about this in at least one of the pre-hearing conferences, and I was in the direct case actually keeping rough track of approximately how long each of the witnesses was attracting questions. It really is just a caution to please not abuse it, if you will, so that all 45 minutes of your questions aren't going to one witness. That's all. It's hard to do this without a chess clock, actually.
That was exactly what I was trying to request. Thank you, Madam Hearing Officer.
I understand. Ms. Menard, do you have questions of this panel? She may have stepped away. Mr. Nasco? Mr. Duff? Mr. Smith? Mr. DeSalen?
Thank you, Madam Hearing Officer. We do have just a few questions here for Mr. Copal and for Mr. Drews. Good morning, folks. My name is Charles DeSalen. I represent the Coalition for Clean Affordable Energy. Hope you're doing well. Now, my first questions go to Mr. Drews. And we're going to talk a little bit about indirect land use change. And I'm going to use the word ILUC, and you'll understand what I'm talking about, I presume.
I do.
Okay. And then let's see, in rebuttal, you address CCAE's recommendation. And when I say CCAE, I'm talking about Coalition for Clean Affordable Energy. You address CCAE's recommendation to assign all crop oil feedstocks the same ILUC value as palm oil. Is that correct?
That is correct.
Okay. And you question the feasibility of compliance with the department's proposed carbon intensity targets if the board were to adopt CCAE's proposal. Is that also correct?
Yes, that is correct.
Okay. And do you agree that there is an ample supply of non-crop feedstocks like used cooking oil and tallow?
Sorry, was that the end of the question?
That was, I'm sorry, that was the end of the question, yes. I'm asking if you agree.
Can you define what you mean by ample supply? Depending on the answer, that may be a yes or a no, or an it depends.
Well, I think it would be ample to meet the targets, sufficient to meet the targets.
I would say that in isolation, if no other state, including California, which, as I discussed, has a number of reasons why it needs to increase potentially its use of those same feedstocks. If no other state were to draw upon any use of waste oil feedstocks, then yes, I would agree that there are sufficient available feedstocks to meet New Mexico's demand. I would not agree with that once factoring in the market realities of other U.S. programs that would be competing for the same feedstocks.
Okay. And would you also agree that there would be a strong incentive for fuel suppliers to send fuels made from these feedstocks to New Mexico because they would generate more credits here than they would in other state programs?
I wouldn't necessarily agree with that. I would grant the mathematical fact that early on in the program, when compared to other states which have further along carbon intensity reduction targets, that they would generate more credits. I think you also have to look at the avoided deficit generation side of the equation when you're doing that type of an analysis. Similarly to the fact that these, due to a less stringent CI curve, those fuels would be generating more credits. They would also be offsetting fewer deficits from competing diesel sources, which could include fossil-based diesel or crop-based, biomass-based diesel. I think that there would be slight differences. I haven't specifically evaluated between, which would have to do with the carbon intensity in particular of fossil diesel in what is CTFP table 4 and exists in comparable tables for other programs. So there would be slight differences, but I think that when you're doing an analysis like that, you have to consider the deficit avoidance side of the equation as well as the credit generation side of the equation.
Okay. And then finally, did you model a scenario where CCAE's ILUC recommendation was adopted to test whether the program compliance would be feasible?
I did not formally model that scenario. As discussed in the overview of the Zephyr scenario, in order to address what I think would be potentially very legitimate concerns about the availability of waste oil feedstocks in our Zephyr scenario, we actually took the conservative assumption from the perspective of understating benefits and overstating costs, of assuming no waste oil feedstocks were available to New Mexico. I think that is probably not strictly true. I think that in fact you would see some waste oil feedstocks that would potentially be available to the state, which would tend to reduce the cost of compliance relative to what we said. But I don't believe that there's sufficient evidence, especially if one envisions a scenario like the repeal of 177, where those feedstocks would be available at nearly the quantities to satisfy New Mexico's demand and the demands from other states, in particular California, who also would see their NMVES equivalent policies overturned, and who have tighter CI reduction targets, larger diesel pool demands, and in the case of California, also a ban on credit generation from crop-based feedstocks above certain percentages, which would preferentially divert waste oil feedstocks to that state.
Okay, I think I followed that. I have no further questions for you, Mr. Drews. Thank you very much for your testimony.
Thank you.
And then I just have a few more questions here for Mr. Kopel. And I want to direct most of my questions, or several of my questions, are going to go to not only your rebuttal testimony, which is 138, but excuse me, Exhibit 138, but also the report, which is NMED Exhibit 139A. And that's a report by the International Council on Clean Transportation, or the ICCT. Is that correct?
Yes.
Okay. And the report provides a peer review of the carbon intensity model that the Washington Department of Ecology proposed to use in its Clean Fuels Standard program. Is that correct?
That is correct.
And that's at the state, excuse me, let me start over here. The state of Washington had contemplated using the California's ILUC values for most crop feedstocks, but relied on the C Club model for ethanol and sorghum. Is that correct?
Well, my understanding is that that was recommended to Washington, but they did not adopt that for their rules.
Okay. Now, in this
Madam Hearing Officer,
Ms. Sona.
I'd object to the lack of a foundation being laid for Mr. Kupal to testify about the exhibit, and request that a foundation be laid regarding why he used this exhibit before there's specific questions regarding it.
Mr. DeSalem?
I think this is one of the exhibits that the Environment Department has introduced, and I'm questioning the panel. We are questioning a panel here, and if Mr. Kopel is not the proper person to answer the question, then I'm certainly willing to have one of the other witnesses answer the question.
Is this better answered by Mr. Ford or another witness?
Well, maybe we'll see what the question is.
All right, go ahead, Mr. DeSalem.
Okay, thank you. Now, in this proceeding, several of the parties have recommended relying on the C Club model. Is that correct?
That is my understanding, yes.
And do you believe that ICCT's critique of the C Club model to be valid?
I have reviewed the ICCT's critique of the C Club model, which was very pointed. You know, I think we introduced it as an exhibit because we felt there was another piece of evidence that, along with the other studies that we submitted, showed that we provided evidence for why we felt the California ILUC values were the most appropriate for New Mexico at this time.
Okay. Now, ICCT recommended using the California Air Resources Board's model for ILUC values instead of relying on the C Club. Is that correct?
That is correct.
Okay. And ICCT also discussed some of the drawbacks in the model that the California Air Resources Board relies on?
I'm not familiar with those.
Okay. The ICCT report finds that the model is likely to understate the ILUC or the ILUC impacts. Is that correct?
Can you point me in the report where that's stated?
Let's see. I believe it's on page 27.
Can you direct me to where on the page?
I don't have it in front of me. Apologize. It's on page 27.
I don't see this. I don't see that referenced on page 27.
Okay, I'll move on. The report did not consider the reasonableness of more conservative alternative approaches, such as Dr. Liskowski's recommendations, does it?
I really just submitted this as sort of a comparison of the California and C Club. So I don't have anything to say with respect to its conclusions beyond that.
Okay, very good. Well, thank you very much, Mr. Kopel. Those are all my questions. Thank you, Madam Hearing Officer.
Thank you very much, Mr. DeSalen. Mr. Lobdell? Mr. Sorayas? Ms. Veracruz? Ms. Tremblay? Mr. Maxwell?
No question. Thanks.
Thank you. Mr. Weatherby?
No questions. Thank you.
Mr. Harris?
No questions.
Thank you. He said no questions. Mr. Tucker? He said no questions. Ms. Olson? All right. Thank you.
Is somebody speaking? Because I cannot hear.
Not just yet. She's about to.
Just getting organized. The setup's a little awkward. Okay, good morning, Mr. Ford, Mr. Kopal, and Mr. Drew on the platform, I believe. My name's Carrie Olson. I'm here on behalf of the American Fuel and Petrochemical Manufacturers. And as indicated to the hearing officer, I do intend to question you all as a panel. So I'll jump right into it, starting with some of the background for the rebuttal testimony that you all are providing. And Mr. Ford, I'm going to direct these initial questions to you, but feel free to defer to your co-panelists. So just for context, I understand that a purpose of your direct testimony was to discuss the economic impact of the CTFP rule.
Yes.
And one of the ways that you evaluated that economic impact was through the modeling that was discussed in that testimony.
Yes.
And just to clarify, Mr. Ford, you're currently employed with the New Mexico Environment Department's Climate Change Bureau as a climate change economist.
Yes.
And Mr. Copal and Mr. Drews, you each are private consultants that NMED contracted to help with the department's modeling and analysis provided in the direct and rebuttal testimonies.
That is correct.
And correct for me as well.
So as clarified on page 2 of your rebuttal testimony, Mr. Ford, the earlier modeling presumed continued implementation of the New Mexico Motor Vehicle Emission Standards, NMVES, adopted by the Environmental Improvement Board approximately 2 years ago.
For the BCA that we submitted with our NOI, that is indeed the assumption, yes.
And the NMVES rulemaking preceded your tenure at the department, is that correct?
No, I was, I did not personally contribute to NMED efforts for that rulemaking, but I had been hired and attended the EIB hearings on the NMVES rulemaking. So I was an audience member, but I was an NMED employee as well.
Okay, I was curious because I think you started in the department in November 2023, and that's approximately when the rule was adopted.
Yes, my first 2 weeks at the department were in part spent attending those hearings.
That must have been quite an introduction. Okay, so your rebuttal testimony now provides additional modeling that assumes the removal of policies supporting zero emission vehicle expansion.
Yes, specifically the NMVES and the federal multi-pollutant and phase 3 rules respectively, those 3 measures.
Okay, and are there any other policies that were removed?
None specifically that I can state outright. They were all baked into the 2025 annual energy outlook, the EIA's 2025 annual energy outlook alternative transportation case, which we chose specifically for its non-inclusion of those policies mentioned, which is not to say that there may not be others, but those were the ones at the top of our priorities.
Understood. So we have the modeling scenarios presented in direct and modeling scenarios presented in rebuttal. Which scenario is NMED requesting the board rely on for consideration of the department's proposed CTFP regulations?
I would say both, because they both represent bookend possibilities of policy outcomes to see the range of outcomes that could take place with the CTFP in place.
Okay. You characterize throughout your testimony that NMVES is the prevailing law in New Mexico. Is that accurate?
Yes, that is NMED's position. That's correct.
Okay. Based on your testimony, are you asking the board to rely on your opinion regarding the state of that law in New Mexico to inform this rulemaking?
Objection, Madam Hearing Officer. Mr. Ford explicitly attributed these statements to Director Miano's testimony in his Sir rebuttal. And so he's also just testified that that's NMED's position. So I'm not sure this question is helpful and seems more harassing or intimidating than helpful for the record.
Madam Hearing Officer, it's shocking to hear that coming from counsel who has repeatedly objected and in fact threatened other witnesses. Nevertheless, if this is a statement in his testimony, I'm allowed to explore the basis for that statement. So I would respectfully ask that I be allowed to proceed with my cross-examination.
Yeah, Mr. Ford, to the extent you're quoting someone else, that's fine. You can say that. If you have some other insight to share as part of the answers to Ms. Olson's questions, that's great too.
And Mr. Ford, I think I'll just restart with these questions to eliminate any confusion on the record. So I think I asked that you stated in your testimony that NMBES is the prevailing law in New Mexico. You confirmed yes. Is that your opinion that it's the prevailing law in New Mexico?
That is NMED's opinion. So as a representative of NMED, yes.
So you share that opinion?
I'm speaking for NMED, and as a representative of NMED, yes, I do share that opinion.
Are you asking the board to rely on your testimony regarding the state of the law in New Mexico or something else?
I am asking the board to consider both scenarios that we have submitted, and we put a lot of time and effort into those scenarios. So I would like the board to consider both of those scenarios in addition to NMED's stance that they both represent bookends, but there's not a both sidesism here. There is obviously some greater likelihood in NMED's position of prevailing law continuing. But again, we did the RSA analysis specifically so they could see the entire horizon of possible outcomes and make a decision educated by every possibility that could emanate afterwards.
So to put a finer point on it, you personally are not testifying to the state of the law in New Mexico. You're simply repeating what others may have told you regarding the law.
I am testifying with regards to the scenarios that we project, and I only look at relevance of the state of the law insofar as they apply to consideration of our projection scenarios. So I can testify on those scenarios rather than directly upon the state of the law.
Understood. So is it fair to interpret the statements in your testimony regarding the state of the law, what's speculative and what's certain, all of that regarding the state of the law is based on information from somebody else?
Objection asked and answered.
Yeah, Ms. Olson, I think he's being very clear with you about what he's relying on for his own testimony.
I haven't heard him say what he's relying on for his legal assumptions, actually. I've heard him represent that's the department's position, but I haven't heard what the basis for those assumptions is. And so my question is he asking the board to rely on statements in his testimony regarding the state of the law, or is he relying on something else to prove those statements?
Okay, so is there something else you're relying on?
I'm asking the board to rely upon the statements in my testimony regarding modeling practice, and will underscore standard modeling practice that is, reflected, for example, in the EIA's reference case scenarios, is to assume that the legislation and regulations on the book are prevailing law and policy, and that is exactly what we do in the BCA. So I would ask the board to I would ask the board to account for what I have stated in my testimony about these various issues as they relate to weighting and considering our modeling scenarios.
On page 12 of your rebuttal testimony, you testify to the Congressional Review Act resolutions revoking California's Clean Air Act preemption waivers. Is that accurate?
Let me just check page 12.
Sure.
Are you sure it's on page 12?
That's what I have. Do you recall having any statements in your testimony regarding the Congressional Review Act? You can just say yes or no. Or you don't know.
I think I do mention the Congressional Review Act in my testimony, yes.
Are you aware of the legal effect that a Congressional Review Act resolution has?
Objection, Madam Hearing Officer. With this line of questioning, the testimony has been that Mr. Ford can state whether or not he made an assumption, and he is not stating that he is offering any veracity as to those assumptions, but the extent of his testimony in written form and the use of this information was to form the baseline as an assumption. And so his understanding of the veracity of the law, where it may go, he's already explained he can't do that.
Madam Hearing Officer, I'm not asking him to testify to the veracity of the law. I think everybody in this room understands he's not a lawyer. I'm asking him a question about his understanding as an economist.
Okay, just so that's clear, Mr. Ford.
Yes, I am aware of the general provisions in the Congressional Review Act. I would prefer not to comment legally on anything normative regarding these matters, as I am not a lawyer, and there are some in this room who would be very upset with me for trying to be one.
Understood. Okay, so let's go to the impact of modeling. Do you agree that an objective of this proceeding should be to establish rules to ensure a stable and functional credit and deficit market, sorry.
Yes.
And setting the legal assumptions in your testimony aside, I think you acknowledge there's certainly uncertainty regarding the state of federal policy.
Yes, and we undertook the RSA modeling specifically because there was uncertainty in the state of federal policy. So we did that to help the board make a decision while accounting for what may or may not occur going forward.
Sure. Is it fair to understand the rebuttal modeling to indicate that rollback of federal zero emission vehicle policies, I think you're calling it the Zephyr scenario, can significantly impact the credit market?
Yes, it would impact the credit market, namely by impacting the number of ZEVs and the vehicle miles traveled by ZEVs in New Mexico's vehicle fleet. Credits can be generated by producing, importing, or dispensing for use in New Mexico the fuels needed for that ZEV fleet. And so with fewer ZEVs and fewer vehicle miles traveled by ZEVs, fewer credits would emanate from producing, importing, or dispensing for use the fuels that those ZEVs and their drivers need. And so there would have to be other credit generating mechanisms that allowed both for near-term bank builds of credits and the satisfaction of the annual targets as established by the Clean Transportation Fuel Standard, or CTFS, within the CTFP.
And Thanks for that explanation. I get the takeaway from your testimony on that point to be the CTFP can still be feasible, but it requires regulated parties to generate significantly more credits. And you specifically point to renewable diesel. Is that correct?
Yes, it is by no means the only way that regulated parties can make the program feasible. And I would add, like, the takeaways are not only that the program is still feasible, another takeaway is the program plays a larger role in decarbonization, generating environmental benefits, generating job benefits, and generating health benefits for New Mexicans. But with that in mind, yes, I think, renewable diesel is largely assumed in our modeling to be what we call the marginal credit generating fuel, which is to say we have credits generated from some activities such as driving ZEVs, where it's really influenced only by the fuel demand from New Mexico's existing vehicle fleet, which we just take as a given under the BCA and another given under the RSA. And then we look at other credit generating options. And by no means is it only renewable diesel. There are options to, for instance, substitute renewable natural gas for compressed natural gas in natural gas vehicles, or for fossil compressed natural gas in natural gas vehicles as one price response. And another is, for instance, reducing the carbon intensity of the electricity that is used for specifically BEVs and PHEVs, battery electric vehicles, plug-in hybrid electric vehicles, by retiring renewable energy certificates, or RECs, in the CTFP for renewable generation. That also would lower the carbon intensity and make the electricity used for those vehicles more credit generating. I think Mr. Drews is also able to speak to those various options in more detail, though.
Would you wrap up with Mr. Ford, please?
Yeah, I'm trying to be patient with letting him expound upon the answers. So I have a couple more questions to finish this. So going back to the question I asked, I think you answered your feasibility relies on significant increase in biodiesel. I think you testified in your SIR rebuttal that there's a question of whether sufficient volumes of renewable biodiesel are readily available today to close the gap between CTFP credits and deficits and achieve compliance. Is that accurate?
Well, I didn't submit a SIR rebuttal.
Well, I don't think there's a requirement for written SIR rebuttal. I'm talking to the SIR rebuttal statement that you made at the end of your presentation.
Oh, do you mean the oral testimony?
Yeah.
Yeah. Okay. Yes, there were questions about, the volumes of renewable diesel, but this was more.
And sorry, I think there might be confusion. All I'm asking you is that an accurate summary of the statement you made that there may not be sufficient volumes of renewable diesel today readily available in New Mexico to close the gap between CTFP credits and deficits to achieve compliance? I'm just asking for a yes or no if that's accurate.
No. Today and through 2027, the renewable diesel from just the one renewable diesel refinery in the state could supply enough renewable diesel through its pipeline connections to in-state pipeline connections to terminals here in New Mexico to more than satisfy the need.
And have you done that analysis supporting that testimony?
Yes, that's part of the blending percentages that come from the RSA's fuel and credits market model that Mr. Drews can speak to in greater detail, but the blend rates in that model that are needed to comply through 2027 are in fact using less volume of renewable diesel than the capacity for the one in-state refinery to produce, and are thus immediately feasible for that 2-year period. And then long term, it's the question of, does renewable diesel need ever surpass all of our diesel consumption? Because if that happened, it would not be possible to get enough diesel into the state. But I just want to underscore that, like Dr. Schubert, we find that those blend volumes peak at about 92%, so less than 100%. So it also remains feasible long term.
So your testimony is that the in-state refinery is producing sufficient biodiesel today to bridge that gap if the rule were to take effect tomorrow.
Indeed, they do have capacity to do that, yes.
Okay, are you aware of the New Mexico biodiesel mandate?
I have some awareness of the New Mexico biodiesel mandate. I'm not an expert, but I know of it, yes.
And are you aware that New Mexico has not come close to meeting that biodiesel mandate?
My belief, and I can be corrected if wrong, is the biodiesel mandate has been suspended, and thus compliance is not an actual issue that has been tested in real life.
Are you aware of the reason for this suspension?
I am not. I cannot speak to that.
Okay. I just have 2 additional, hopefully quick questions for you. Well, actually, I'll skip those and shift to, I think you said Mr. Drews may be better able to answer questions about availability of.
All right, Ms.
biodiesel.
Olson, we need a short break
Okay.
before you shift to Mr.
I have like
Drews.
3 minutes, but
no, that's
we
fine
can
then.
take a break if you want.
No, that's fine. Go
Okay,
ahead.
it won't take long. I think I have like 4 questions left. So, Mr. Drews, I apologize. Awkward looking at the screen. Have you specifically analyzed the productivity of available renewable biodiesel and whether or not that can fill the immediate short-term need for credits to establish a sufficient market?
Can we clarify terms? Biodiesel and renewable diesel are separate categories of fuel. Are you asking about biodiesel or renewable diesel? Or both in collectively?
Well, please explain, and then if it makes sense, you can answer with respect to both.
Sure. So biodiesel and renewable diesel are both diesel substitute fuels. They tend to be derived from the same feedstocks. They use different chemical processes in order to produce the fuels. They're somewhat chemically different, particularly in that biodiesel typically has limitations on how much can be blended into existing diesel engines without, basically triggering engine challenges. That those blending percentages differ depending on the model year. But renewable diesel, and I should also state that biodiesel was a technology that became mature earlier than renewable diesel. Renewable diesel is a different chemical process, and it is much more chemically similar to fossil-derived diesel, and thus a lot of the discussion here about renewable diesel has tended to focus on it being a marginal fuel because it does not have the same blending limitations that biodiesel does.
Thank you for that clarification. And can you also clarify which your modeling assumes can be a near-term substitute to maintain feasibility of the CTFP in the assumption that the zero emission vehicle policy rollbacks are in effect?
Sure. Yeah. So the modeling uses both, and I should state that there is existing biodiesel currently consumed in New Mexico today, absent any of the policies. There are not commercially significant volumes of renewable diesel that exist today. Our modeling conservatively assumes a 5% blending cap on biodiesel, which is sometimes called B5, which is generally consumable by all existing on-road diesel engines, and our modeling generally in the diesel pool allows either B0, which is 100% fossil diesel, B5, which is 5% biodiesel blended with 95% fossil diesel, or R100, which is 100% renewable diesel. So early on in the program, biodiesel consumption and renewable diesel consumption both increase relative to current day blending trends. Over time, as the renewable diesel penetration increases, it displaces B5, reducing biodiesel as well as renewable diesel use. In the BCA scenario, biodiesel remains at or above the levels that it generally currently exists in today. In the Zephyr scenario, it begins with a higher level of use than exists today, but actually falls below current levels of use due to displacement with renewable diesel.
Okay, and are you familiar with the New Mexico biodiesel mandate?
At a high level.
And that relates. Oh, sorry, didn't mean to.
No, I was going to say. I mean, I have some working understanding of what it is, why it's been suspended at a high level term. I don't, have the level of detail that New Mexico's agriculture department, for example, would have onto exactly why they suspended it.
Sure, and the New Mexico biodiesel mandate relates to what you referred to as B5 biodiesel, correct?
Yes, it specifically relates to biodiesel. My understanding is that it does not allow renewable diesel, which I would say is somewhat different than a lot of programs. For example, the RFS, U.S. Federal Renewable Fuel Standard, allows both. But yes, my understanding is that the New Mexico biodiesel mandate, were it implemented, would require all diesel sold in the state to be B5.
And I don't know if you were here previously to hear Dr. Murphy's testimony or if you've reviewed his direct testimony, but he testified generally that to the extent these alternative, or I don't want to use alternative because that probably has a regular meaning, but these renewable diesel and biodiesel aren't readily available, it can take 3 to 5 years to develop the market for that. Do you have any reason to disagree with that?
So my memory, I was here for that conversation with Dr. Murphy, and I don't want to overstep and try to mischaracterize his testimony. So I'm going to specifically speak to my understanding of his testimony. My understanding of that line of discussion was that he was speaking to a hypothetical world, which I believe he said didn't match reality where there was insufficient national supply of biomass-based diesel, and that he said that in such a hypothetical world, again, this is only my understanding of what he was saying and of that exchange, that he said that in such a hypothetical world, it could take those timelines that you laid out in order to make those supplies nationally available. I don't think that I would characterize the overall supply of biomass-based diesel, inclusive of renewable diesel or biodiesel, as being nationally constrained at this time.
Sure, but you don't disagree with, I believe, Mr. Ford's testimony earlier that additional infrastructure may be needed to get that supply to New Mexico?
I mean, I think it depends on the time frame that you're discussing. I generally don't disagree with anything that I've heard Mr. Ford speak to today about that. As Mr. Ford indicated, sufficient renewable diesel refining capacity exists in the state to meet the blending percentages that we model in the early periods, 2026 and 2027. I don't have a reason to dispute, but nor have I either analyzed or seen an analysis by anyone that sort of concretely lays out the levels of infrastructure that would be needed beyond those dates.
Appreciate that. I have two questions.
I'm not trying to shorten your time, but we do need a break about every 90 minutes.
Understood. I defer to you. I literally have two, what I hope will be very brief questions.
Go ahead.
And I appreciate your explanation. I think I'm finally starting to understand this. So we've heard testimony about the ever-changing federal landscape and uncertainty around federal policy. We've heard testimony about steps that may be needed. Do you agree that a phased approach to implementation of this program could provide opportunity for both the department and regulated community to make adjustments in response to the impact of these changes to ensure a stable and functional market?
Objection, Madam Hearing Officer. Vague as to the use of phases. There's been many perspectives on what that means.
I'm just asking generically about a phased implementation.
All right. So, Mr. Drews, you can certainly identify whatever limitations or understandings you have about the kind of phases you would be talking about in your answer.
And I'm not asking you to comment on any specific proposal. I'm asking about the benefits of a phased implementation.
And Madam Hearing Officer, that actually would be speculative if we can't tie it to a proposal before the board.
Madam Hearing Officer, I'm asking him in his expert capacity about how the board can consider implementing a proposal.
I understand you're asking a general question, and I'm just advising Mr. Drews that he can offer whatever answer he's able to offer without speculating if he has an answer on phases generally as opposed to a particular phased proposal.
So with all of that, I actually don't know that I'm the right witness for that question. I'm not. I am not and have not directly implemented a proposal. A number of other department witnesses are probably more suited for that question. I think at a high level, phasing can conceptually, help under certain circumstances, but I think identifying any specifics is sort of both beyond my capabilities as well as not necessarily something that I could do without speculating.
I appreciate that. And my final question is, does the modeling that the department provided take into account the um, the relative cost increases for greater zero ZEV? I'm blanking on what it stands for right now. Zero emission vehicle uptake. So costs related to that versus costs of the program. I mean, yeah, cost of the program. I don't know if that question made sense. I can repeat it.
Yeah, maybe if you can clarify, it's a little, there's kind of a multifaceted answer, and I'm not exactly sure where you're going.
Sure. I think one of the benefits that is stated for the program is under the scenario 1 versus scenario 2 is the cost increase. And I'm wondering if that modeling took into account the relative cost associated with greater uptake of zero emission vehicles.
So speaking across both scenarios that the department's presented, each scenario essentially assumed a set of underlying state and federal policies which affected the uptake of electric or other zero emission vehicles. Those scenarios were essentially considered in the baseline. And what that means is that neither the costs nor the benefits of any zero emission vehicle adoption was included in our isolated reporting of benefits or costs related to CTFP. As far as between the scenarios, again, we didn't necessarily across both scenarios, we did not assume any incremental uptake of ZEVs due to CTFP. That was a conservative scenario in the sense that it would tend to understate benefits and overstate costs in either case. But were such activities to occur, they generally would be occurring by actors, economic actors, in this case, individuals or businesses in New Mexico who, decided that amongst their vehicle purchasing decisions, the impact of CTFP, essentially made them, voluntarily choose to adopt more ZEVs. And in such a scenario, one would generally expect that that would actually reduce the costs of the program relative to what we stated.
Okay, that's all my questions. Thank you for indulging me.
Thank you, Ms. Olson. Let's take a short break till 11:35 and then come back and see if we can't finish up this panel.
I cannot hear anybody. I don't think the sound system is on.
It may have just started working, Mr. Lee. Can you hear me?
Yes. I haven't gotten anything since the break, if you guys already started.
I think it just started working. The sound did anyway.
We got this.
Is the computer sound muted on the witness platform?
Testing 1, 2, 3 on the platform. You able to hear us?
Yes.
Thank you.
So you can hear us?
Yes, Judge, I'm ready when you are.
Great. Thank you so much. All righty. Mr. Mollenberg.
Thank you, Madam Hearing Officer. As I mentioned before I start cross, quick housekeeping issue is to move for the admission of Dr. Schubert's written rebuttal testimony. I think it's NMOGA API Exhibit 20. And I do acknowledge the discussion and objections raised by Mr. Sona in the prior discussion.
Okay. Other than the objections already on the record from Ms. Sona, are there other objections? No. All right. So it's admitted, subject obviously to the cautions we've already talked about. Thank you. So do you have questions of, you said, Mr. Kupal?
Yes, Madam Hearing Officer, I do have questions for all three of the witnesses on this panel.
That's great.
But I will start with Mr. Coppell. And again, good morning to the panel. So Mr. Coppell, as we started to talk about off the record, my questions to you are going to focus on the issue of the R&D GREET model versus the New Mexico GREET model and your discussion in your written rebuttal testimony on those points. So, Mr. Coppell, I believe in your written rebuttal testimony, you talk about a few different recent updates to the R&D GREET model. Do you recall that?
To the R&D GREET model or the NM GREET model?
I believe to the R&D GREET model. I think you refer to 2023 and perhaps a couple of 2024 updates. And I'm not going to ask you about specific updates. I'm just kind of introducing the topic here.
I think we do make mention of an R&D GREET 2024 revision 1 in presenting the disclaimer, but I don't think, I'm not aware of any specific updates in R&D GREET.
Would you agree with me that the R&D GREET model is updated by Argonne National Laboratories from time to time?
Yeah, they do put out, maybe semi-annually or, annual-ish updates of the model. Yes.
Right. And are those updates generally intended to incorporate scientific developments and data relevant to carbon intensity calculations that will govern regulated parties under the CTFP?
I don't think, I think the updates are, first of all, are sort of well documented on their website, and I think they're not sort of uniform updates to everything in the model. They tend to focus on, maybe different pathways or different attributes that that there is further research in that they want to incorporate, or if there's bug fixes they want to make to the model, they'll go ahead and do that also as part of updates.
Thank you. So I guess the distinction you're drawing is there isn't a universal update. They tend to focus on discrete issues when they do make updates, right?
That's my understanding.
Okay. And would you agree with me that whichever model is used to calculate carbon intensity values under the CTFP will require future updates from time to time?
Oh, so for example, will an NM GREET require future updates? Is that your question?
Yeah, and I just was referring generally, but NM GREET would require updates, or if the R&D GREET model was selected by the board, that also would require updates from time to time in the future, right?
Any model that's used for carbon intensity modeling would require updates.
Okay, and those future changes to those models, or the model, I should say, will affect the calculation of carbon intensity values going forward?
It would depend on the nature of the update, but presumably.
Okay, and if the board adopts the New Mexico GREET as proposed by the department, Then for future updates, the outside models used for parameterization of New Mexico GREET will have to be reviewed and updated as well, correct?
Objection. Vague as to outside models.
Would you just clarify your question, Mr. Mullen?
Yes, thank you, Madam Hearing Officer. So if the board adopts New Mexico GREET, well, let me back up. In your rebuttal testimony, you talk about outside models incorporated within New Mexico GREET. Is that right?
Yeah, there's really, I talk about 3 specific external, and really one of the externals is just another, is sort of a version of GREET. So it's really the OPG model, and then the California ILUC values are the kind of the external outside of GREET estimates that are being brought in.
Right. So for future updates to New Mexico GREET, those outside models that you've referred to also would have to be updated, correct?
I mean, not necessarily. I think it would depend on, again, there may be updates to specific pathways that, don't merit an update to ILUC values. I mean, we've had a lot of discussion of ILUC values, and certainly any update to ILUC values is a much larger issue that we've all discussed. So I don't think I would agree with that statement.
But choices would have to be made at any rate as to what to update and what not to update.
And yeah, and really, it's sort of a similar boat with R&D GREET, because whenever R&D GREET is updated, there would have to be an assessment of R&D GREET and decisions about whether those updates need to be reflected in the CTFP or not. But I think in general, updates are really going to be specific to what is being put out through the R&D GREET model, and any sort of programmatic elements, I think that would need to be accounted for from NMED.
Is it your understanding that future updates to the New Mexico GREET model would require a rulemaking by the Environmental Improvement Board?
I'm not familiar with the specific provision.
Okay. On page 3 of your testimony, and again, I'm referring to your written rebuttal testimony, you refer to and quote a statement on the Argonne National Laboratory website that you describe as a disclaimer. You recall that?
Yes.
And you say that the R&D GREET model is not endorsed by ANL for regulatory application, yet NMED is proposing to use the R&D GREET model as the basis for most of the New Mexico GREET model. Is that correct?
I don't believe that's a fair characterization. I think what we're pointing to is the unmodified R&D GREET that we understood NMOGA API to be proposing for use for the CTFP program.
And in that regard, the second sentence of the italicized language on page 3 indicates that some versions of R&D GREET have been formally adopted in rulemakings, correct?
I'm not reading that from the disclaimer. I think what they're saying in the disclaimer is that numerous rulemakings use R&D GREET as a basis, but then are adapted specific for the policy, whether it's tax policy or state policy. So it's actually quite consistent with what NM GREET is in terms of a model for the program.
So are you disagreeing with that part of the disclaimer that you quote, saying numerous versions of GREET are currently publicly available, and then in parentheses, including versions that have been formally adopted in rulemakings, referenced in rulemaking documents, and referenced in solicitations, comma, in parentheses, and others are likely to become adopted?
Objection. Asked and answered. Mr. Kupal answered what he thought about that portion of his testimony, quoting the text.
Right. Was there something else?
Well, my question was whether his testimony then disagreed with the statement in the disclaimer.
All right, go ahead.
No, because the numerous versions of GREET, I believe, and this is actually clarified in the following sentence, But the numerous versions of GREET, I believe, are referred to as, for example, California GREET, Oregon GREET, Washington GREET. And then the following sentence says, these derivatives of R&D GREET model. So yes, these derivatives of R&D GREET model would include California GREET, Oregon GREET, Washington GREET. So nowhere in this disclaimer am I reading, am I interpreting that, and I guess that's why they are putting out a disclaimer, is that they're saying R&D GREET is not used directly for these regulations.
But certainly parts of it are used directly, correct?
I think that's what they're saying. Yes, they're saying that derivatives of the R&D GREET model, which I would include NM GREET as a derivative. You know, they're starting with the R&D GREET model, but they're adapting it for the regulations as necessary.
Now, the statement on here goes on to say that the derivatives of R&D GREET used for a particular regulatory program will reflect the particular statutes and parameters of those programs, correct?
Yes.
And the different programs have different statutes and parameters that govern each of the programs, correct?
That's my understanding.
Do you think it would even be possible for Argonne National Laboratories to develop a single version of R&D GREET that could reflect all of the different statutes and parameters in the various programs?
Objection. We've established, is it possible? Speculative questions aren't helpful.
All right. Mr. Coppell, if you can answer it without speculating, go ahead. Otherwise, just say so.
That's just speculation.
Well, let me ask it the other way around. You know what? I think I think my point's probably been made by the question. Would you agree with me that nowhere in your testimony you cite a specific statute governing the CTFP program that compels the use of an outside ILEC model?
I would agree with that.
And the same question with regard to the OpG model.
Yes.
So instead, would you agree with me that the selection of the ILUC and OpG models used for parameterization within the NM GREET model are based on technical or policy judgments?
Yeah, I guess I do want to clarify that there is the directive to NMED to coordinate with other states, and I think that is certainly that comes to bear in terms of the choices, some of the choices made for NM GREET. But I think that the technical basis is in terms of trying to get to the most accurate and sort of, I think, most appropriate for the rule version of the model that I think is reflective of broader estimates and broader science that have been published in the literature, embedded in the literature, and we think is a better source of CIs than the unmodified R&D GREET model.
Thank you, Mr. Coppell. Turning to the ZPR modeling, and my understanding is that ERG had a role in that, right?
Yes.
You didn't run a version of that model that would incorporate the carbon intensity of palm oil for all biofuel feedstocks, did you?
Objection, Madam Hearing Officer. This exact question was asked of either Mr. Ford or Mr. Drews by CCAE. So I believe it's repetitive to ask it of Mr. Coppell.
Okay, that's overruled. If you have an answer, Mr. Coppell.
Sorry, could you repeat the question?
I was just asking you with regard to the ZPR modeling, whether any version of that modeling reflected the CI value of palm oil in place of the CI values for, I think in the model you ran, it would be just for soybean oil. Is that right?
I think that question was addressed by Mr. Drews in response to Ms. Olson's questions, but the modeling of CI values through the model system would be not have been in ERG's lane, but is more related to the fuel credit market that Mr. Drews ran.
Okay. Thank you, Mr. Coppell.
Is that all of your questions of Mr. Coppell?
That's all of my questions of Mr.
All right,
Coppell.
you've brought us exactly to noon. So I think in order to preserve a lunch hour and come back at 1, we ought to take a lunch break. And
Okay.
then if there's any public comment, you can ask your questions of Mr. Ford and Mr. Drews after that.
Okay.
Thank you very much. I'm back at 1. Thank you, Pam. We are on day 13 of the hearing in EIB 2523 on the Clean Fuels Transportation Program. We've come to another public comment session. I saw one person on the, I'm sorry. Mr. Lee, can you hear me?
Yes, Judge.
Okay, good. Thank you. Okay.
If someone is trying to speak on the record, I can't hear them.
No, they are evaluating the speakers in the room. Hello, hello, hello. Yeah, all right. Terrific. I saw one person on the platform who indicated in the chat that he wished to offer comment during this session. Tim Buxton. Mr. Buxton, are you on the platform and can you unmute yourself?
Okay, I seem to be unmuted. Can you hear me, please?
Yes, thank you. Would you spell your first and last name, please?
Sure. I'm Tim Buxton, Tim Buxton, as in North.
And do you swear or affirm to tell the truth?
I do.
Thank you. I'll start your time. Please keep your comments to about 3 minutes.
Right. Okay, thank you. Madam Hearing Officer and members of the board, my name is Tim Buxton. I want to thank the Environmental Improvement Board for carefully considering this important proposed rule and for making it available for all of us to listen to. I want to thank the Environment Department for their hard work to develop and propose the rule. I also want to thank Governor for seeing how vital renewable energy and transportation is to New Mexico's prosperity, advanced technology, and workforce development. I am a retired high school physics and chemistry teacher. My wife and I love hiking and camping here in New Mexico, so we care a lot about the state and its future for our 3 grandsons who live near us in Albuquerque. I have listened to many of the discussions deciding this important clean fuels rulemaking. And in response, I want to address what Ms. Lozzi said yesterday. She gave the NMOGA opinion in her testimony that all vehicles be treated equally. NMOGA holds that combustion engines are the same with regard to carbon as EVs, so that the energy economy ratios, or EERs, should not be assigned. I believe this would be an absolutely false approach. Why is this wrong? Because any fuels other than electricity are compounds of carbon. Carbon is the very element we are working to avoid. When burned to propel our vehicles, they exhaust carbon dioxide, the greenhouse gas, and partly burned carbon molecules that the sun's ultraviolet light in New Mexico turns into long-attacking ozone in our air. That is the regrettable and avoidable story of using heat from burning carbon to produce motion for transportation. What about electricity? Electricity is pure energy, ready to produce motion directly by a magnetic force. Electric vehicles need no exhaust pipes because they do not spew out greenhouse gases, lung-attacking compounds, and particulates that carbon fuels always produce. EVs turn 90% of the electricity they get into useful work, cleanly. So I believe we can count ourselves lucky that electricity is now available as a clean fuel generated by solar and wind in New Mexico. Electric vehicles emit no greenhouse gas emissions and no exhaust pollutants which attack our lungs. Therefore, the credit markets we establish should give electricity fuel every possible support and so encourage more EVs, which are pollution-free and carbon-free. In order to give this encouragement to electric fuel, our 2 EV driving families strongly recommend that we give the EVs of our state the energy economy ratio of 4.4 that they have been given by the National Renewable Energy Laboratory. And that is what they deserve. Thank you very much.
Thank you very much, Mr. Buxton. Is there anyone else on the platform who would like to offer public comment during this session? Our next session will be at 1 p.m. tomorrow. No? All right. We will resume the technical case then. Mr. Mullenberg. When we broke for lunch, you had expired your time on Mr. Coppell, so now you have 15 minutes each with the other 2 witnesses.
Thank you, Madam Hearing Officer. I think this is on. Okay. My next set of questions is for Mr. Drews. Good afternoon, Mr. Drews. I guess it's a little bit later in the afternoon your time. Mr. Drews, I think you are muted.
You are very correct. Good afternoon, and apologies.
No worries. So, Mr. Drews, I have some questions for you relating to the modeling work presented in, I think it's NMED Exhibit 143.
Okay.
The testimony describes the modeling as a sensitivity analysis. Is it fair to say then that essentially you've run a different version, or perhaps more accurately a version of the initial model using some different inputs for the variables? Is that true, or perhaps it's better for you to describe it in your own words?
Sure, I'd be happy to. First, let me just actually clarify. You're referring to NMED Exhibit 136, right?
I'm referring to it perhaps is 136.
Right.
It's
I don't know what's in Exhibit 143.
Okay, fair enough.
But yeah, presuming that that's correct, and we're talking about the modeling underlying the RSA, yes. We ran the same model as with the BCA, with the same assumptions, with a few exceptions that I think we are covered in both the RSA document, which I believe is NMAD Exhibit 134, as well as my testimony, and to some degree the testimony of my co-panelists. The largest change in assumptions, as we've discussed, was the removal of a variety of policy assumptions which support ZEV adoption, zero emission vehicle adoption in the state. Most notably, the new motor vehicle emission standards, or NMVES, There were a handful of other changes to the model, most of which concern biofuel availability and policy, which I've outlined in my written testimony and are also outlined in NMAD Exhibit 134, the RSA. But beyond what is sort of explicitly specified in those documents, the same model was run with the same assumptions.
Thank you, Mr. Drews. You described the new modeling work as to establish a bookend low value for how the program will perform. In contrast, is the BCA version of the model the other side of the bookend or the high end of how it would perform if the legal questions were resolved as NMED prefers?
Sorry, first of all, I don't specifically recall using the term low and high. If I did, I'm happy to be corrected there. But I did describe them as two bookends, and I think it's appropriate to say that while there are a number of conservative assumptions which have been outlined in the benefit cost analysis appendix B in particular, I cannot specifically recall the exhibit number. I can get it if need be. There's a number of conservative assumptions, and by conservative here I mean assumptions that would tend to increase estimated costs and decrease estimated benefits of the policy that are present in both models. So I think that one could certainly envision a scenario with the policy outcomes that you just identified where costs would be lower or benefits higher than what was estimated in the BCA. But I think that certainly, that within the discussion specifically of policy outcomes, I think that's probably roughly appropriate.
Madam Hearing Officer.
Ms. Sona, Pam is in the sound booth trying to address the pops and crackles.
Okay, as long as Mr. Mullenberg can hear and the board can hear, I'm okay. I just want to make sure it's not too distracting in the room with what Mr. Drews is answering about.
Okay, thank you. I'm sorry, Mr. Mullenberg.
No worries, Mr. Drews. We're having some issues with the sound in the room. I think I'm fine going ahead, but please, Madam Hearing Officer, tell me if you want to stop me to stop.
Thank you. Go ahead.
So yeah, I did notice in your testimony you said a bookend low value, and I wasn't quite sure what you've meant by that. So I appreciate your clarification here. So at any rate, with this model, would you agree that there's a high number of variables within the model?
Yes, I mean, obviously, high can have different meanings depending on who asks, but I think that's an appropriate statement.
Right, and each of those, with respect to each of those variables, there are either different assumptions that can be made or different data can be used to define each of the variables?
Yes, I mean, I think some assumptions are more reasonable than others, but there are a variety of variables where reasonable minds could disagree on what's the best source.
And I guess the point I wanted to make, which is relatively simple here, is just that with models such as this, they can really predict a large range of outcomes depending on what values the modeler assigns to particular variables. Would you agree with that?
Yes, I mean, with the caveat that, as I discussed, we tried to explicitly, when we saw uncertainty, we tried to explicitly make assumptions that would tend to underestimate benefits and overestimate costs.
Thank you. One of the variables in the model is an assumption or value assigned to crop-based biofuels, as you discuss on page 3 of your testimony. Is that correct, or do you have any clarification of that?
Let me go there. It's slightly. Sorry, I'm just trying to find. So on page 3 of my testimony, I think just to clarify, I'm speaking, I believe, to the overall carbon intensity of crop-based biofuels. But yes, the overall carbon intensity of biofuels is one of the assumptions in the model.
Okay. And when you're looking at that particular assumption, whatever value you are using for your predictions can be affected going forward by changes in federal policies affecting international trade. I believe you point that out. Is that right?
Yes, and I think it's important to clarify. We intentionally selected a conservative, and again by that I mean high cost, low benefit carbon intensity by assuming that 100% of all of the biodiesel and renewable diesel consumed in the state are derived from soybean oil, which is one of the higher carbon intensity feedstocks available, and the highest carbon intensity that's widely used in programs comparable to this. But yes, so I believe that our assumptions have baked in a lot of the trade headwinds that I discuss in my testimony. But yes, I agree with your statement.
And the trade headwinds, that's really just, we're talking about the price of soybeans as a commodity, correct?
The price of soybeans as a commodity, as well as certain assumptions around the availability of imported waste oils.
And with regard to soybeans in particular, there are a lot of factors that affect soybean prices, such as weather, drought, and those kinds of factors as well, right?
Yes, those are among the factors that affect the price of soybeans. I will say we are using the second most recent USDA forecast for the price of soybean oil. There is a more recent forecast. I should clarify. If we had adopted that, we would have generally shown lower credit prices and lower consumer costs of the policy. But in the interest of preserving comparability, we are using the second to most recent USDA forecast for soybean oil and essentially baking in their assumptions.
Thank you. And moving to a different topic, on page 6 of your written rebuttal testimony, you testify that based on the additional modeling results, the model predicts that the CTFP policy targets are still achievable. Does that sound correct?
I don't specifically see it there, but that is a statement I'm fairly confident that I make in my written testimony.
Thank you, Mr. Drews. And I'm kind of focusing on the word achievable. And I'm wondering if your model assigned any degree of certainty or uncertainty that the CTFP policy targets are still achievable.
So I think it's important to clarify the model is an optimization model, and as such, like most optimization models, it's deterministic. So we did not run something like a Monte Carlo simulation to try to derive probabilities. There are many factors that could conceivably play into that. I don't actually know that I would say that the price of soybean oil, for example, it would be the first factor I would point to from the question of achievability. But no, like most optimization models, it's deterministic. So there's not an uncertainty range around that.
Thank you for that. And that really was the gist of my question. Mr. Drews, do you have your written rebuttal testimony with you there?
Yes.
Okay. Could you take a look at figure 4, projected credit and deficit generation and bank balance?
Yes, I am here. I am there.
Okay, thank you. I'm particularly focused on the purple line showing the bank balance. Do you see that?
I do.
So that line shows a steep increase over the first, well, it looks like up through the year 2029. Is that correct?
Yes.
And that represents credits being banked during that period?
That's correct.
And then from that point, the line drops for the rest of the period shown by this figure, correct?
Yes.
And that reflects that for each of the years where that line is declining, there's actually a net deficit in can't think of whether it's deficits or credits, but in other words, the projected volume of deficits for each of those years exceeds the projected number of credits. Is that right?
Yes, and I think it's important just to clarify that that this figure we're discussing is representative of the Zephyr scenario.
Right, right. And at the end of the period there, 2040, it shows, based on this figure, that there is no remaining credit bank, correct?
That's right, and I think it's important to note to our earlier discussion about not changing assumptions from the BCA. In both scenarios, the model was set up in order to essentially evaluate the program through 2040. I would describe that as a modeling artifact and not necessarily an indication that anything in the model would suggest that is a necessary outcome. Some of the optimization logic essentially was keying into that value.
But if this model became an accurate prediction of the future, do you think it presents a sustainable course for the CTFP program?
Objection, Madam Hearing Officer. The question calls for speculation. There's no representation that this is an accurate representation of the future.
Yeah, Mr. Drews, I would have to ask you not to answer the question if it requires speculation on your part, but if you have something else to say, that's fine.
I mean, I think that probably would require speculation as phrased.
Yeah, thank you, Mr. Drews. Just a last question. In the model, is there any consideration or accounting for credit market liquidity?
Yes, I mean, the model is essentially designed in order to ensure that there are sufficient credits to meet the deficit obligations in the model.
But other than showing that there are sufficient credits in the market to cover deficits that would be the only measure of credit market liquidity that the model considers. Is that right?
Can you be specific about what types of liquidity measures you're referring to?
Well, I was going to ask you if you had answered something differently. What liquidity, what credit market liquidity measures the model uses, and perhaps I should just ask that question.
Sure. So the model does not have. Well, let me clarify this a bit. The model has limitations on foresight, as well as limitations on the feasible rate of credit bank growth. There's not in the model a specific parameter that seeks to essentially maintain credit market liquidity above what is ultimately necessary in order to achieve policy compliance. I think it's important to note that prior to the last year of the forecast, there is a net credit bank in the model, which would show sufficient liquidity as far as any liquidity measures in the last year. The model, due to a modeling choice to end at 2040, does not require final year liquidity value, though were that to be incorporated, I don't think it would meaningfully change the underlying conclusions of the findings, especially because while the policy CI reduction values cease to become more stringent after 2040, while a number of factors, including electric vehicle penetration rates and the carbon intensity of grid electricity, continue to become more clean and would tend to loosen the market going forward.
Would accounting for market liquidity in the model affect its projections as to credit market prices?
It would depend on exactly how one were to do that. I think that the way that the model is set up, the credit market prices are set by the marginal cost of generating another credit, and so there's not an additional, as long as there are additional credits that can be generated in the model, there's not a formal incorporation of liquidity measures. So I don't think that if that were done to sort of a small degree or to any degree that I would describe as sort of typical in this space, I don't think it would have a material impact. You would just end up with a little bit more credit generation, which would increase both costs and benefits relative to what is shown here.
Mr. Mullenberg,
yeah,
even adding to your time, it's done.
Okay, and that's fine. That was the end of my questions for Mr. Drews anyway. My remaining questions are for you, Mr. Ford. So on page 2 of your written rebuttal testimony, you discuss modeling anticipated EV or electric vehicle adoption rates based on various factors. Does that sound correct?
Yes, that is broadly what is addressed there on page 2.
Would you agree that the actual availability of credits based on EV adoption will depend upon consumer decisions regarding electric vehicle purchases?
Objection, Madam Hearing Officer. This calls for speculation.
All right, same caution, Mr. Ford. If you can answer it without speculating, that's great.
What I can say about the model itself is that implicitly the fleet and VMT numbers in the analysis that drive ZEV fuel consumption and the credits that it generates do require implicitly consumers to purchase ZEV vehicles for the fleet and the degree to which they travel in said vehicles.
Referring to pages 9 through 10 of your written rebuttal testimony, would you agree that the new modeling work that you're discussing shows heavier dependence on drop-in fuels to supply the necessary credits?
Broadly speaking, that is true because there are fewer credits from the purchase and driving of ZEVs. In the specifically Zephyr scenario, drop-in replacement fuel uptake must increase in order to meet the carbon intensity reduction targets of the CTFS.
And specifically, I think if I understand, and tell me if I'm wrong, that the new modeling work anticipates that most of the difference in credits will be made up by renewable diesel. Is that correct?
There are three principal options that make up the difference between in the model, and this is not to say in real life there are other options that the model is not considering in order to be conservative, i.e. low benefit, high cost. But in the model, there are three principal options that regulated parties use to make up the difference between deficits and credits. Those would be increased uptake, as we've discussed, of RD, increased blending of RD, increased use of incremental RECs, renewable energy certificates that are retired to lower the carbon intensity of that electricity that is used so that it generates more credits, and increasing blending of renewable compressed natural gas with the natural gas consumed for natural gas vehicles, which lowers the carbon intensity of that fuel that's consumed and also incrementally generates more credits to help meet each year's target.
So you said a lot in that answer. And of course, I was focused on renewable diesel, but is it fair to say that the outcome of the new model results depends upon the availability of renewable diesel within the New Mexico market?
Objection, Madam Hearing Officer. This has been asked and answered. The witness just answered that question to the best of his ability.
Do you have anything to add, Mr. Ford?
So I will say that to the degree that credits must be generated above what can be generated from blending renewable natural gas and from retiring RECs, that once those options are exhausted, there is additional slack for RD to pick up and help as the marginal source of credit generation to close the gap each year and or bank more credits to close it for future years.
Thank you, Mr. Ford. On page 9 of your written rebuttal testimony, if you're with me, I'm looking at the last paragraph, which is the second paragraph that starts on that page if our printouts are the same. The paragraph that I'm referring to said, "It is worth noting."
Okay, that
I'm
is a
thinking of our
different
different
printout.
pages. Your
It is
printout may
worth
be different
noting.
than
Is
mine.
that's the start of the paragraph?
Yeah. I know printers work differently sometimes. This is in it's under a heading C that starts infrastructure needed for credit generation. And it's about the third page of that section. See if we can get lined up here.
Okay, I'm in that section. It's important to mention infrastructure. It is important to mention. Is that no?
No, it's actually
It is worth noting. Okay,
it is
got
worth
it.
noting.
Sorry.
We're there. Okay,
Yes, go ahead.
perfect. And I guess in my first question here is, was there a particular reason that you selected Washington State for comparison in this paragraph?
I selected Washington State for comparison because I know that there are some parallel policies that they have in place, such as cap and invest, which we do not here. So I will acknowledge that up front. But I selected them because they're the closest analog to a state that has recently enacted a similar policy and that has broadly similar ramp ups, I believe, before the latest changes, which actually increased their carbon intensity reduction targets. They had a target of 20% CI reduction by 2034 versus 2017. It's as close as we can find to an analog of a state that has recently enacted such a policy and had to quickly increase the volumes of biomass-based diesels to generate and bank credits. I'll leave it there for now.
And thank you for that. And actually, you pointed out the cap and invest program in Washington, and would you acknowledge that the cap and invest program in Washington has an effect on credit prices in Washington?
I would acknowledge that and add that that is the lack of such a policy in New Mexico in our modeling also helps to explain why our prices are credit prices in our model are generally 2 to 3 times theirs that they are experiencing presently.
Right. And in fact, you make mention in the paragraph that we've been talking about that Washington credit prices have averaged less than $30 per unit for every month in 2025, right?
Yes.
And over that same period of time, credit prices in Oregon and California have generally been considerably higher, correct?
Oregon, yes. California is actually closer right now to Washington State than it is to Oregon.
Madam Hearing Officer, can we have a time check, please?
You have about 5 minutes, Mr. Millenberg.
Madam Hearing Officer, I would object to 15 minutes with Mr. Ford when Mr. Mullenberg went extensively over his time with Mr. Drews and I've even accounting for some of the lapses and breaks and things like that. So I'd object to it being 5 minutes remaining.
All right, so I'm going to stick with the 5 minutes. I did add a few minutes to the time with Mr. Drews because of the many sound disruptions. It was really distracting. Go ahead, Mr. Mullenberg.
Thank you, Madam Hearing Officer. I'm just looking at my notes, but I may actually be finished. Let me just look at one more thing here. Back about 3 pages from where we were just looking at, I'm on page 36 of my version, and it's the page where it shows figure 3 at the top. And in the text below those figures, there's a sentence that says, this analysis used a static projected price for CTFP credits based upon historical prices in the Oregon Clean Fuels Program. Is there a particular reason why you picked Oregon for this particular analysis?
To clarify, this analysis on page 36 is in reference to neither the BCA nor the RSA nor an analysis that we have submitted as an exhibit. This was an internal estimate when we were deciding what ramp up to use for the CTFS. That was a feasibility analysis, and I don't recall why we just plucked Oregon's prices, but that's what we did just to have some analog to compare different CTFS curve possibilities. But it was not anything akin to the fuel and credit markets module that was developed for the BCA or RSA that has dynamic prices and actually illustrates what a market outcome would look like.
Okay. Thank you, Mr. Ford. That's all the questions I have. Thank you for your time, and thank you all for your testimony.
Thank you, Mr. Mullenberg. Ms. Sona, do you have redirect?
Thank you, Madam Hearing Officer. I have no redirect for these witnesses and would, from NMED, sincerely thank you for your testimony and being here with us today.
Thank you, Ms. Sona. Member Ely, do you have questions of the ED panel?
Yes, I do. Just one moment. The enabling statute for this rule requires that the board adopt a rule, regardless of whether ZEV is on the books or not. But your modeling provides us maybe some insights about what costs or volume would be without the program. I'm wondering if you can answer, it may be best for the next panel. Are there any obvious policy strategies that we should consider to build a resilient program in case the states do not prevail in 177? The challenge is lost. Is there anything we can do based on the modeling to consider costs and environmental impacts?
I'll start there. I think this is something that we have thought about already to a really high degree. And so like our cost containment mechanisms, they really do a lot to prepare us for any situation that may occur. I would probably not be within my remit to advocate for any policies outside of the CTFP, but just within the remit that we have received from the state legislature, we have a very robust policy framework of allowing, when there's tight markets, for regulated parties to have a credit clearance market, taking measures to ensure that that market is liquid and that regulated parties have options for compliance, being as flexible as we can to make sure that that compliance can be done in an economically feasible way. The deferral mechanisms and the banking provisions allowing regulated parties on their own volition to plan for a rainy day. I hate to just answer that question by kind of tooting our own horn a little bit, but I think it really is something that we have been rarely considerate of and addressed to a really high degree.
So the way the existing draft is written does provide a resilient program that can weather some of these federal changes.
It does, and furthermore, I would say that it provides discretion with how the program is implemented should the worst case scenarios occur with regards to any unforeseen emergency or forecast conditions, to very adequately address any changes in underlying conditions that we wouldn't plan for, other than those in the RSA model, where the program survives what I would say is a pretty stringent stress test and makes it all the way through.
And then this next question may be best directed at Mr. Drews, but of course, any panel member can chime in. Mr. Drews, you did, maybe it was on the cross with CCAE, you did talk about what happens if the challenge to 177, if the states fail their challenge to the administration's proposal to roll back the provisions of 177 in the Clean Air Act. So I'm wondering, considering that the three states that currently have low carbon fuel standards are all 177 states, and if they all lose the ability to increase their number of credits in those states because of that rollback, seems like there will be a lot of competition to get some of the renewable diesel in each of those jurisdictions. Can you maybe give us a little more insight about what you think might happen to the market if we have both, if we do lose the 177 state challenge?
Yes, sure. Yeah. Thank you, Member Ely. So, I think first of all, in the discussion with CCAE, I was really limiting some of those statements to competition for waste oil, which I will start with. Waste oil is, which can include used cooking oil, as well as other low or no ILUC feedstocks like tallow. And I would probably also throw distiller's corn oil into this mix. These are feedstock limited resources. They're not, sort of definitionally, the reason that they don't have large ILUC values is because you can't just increase acreage and get more of them. And the reason why we took the very conservative step, which has not actually materialized in any state to this point, of assuming 100% soybean oil in the Zephyr scenario, was because we wanted to provide you with a stress test of exactly what you were describing. Essentially, what would happen if states start to really compete for these sort of feedstock limited fuels, and so that's why we did that. I think, as I was discussing with the CCAE attorneys, I think that California's current policy has a number of features which, in addition to its sort of long-time status as the largest receiver of these lower CI feedstocks by far, I think it would continue to consume a large share of those. And for that reason, I somewhat think that competition within the higher CI sort of crop-based feedstock space, which is limited in the number of credits it can generate in California, would actually be a little bit less relevant in that case. I would expect that at least in the BDRD market, you would see some degree of bifurcation. I think with respect to competition between New Mexico, Oregon, and Washington, I also think it's important to note that the federal RFS, and I went over this somewhat in my testimony, but the federal RFS sets renewable volume obligations for biomass-based diesel, and so a variety of policy changes, have actually limited the eligibility for certain waste-based feedstocks there for full satisfying of renewable volume obligations, largely due to penalties for imported feedstocks. And the federal RFS renewable volume obligations for these fuels are higher than even near term than the total diesel demand from all sources in Washington, Oregon, and New Mexico combined. There are other states with biodiesel type mandates that would come into play, but I think that you would see quite a lot of federal support, at least under current policy, for crop-based feedstocks, or for biomass-based diesel derived from crop-based feedstock, which would, I think, ensure that all three of Washington, Oregon, and California, and New Mexico can access a fairly high volume of these fuels. They would tend to be the premium markets under most circumstances to receive them. And I think that the actual increase in renewable volume obligations, I believe it's something on the order of a 30 to 40% increase just over the next 2 years for biomass-based diesel from 2025 values, but that the increase of these would go a long way to making sure that there's sufficient supplies available.
Thank you for that. And you also, I think, in the same cross mentioned the ILOC value of palm oil would limit maybe the number of credits that the state could generate for these biofeedstocks because of its high value. Would that play into the availability of biofuels under the scenario you just described?
Yes. Well, functionally, yes. If a palm oil ILOC was adopted for all crop-based feedstocks, while one could import crop-based feedstocks into New Mexico, they would not be materially credit generating. They may even generate more deficits than fossil diesel in certain circumstances. And so if that were adopted simultaneous with something like a successful challenge to 177, I think there's a high probability that New Mexico would get into a bidding war with California for feedstock limited biomass-based diesel, which I don't think would serve anyone's interest, and potentially could lead to substantial and long-lasting deferrals.
And then one last question, I think, for Mr. Kopel. Did the latest SRA model consider the change in the rule which eliminates liquid fuels from book and claim regarding the level of criteria pollutant benefit from the program?
We did not. I mean, I guess I don't know if Mr. Drews has any input on book and claim. Go ahead.
Let me start. I should just clarify. We did not actually in the BCA modeling. We did not assume book and claim for liquid fuels. We did for electricity and gaseous fuels, but that change didn't impact the liquid fuel modeling in the FCMM, which would flow through into the health impact analysis.
That's all for my questions. Thank you very much, gentlemen.
Okay, thank you. Member Garcia?
No questions right now. Thank you.
All right, Madam Chair.
All right, I'm gonna just share some questions, and whoever can best answer. I'm trying to keep track of whose expertise, but if you want to just chime in, and with the exception that I think this will be for you, Mr. Copal. I understand that there's been concerns and discussions raised about the evolving regulatory framework that we're all living through, in particular in regards to electric vehicles. But it's my understanding that from your presentation and testimony that your recent analysis aims to take into consideration a conservative consideration in terms of some of the evolving regulatory framework, in particular to electric vehicles. Is that correct?
Yeah, that's correct. The scenario specifically accounts for, and this is based on the modeling that was done by the
speaking and start again.
Okay. The scenario that we modeled specifically is based on modeling done by the Energy Information Agency, the Annual Energy Outlook, which specifically modeled a scenario of no ACC2, no California programs, no ACT, Advanced Clean Truck, so by extension, no NMVES, and then also the rollback of the Biden era rules for light duty vehicles and heavy duty trucks, known as the 2027 multi-pollutant rule and the phase 3 heavy duty truck rule. So the projections I was showing this morning already account for those being rolled back. And then what is being accounted for in terms of electric vehicle sales is sort of a combination of market momentum. You know, there is, I mean, I think I've testified here a couple times, and, you know, drawing on my experience working for Nissan, you know, in the auto industry, and just a lot of interaction with automakers, having worked for EPA, that manufacturer product plans don't turn on a dime. You know, that manufacturers are planning at least 5 years. They have their product plans already, you know, planned out at least 5 years in advance. And so there are a continued expansion of electric vehicles on the market. I mean, we're seeing new models introduced, and we are also seeing attempts by the automakers to try to make up for some of the loss in federal tax credits, for example, through incentives. You know, several of the major auto manufacturers are actually offering financial incentives to make up for tax credits. So I think that there is continued momentum for EV sales, and that's sort of what's driving the projections, you know, even that we modeled and showed this morning, even with the rollback of those rules.
Thank you for that. And I know I listened through the testimony and read the testimony by Dr. Schubert and yourself. On the demonstrative exhibit, page 4 of your presentation, you had a line where the AEO 2023 reference, I think, was from the Stillwater reference, and then the AEO 2025, the all trans MTN. What is the difference between, can you just remind me what the difference between those two assumption lines are? What is, I know one is lower than the other,
Sure,
but
yeah.
but when I just know, when I look at it, you know, we're looking at you know, of course, on the y-axis, it's a looks like percentages.
That's
But
right.
can you further explain?
Sure. Yeah. So the AEO 2023 case was, you know, I guess as the name suggests, I mean, that was sort of the, you know, each year AEO updates their modeling, you know, their modeling suite. And so that was from, you know, their projections for, you know, published in 2023 or maybe even prior to 2023. I'm not sure exactly when they published. So it was actually before those rules were put in place, before the rules I just mentioned. But it's also was before kind of the current market momentum that has been created with those rules sort of already being in place, right? And so it's sort of similar assumptions with respect to the policies, but the AEO 2025 alt case is kind of considering the more recent movement of the market and drivers with respect to EV sales.
Thank you for that. And I don't know if this is a modeling question. Well, it is a modeling, just so that I can understand. In some of the analysis, there's, you know, we talked about kind of how this rule will impact, I guess, the market and how, you know, all of the analysis, the cost benefit analysis will happen. Can you share a little bit more of how how, I guess, the timing of the implementation of this rule was in terms of certain milestones in your model, in terms of cost benefit? And if, you know, given that we're looking at, you know, years out on the model, I guess what I'm just trying to get, is there a point where, maybe I'm doing a compound question here, but is there a point where, you know, as we go forward, where the cost benefit, when is it a, you know, a positive cost benefit where it's a good, we're in a good place, and then where, I don't know if I'm making sense here, but, and then where are we seeing that, you know, we need to take it out more, has to be more years out before we realize cost benefit for this rule?
Thanks. Yeah, I think that's a good question, but I'll pass it on to Mr. Ford to start.
Yes, thank you. When you switch between yourselves, if you would just state your names. Yeah.
This is Michael Ford again. Yes, so it is a very good question. And the first thing we start with when we're looking at the different targets year by year is what we must do under 74-1-18. I mean, that's the statute that we are here to implement on behalf of the state legislature. In terms of what happens in between the targets that statute sets for 2030 and 2040, in forming this rule, we had some discretion of the annual targets between those decadal targets and how we get there. And so we did look at that, and we looked at 3 different approaches. One, and this is particularly for getting to the 2030 target of the 20% reduction, because that's the fastest acceleration in the program, is how do we do that in a way that balances the need to get greenhouse gas reductions going and get the benefits of cleaner air going and get the benefits of building clean energy going, while balancing the need early on for regulated parties to generate kind of credits above deficits that they can bank and help meet that ramp up that happens in later years. So we looked at a linear, it's kind of a Goldilocks type story here, but we looked at a linear curve that just connected us from 0 to 20% with like 4% increases, just 4, 8, 12, 16, 20. Then we looked at a graduated slope that I called it the half moon, because it looked kind of like a half moon when you looked at it sloping up. And that was based on a mathematical formula that I can explain if desired. And then we looked at something that's called the hockey stick, where we just make the target ramp ups as small as we can in early years. Like it's 0.5 percentage point each year until 2029, and then it just shoots up to 20. And so that last one is the first one, the linear, is maximum greenhouse gas reductions, minimum banking. So like that generally means higher cost. The other extreme was the hockey stick, where the curve was so slow at first that was minimum greenhouse gas reductions, but maximum banking and ease of compliance. And the half moon was between the two, and it's kind of like a Goldilocks, where you are getting some near-term greenhouse gas reductions, some near-term air quality benefits, near-term jobs to put the infrastructure in place to get the credits up and running. But it's not so sudden that it, excuse the analogies, pushes down too hard on the gas and kind of blows out the engine. So it's a good compromise between the two extremes. And so we looked at that, and it really is what got us where we needed, and balanced the environmental goals of this program with the concern and ability to contain costs from the program.
Thank you for that. And I think I want to explore that a little bit further. I know we've talked about some of the assumed infrastructure or current existing infrastructure in New Mexico. So in your that response, is that where also there's been the discussion about the renewable diesel infrastructure that is currently in the state? Is that something that you considered in the modeling assumptions?
To get to the bottom of that question, we had to look at the blending rates that we anticipated regulated parties would need to do in 2026 and 2027, not just to comply with those years, because the targets were, that's 1.8 and then 3.5. Those are not the highest targets, given we're going to we're going to 20% in 2030. But so we thought about not just to meet those targets, but also to bank enough to meet the future years, to make sure that they have enough credits in the bank to make it work in 28, 29, and 30. We said, what kind of blending rate? And Matt's model, which does an optimization, so it's not we said, it's we modeled regulated parties that were looking to comply in the most efficient and effective way possible. What kind of blending would they need to do in 26 and 27 to get that credit bank built up to an ideal level? And that blending rate maxes out in 2027. Well, not maxes out, it is in 2027. It reaches 15.5%. But we did that analysis was like after Matt ran his model, which was later on from when we decided on the curve. We later on, Matt ran his model and we looked at what those blending rates were. And that is where we said, okay, without any kind of prejudgment or priors, we came in and said, what's the model say? Okay, the model says 27, it's 15.5%. Okay, what's our in-state capacity that we have pipelines connecting terminals in this state to now from Artesia? Okay, with the recent expansions, it's 9 million gallons a day. Okay, take that 9,000. Sorry, it's 9. It should be 9,000 gallons a day, not 9 million.
9,000 barrels a day, I think.
Barrels a day. Sorry. 9,000 gallons a day times 42 was where I was going. 9,000 barrels a day of capacity. Okay. What does that allow us to blend at? And as Dr. Schubert said in his testimony, That would allow, he said, about 20%. We calculate 18.5%. Okay, so Matt's model with the optimization says the optimal compliance plus bank build that regulated parties would need is 15.5%. Those 9,000 barrels a day times 365 into our diesel pool get us 18.5%. Looks like in-state capacity succeeds with some cushion. That's something we didn't really determine until after Matt ran his model, though, and we'd already decided on the curve. But it definitely does give us some faith, and that is, by the way, in this Zephyr scenario where kind of everything comes up snake eyes for supporting policies. That is in this kind of absolute stress test sensitivity case that we make it through 2027 with in-state and a little bit of cushion. So that is how we reached that determination and kind of the timeline before which the other credit options would need to arise. And it may not be renewable diesel. There's so many other options that we have, by being conservative, just flat out excluded from our analysis that could also come to pass. But that is, if we were relying exclusively on RD, after 2027 is when we would need either infrastructure or transport to get it to the state. If none of those other options came to pass and there were no other supporting policies and we were just in this like total maximum stress case.
Thank you for that. That's all the questions I have for right now.
Thank you, Madam Chair. On the platform, Member Honker, do you have questions?
No further questions. Thanks.
Thank you. Member Bitzer? No? All right. Is there any reason not to excuse this first NMED panel? Well, thank you, Mr. Coppell, Mr. Ford, Mr. Drews. Thank you very much.
Thank you.
So I understand that we go to Mr. Wade and Mr. Smith now. Is that correct?
Yes, Madam Hearing Officer, that is correct.
All right.
For planning purposes, I wanted to ask whether the board had had a chance to think about if they had wanted Mr. Beck to appear, so that we could make arrangements to have that possible just for board questions or to clean up with an oath for the record. We also thought over the lunch break, perhaps we could just have him submit a attestation under oath in writing for that, but just wanted to get clarification.
All right. And I forgot to ask on the lunch break. So let me ask if there's a board member who would like to speak up now about the video, which I think was Exhibit 141.
I don't feel the need to question Mr. Beck.
I'm good too, but I do have a question. Will it be part of the record? Okay.
All right. Member Honker, do you have a need to hear from Mr. Beck on the video?
No, thanks.
All right. Thank you. I think we have our answer. That's a no from all four. So should we take a break before we go to Mr. Wade and Mr. Smith? All right. Let's take 15 minutes. Come back at 2:27. Okay. All right. David, you okay? Yeah.
Your Honor.
Thank you. All right. We are going to turn to Mr. Wade first, I believe. Yes, Mr. Wade? All right. Can you unmute yourself, please?
Yeah, can you hear me okay?
Oh, yes, very clearly. Thank you. Would you please spell your first and last name for the record?
Sure. Samuel Wade, Samuel Wade.
Do you swear or affirm to tell the truth?
I do.
Thank you. Go ahead and introduce yourself and proceed with your testimony.
Thank you very much. I'd like to work in conjunction with my colleague Yanni here. Yanni has some prepared questions for me. Go ahead, Yanni.
Oh, terrific. Thank you. I'm sorry, Mr. Sorayas. I didn't swing to you.
Not a problem. Thank you, Madam Hearing Officer.
Go ahead.
Mr. Wade, please state your name and current title.
Sure. Samuel Wade. I'm the Vice President for Public Policy with the Coalition for Renewable Natural Gas.
Is RNG Coalition Exhibit 2 a copy of your resume?
It is.
Please describe your academic background for the board.
I have a Bachelor's of Science degree in Mechanical Engineering from the University of California at Davis, a Master's of Science in Mechanical Engineering from the University of Hawaii at Manoa, and a Master's of Public Administration in Environmental Science and Policy from Columbia University.
Thank you. And can you summarize your professional background in clean fuel regulations?
Sure. I've been working in the space for almost 20 years now, including spending 9 years with the California Air Resources Board. For 4 of those years, I served as the chief of the Transportation Fuel Branch, and I oversaw California's Low Carbon Fuel Standard Program. In other capacities at CARB, I served as Deputy Director of Legislative Affairs and also as a staff person worked on their cap and trade program and their first greenhouse gas scoping plan. Since leaving CARB in 2019, I've been with the Coalition for Renewable Natural Gas in various roles. And currently I serve as our Vice President of Public Policy, where I oversee our legislative and regulatory engagement across the country, both the federally and the state level, as well as in Canada.
Thank you. Have you previously provided testimony and technical input to state agencies on clean fuel program design?
I have, yes. I've been involved in all of the various state level programs that have been discussed, California, Oregon, Washington, as well as the Canadian program as well.
Is RNG Coalition Exhibit 1 a copy of your testimony, your rebuttal testimony?
It is.
Did you prepare the rebuttal testimony yourself?
I did.
And is the rebuttal testimony true and accurate to the best of your knowledge and expertise?
Yes.
Great. Can you please summarize for the board the purpose of your rebuttal testimony and summarize your testimony?
Sure. The written rebuttal testimony was in response to testimony filed by the Coalition for Clean and Affordable Energy. The purpose of the testimony is to address incorrect statements made by CCAE regarding avoided methane crediting and book and claim accounting for renewable natural gas.
Thank you. Madam Hearing Officer, I move for RNG Coalition for the admission of RNG Coalition as Exhibit 1 and 2 into the record.
Thank you. I'll pause in the event there are objections. Oh, thank you. They're admitted.
Thank you. I'll get into my rebuttal questions for Mr. Wade. On page 36 of her written testimony, Dr. Laskowski stated that the California LCFS required physical delivery of RNG prior to 2019. Mr. Wade, is that accurate?
No, it is not. As can be seen from CARB's public list of registered pathways.
Hold on. I'm very sorry. Mr. Lee, you have something?
I do. I would like Mr. Saras to slow down and start his question again.
Okay, Mr. Sorayas, if you would, please.
Understood. On page 36 of her written testimony, Dr. Laskowski stated that the California LCFS required physical delivery of RNG prior to 2019. Mr. Wade, is that accurate?
No, it's not accurate. As can be seen from the California Air Resources Board publicly available list of registered pathways, there were landfill RNG pathways registered in the program and serving the program from as far away as New York, Texas, and Ontario, Canada, well prior to 2019. In fact, almost all RNG came from out-of-state supply at the very beginning of the program, simply because there was not yet any RNG built in California. However, due to the success of LCFS incentives for RNG, in-state supply has grown rapidly, and California now has the largest number of RNG projects of any state, with 135 operating projects as of our last survey.
Thank you. And on page 39 of Dr. Laskowski's testimony states that for book and claim pathways, the CI score does not have emissions from transporting it to New Mexico. Would this be correct in the California LCFS?
No, it would not be correct. In fact, the California LCFS CI scoring for RNG pathways does capture distance-dependent emissions associated with energy and gas loss due to transporting RNG to the end use, for example, all the way to California. That fact is very clear from the publicly available RNG pathways posted on CARB's website, and our written testimony cites to one of those examples. Because the carbon intensity of RNG pathways increases as a function of distance from the point of end use, there is an incentive to source from closer projects, all else equal. I believe this is one of the reasons why so many in-state RNG projects have been built in California to serve California fleets.
Thank you. In her testimony, Dr. Laskowski claims that book and claim accounting enables double counting of RNG benefits. To your knowledge, has CARB or even RNG opponents ever identified a single instance of double counting caused by book and claim?
No, not to my knowledge.
Are you aware of any clean fuel program that has successfully promoted RNG use while relying on an accounting system other than book and claim or mass balance?
No, these concepts are really fundamental to the RNG industry and have been used consistently in the US Renewable Fuel Standard and the European, Canadian, and US state clean fuel programs. Fundamentally, RNG suppliers need a method to transact with RNG buyers even after injecting their gas into common carrier pipelines. I believe that the record in this proceeding shows that CCAE has failed to provide any workable alternatives to book and claim and other similar proven accounting systems. Requiring RNG to be co-located or to use separate pipelines, as Dr. Lakowski recommended yesterday, is conceptually as nonsensical as requiring electric vehicles to drive on separate roads in order to receive credit.
Thank you. In her testimony, Dr. Laskowski claimed avoided methane crediting creates incentives for herd expansion at dairies. Do you agree?
No, this issue's been studied carefully, both by the California Air Resources Board and by independent researchers, some of whom, such as Professor Aaron Smith of UC Berkeley, are skeptical of biofuel incentives under the California LCFS. No party has been able to demonstrate any correlation, much less causation, between increased growth rates at dairy farms and the presence of digesters. Dairy farmers look at digesters as simply an emissions control tool to capture existing methane and put it to productive use. They often outsource the construction and operation of digesters to a third party, many of whom are in our membership, and dairies simply do not change the size of their herds based on RNG revenue. They rely on the RNG revenue as a minor side income stream, but obviously their primary income stream is from milk and milk products, and therefore their decisions around herd size are driven by those primary revenue streams.
Thank you, Mr. Wade. On page 49 to 50 in her original testimony, Dr. Laskowski testified that avoided methane crediting, quote, violates the statute's technology neutral mandate and, quote, unfairly advantages methane from animal manure. Based on your experience overseeing the LCFS, how accurate is that statement?
Well, I fundamentally disagree with that statement. Accurately accounting for the methane reductions created by RNG projects is not an unfair advantage for RNG from animal manure. It's simply correctly reflecting the true greenhouse gas benefits of these fuel pathways. Accurately capturing these types of benefits is exactly what a technology neutral program based on life cycle carbon intensity accounting should do. Federal tax credits in the US, the state level clean programs, clean fuel programs, and Canadian and European CI scoring all recognize some form of avoided methane benefits. New Mexico should not make itself an outlier on this topic. And I'm not aware of any clean fuel programs that have successfully promoted growth in renewable natural gas from agricultural manure management or waste diversion RNG without recognizing avoided methane benefits. Eliminating avoided methane credit, as CCAE would recommend, would simply put these types of projects out of reach for the New Mexico program and would remove a tool that could help New Mexico reach its stated goals.
Thank you, Mr. Wade. Yesterday, Dr. Laskowski testified she had some concerns about heating of digesters. Do clean fuel programs based on carbon intensity provide any incentive to heat digesters?
No, in fact, the opposite. Heating a digester with fossil fuel increases the carbon intensity score for an RNG project Therefore, heating of digesters is actually disincentivized by clean fuel programs.
Thank you, Mr. Wade. Madam Hearing Officer, I yield the rest of my time and make the witness available to the other parties.
Thank you very much, Mr. Saras. Mr. Noyes, do you have questions? And welcome to the hearing room.
Thank you, Madam Hearing Officer. Graham Noyes for
I think I've lost the audio.
Thank you, Madam Hearing Officer. Graham Noyes for Verde Clean Fuels. Mr. Wade, were you able to review Dr. Laskowski's testimony in preparation for your testimony?
Yes.
And were you also able to remotely view the testimony of Dr. Laskowski yesterday during a cross-examination that I conducted?
Yes.
And to your recollection, did Dr. Laskowski make representations regarding the crediting of fossil natural gas in the other clean fuel programs?
Yes, I do recall that.
And what representations were those?
Objection, Your Honor, beyond the scope of testimony.
Mr. Noyes, is that? He was testifying quite a bit about Dr. Laskowski's testimony. I mean, Mr. Wade was.
Well, we might need to see where this goes. I anticipate that counsel for Verde might be eliciting a response to topics within Dr. Laskowski's testimony that Mr. Wade did not cover in his rebuttal.
Okay, so just a caution, Mr. Wade, to the extent that you did not form an opinion about some other aspects of the testimony, you can say so. What we're trying to do is explore the testimony you did give. Go ahead, Mr. Noyes.
Thank you. Mr. Wade, when you administered or were supervising the California Low Carbon Fuel Standard, was there any credit generation from fossil natural gas?
Yes, there was.
And what was the process for generating credits for fossil natural gas?
Same objection.
For other fuels, yeah.
Ms. Gerson, again, Mr. Wade, I think, understands my instruction to him. To the extent he has an answer, he should offer it. And where he did not testify about it or does not have an opinion about it, I think he understands he can say that. Go ahead, Mr. Noyes.
I'm sorry, Mr. Wade, were you able to answer?
Yes, there was crediting to fossil
Didn't
natural
get an
gas
answer.
use prior to renewable natural gas becoming a more important fuel in the California LCFS. So yes, there was crediting to fossil gas in the California system initially.
And why did the crediting of fossil natural gas cease in the California LCFS?
As the carbon intensity curve grew more and more stringent, the renewable natural gas replaced fossil gas over time, with first landfill primarily coming in and displacing fossil gas, and then eventually primarily dairy and swine manure coming in as even lower carbon intensity gas.
And was there at that point or any point later in the California LCFS prohibition on the crediting for fossil natural gas to the extent it was lower than the carbon intensity standard?
No, there's no prohibition on crediting to fossil fuels, is my understanding.
No further questions, Madam Hearing Officer.
Thank you very much, Mr. Noyes. Do we have Mr. Nasco? Mr. Duff, Mr. Smith, Mr. DeSalen, or Ms. Gerson. No, very sorry, Mr. DeSalen.
No questions, Madam President. Thank you.
Thank you. Mr. Lobdell, Ms. Veracruz. I don't think we have Ms. Tremblay. Mr. Maxwell.
No questions. Thanks.
Thank you. Mr. Weatherby. Mr. Harris. He said no. Mr. Tucker. He said no. Ms. Olson. She said no. Mr. Molenberg. Or
No questions.
no questions. Ms. Sona.
Anna first, no questions.
Thank you for that. Let me turn to the Mr. Sorais. Do you have any redirect based on Mr. Noy's examination before I turn to the board?
As I've seen in previous rebuttal and redirect, I'd like to give Mr. Wade the opportunity if he has any final thoughts regarding Mr. Noyes' questions.
Thank you. Go ahead.
Yeah, sure. Just fundamentally that a fuel neutral program in our minds does mean crediting all low carbon fuels appropriately based on their actual carbon intensity. And we hold that avoided methane crediting for renewable natural gas is a critical tool, but the other opportunities for reducing methane should also be explored.
Great. Thank you very much. Member Garcia, do you have questions?
No questions. Thank you.
Thank you. Member Ely?
Just one. So I noticed in your rebuttal testimony, you mentioned the department's proposed limitation of a 20-year avoided methane crediting period. Why the phase down? What's the purpose of that?
Yeah, I would say that that does create problems for RNG projects. The shorter the avoided methane crediting period, the more difficult it is to finance these projects. So we would prefer to see a 30-year period, as California previously had in place. A 20-year just makes the whole project more expensive. I believe the only appropriate reason to phase out avoided methane crediting is if a mandate is put in place requiring control of those emissions. And so unless there is an expectation that New Mexico will mandate methane controls at all dairies or for all landfills and tell them to stop accepting organic waste, an arbitrary phase out is not helpful, especially one as quickly as 20 years.
Thank you.
Madam Chair.
No questions.
Member Honker? Do we have Member Bitzer? No. Okay. Thank you. Is there any reason not to excuse Mr. Wade? Thank you very much, Mr. Wade, for your testimony.
Thank you.
All right, I think we turn now to Mr. Smith from Rio Valley Biofuels. Mr. Smith, are you on the platform? All right, we'll give him a minute.
Hello, I'm here.
Oh, hello. Would you spell your first and last name, please?
First name J-E-D, Jed, and last name is S-M-I-T-H, Smith.
Thank you. And do you swear or affirm to tell the truth?
I do.
Thank you. Please go ahead.
Good afternoon, members of the board. My name is Jed Smith. I am the CEO of Real Valley Biofuels, a biodiesel producer and distributor that has been operating since 2006. I appreciate the opportunity to offer this rebuttal testimony on behalf of our company. We've been deeply engaged throughout this rulemaking process because we believe the Clean Transportation Fuel Program can be a powerful tool for reducing carbon intensity in New Mexico. If it is built on sound, current, and practical foundations. Today, I will focus on three key areas that we believe need attention. First, the indirect land use change or ILUC requirements. Second, the annual program fees. And thirdly, the authority to defer, specifically the forecast deferral section. If you may, I will start with indirect land use change. Let me begin with ILUC. Our position is simple. These requirements should be removed from the proposal rule. The ILUC values currently referenced in Table 9 are based on modeling that is more than a decade old. Models originally used by the California Air Resource Board. Since then, significant improvements have been made to these models, and in some cases, like the federal 45Z Clean Fuel Credit Program, ILUC penalties have been completely eliminated. Starting New Mexico's program with outdated ILUC values would mean that for at least the first 3 years, the program would operate under assumptions that no longer reflect real-world conditions. Then in 2029, during the program's first scheduled review, the department would almost certainly have to revisit these models, possibly updating or removing them. That means 3 years of lost opportunity, 3 years in which biofuels that should be incentivized are instead penalized by old science. New Mexico has set ambitious reduction targets, 20% by 2030 and 30% by 2040. To reach those goals, the state needs all available low-carbon fuels participating. Keeping ILUC penalties in place will reduce the number of credit-generating fuels brought into New Mexico and will discourage investment at the very moment this program needs momentum. We're not alone in this view. To our knowledge, no stakeholders has voiced opposition to removing ILUC language. And practically speaking, it's not a heavy lift. There are only about 8 ILUC references throughout the rule. Removing them now would strengthen the program and ensure its early success. For that reason, Real Valley Biofuels strongly recommends eliminating all ILUC provisions from the proposed regulation and allowing the department to revisit the issue later if new evidence supports it. Okay, the second, annual program fees. Do I need to take questions on that first one, or should I just go and finish my rebuttal and then we'll go back?
Yes, please go ahead.
Okay. The second one is the annual program fees. We do appreciate that the department has already equalized the registration fees for both credit and deficit generators. That was a positive step. However, the annual fee structure remains a serious concern. From a practical standpoint, these fees are administratively heavy and unnecessarily complex. Managing them will require the department to build an annual budget, announce a fee schedule, collect payments, handle protests, and track compliance, all of which adds layers of work that inflate the program's administrative costs. Ultimately, this means that the fees themselves will need to be higher just to cover the cost of managing the fees. From the industry's perspective, the biggest issue is uncertainty. As written, the rule allows the department to announce the annual fees as late as May 1st of each year. By that point, companies like ours will have already been operating for 4 months, generating credits and deficits without knowing what the financial obligation will be. That's not a practical or predictable business environment. Our recommendation is twofold. Ideally, we urge the removal of the annual program fees entirely to streamline administration and make the program more inviting to participants. If the board decides to retain them, then we strongly recommend removing the budget and fee announcement date to December 1st of the prior year. This would allow regulated parties to make informed data-driven decisions before each compliance year begins. Number 3, authority to defer. We appreciate that departments now specify that any transportation fuel supply. Hold on a second. We appreciate that the department now specifies that any transportation fuel supply forecast must be prepared impartially. That's important. However, we are concerned that future administrations could use this provision to pause or stall the entire program, perhaps citing market conditions rather than supply constraints. To avoid that risk, the rule should include explicit language saying that neither fuel prices nor CTFP credit prices may be considered when determining whether the forecast deferral is necessary. This would protect the program from being undermined by short-term market fluctuations. Additionally, the data used to prepare the forecast must be accurate and comprehensive. We recommend requiring the analysis use national level data source such as reports from the U.S. Energy Information Administration to evaluate credit generating fuel availability. If the review relies only on local or regional data, it will overlook the large volumes of biofuel that are already passed through New Mexico en route to West Coast markets. Those fuels are physically here and could easily be used within New Mexico's program. The fact must be reflective in the forecasting process. In closing, Real Valley Biofuels supports the creation of a strong, effective, clean transportation fuel program for New Mexico. We believe that with a few targeted changes, removing outdated ILEC penalties, simplifying or eliminating annual fees, and tightening the deferral safeguards, this program can launch efficiently and deliver meaningful results. We are committed to collaborating with the department and other stakeholders to help make that happen. Thank you for your time and considering our rebuttal testimony.
Thank you very much, Mr. Smith. We'll turn to questions. Mr. Noyes, do you have questions of Mr. Smith? He said no. Mr. Nasco? Mr. Duff? Mr. DeSalen?
No questions.
He said no. Mr. Lobdell? Mr. Sorayas? Ms. Veracruz? Ms. Tremblay? Mr. Maxwell?
No questions.
Thank you. Mr. Weatherby?
No questions.
Thank you. Mr. Harris?
No questions.
He said no. Mr. Tucker? He said no. Ms. Olson? She said no. Mr. Molenberg? No questions. And Ms. Sona?
And maybe a shocking second, no questions.
All right, thank you. Board members, Member Garcia, do you have questions of Mr. Smith?
No questions, thank you.
Member Ely?
No questions.
Madam Chair?
No questions.
Member Honker on the platform? Okay. Thank you very much, Mr. Smith, for your testimony. We'll excuse you.
Thank you for your time.
I understand we're turning then to the second department panel because Infinium's Dr. Zaziski was withdrawn.
Yes, Madam Hearing Officer.
Terrific.
May I ask one for a brief break to get us set up for that panel? And then also, could I request that Ms. Jones send an email to all the parties connecting them with our court reporter to ensure that if they read anything, that they share that written with statement with him so he can ensure timely completion and accurate completion of a transcript?
All right. Thank you, Ms. Sona and Ms. Jones. Is 5 minutes okay? 10 minutes? What do you want? All right. So let's just take 5 minutes. Okay, thank you. Let's come back from the break, please. We are going to hear from our last set of witnesses. This is the second department panel. I believe all of you testified before. All of you have been sworn in. I think it might be helpful to have you, when you introduce yourself, spell your name. All right, go ahead, Ms. Sona. Oh, sorry.
Ms. Gerson.
Oh, I forgot, Ms. Gerson, you had something you wanted to do.
Thank you, Madam Hearing Officer. Yes, I would like to make a motion on behalf of CCAE to admit what's been marked as CCAE Exhibit 21. I circulated that to the parties, Ms. Jones and the hearing officer. It is a PDF of the graph that Mr. Noyes and Dr. Laskowski discussed on cross-examination, and I just wanted that to be an exhibit for completeness of the record.
All right, I'll pause for the moment in the event there are objections. I see Mr. Noyes approaching the podium.
Actually, Madam Hearing Officer, I just wanted to confirm I had the opportunity to review that exhibit and agree that was the correct reference point.
Great, thank you very much, Mr. Noyes. I don't hear any objections, so thank you, Ms. Gerson. We'll admit that exhibit.
Thank you. And I also wanted to say, for the sake of full transparency, because there was some discussion about what had been marked as CCAE Exhibit 19 and circulated, that was a cross exhibit for Mr. Zinski, who had submitted pre-filed rebuttal testimony on behalf of Infinium, but since that testimony has been withdrawn, that is the end of the story with that potential cross-exhibit.
All right, thank you very much. I'll set it aside.
Okay, thank you very much.
Thank you. Ms. Sona.
Thank you, Madam Hearing Officer. We're going to begin this panel with Dr. Rasso, and then we will go to Mr. Vaughn, and we will conclude with Bureau Chief Borchert. And also, just as a reminder to folks, Dr. Rasso is going to spend 5 minutes at the end of her 15 minutes just to briefly respond. She's going to indicate when she makes that transition.
Thank you very much.
Okay. Dr. Rasso, can you please state and spell your name for the record?
My name is Angela Rasso, ANGELA RASO.
Did you previously testify in this proceeding on September 22nd through September 24th, 2025?
I did.
I'd like the record to reflect that Dr. Rasso's qualifications to testify were previously established on the record, and Exhibits 67 to 72 with her direct testimony, resume, and supporting exhibits were admitted. Dr. Rasso, is NMAD Exhibit 128 a written narrative of your rebuttal testimony?
It is.
Do you adopt NMAD Exhibit 128 under oath as your testimony?
I do.
Have you prepared a summary of that?
Yes, I have.
Okay, please go ahead and remember to speak slowly.
I will endeavor to speak slowly. Good afternoon, Chair Sweeney and members of the board. Today in my oral summary, I'm going to cover multiple topics, so I apologize if it feels a bit like I'm jumping around. The first topic I'm going to talk about briefly is energy economy ratios. NMED strongly opposes removal of EERs from the New Mexico CTFP. If the board decides to not include EERs in the CTFP, it would make the New Mexico program an outlier compared to all of the other state programs. All of the other programs include New Mexico's proposal and use EERs as technology-neutral mechanisms to account for the efficiency of actually using the fuel for transportation and acknowledge that some fuels are inherently more efficient at being used for transportation. Moreover, the enabling statute requires accounting for all fuel life cycle emissions through final use by the consumer, not just energy delivered to the vehicle. Without EERs, life cycle accounting would stop at energy delivery and ignore how much driving that energy enables, directly contradicting statutory requirements. Next, I would like to address avoided emissions and carbon intensities used in the program. NMED recognizes concerns about avoided emissions accounting, but does not support removing avoided emissions entirely from the CTFP. Instead, NMED has added strong guardrails in the draft of our rebuttal revised proposed new rule to ensure avoided emissions crediting is limited and appropriate. These guardrails are designed to prevent unintended consequences. The guardrails also align New Mexico's CTFP more closely with restrictions on avoided methane in other states, including California and Washington. The guardrails added by NMED are as follows. First, only methane will be counted as avoided emissions. Second, that the emission reductions are additional. This includes demonstrating that the methane would have been emitted under business as usual conditions. The feedstock is a byproduct of another process. The avoided methane is based on actual facility emissions, excluding any gaming of the system, and that the reductions are additional to all regulations and to common practice. Third, we have added crediting period limits. Fourth, loss of eligibility if regulatory additionality changes. Fifth, NMED may suspend avoided emissions carbon intensities for violations of other environmental regulations. NMED believes this approach responsibly preserves climate benefits while limiting potential for unintended consequences. NMED has also heard petroleum industry proposals to allow the fossil fuels listed in Section 201A to apply for and obtain alternative fuel pathways. This would go beyond allowing certain technologies to qualify for project credits and allow gasoline and diesel to qualify as clean or alternative fuels. NMED has agreed with industry to allow for project credits from nearly the beginning of the program, but strongly opposes allowing them to be clean fuels in the Clean Fuels program. Oxy's redline change of shall to may in Section 201A of the rule would allow all petroleum operators to apply for alternative fuel pathways. Oxy's redline changes to 205A2 do not limit this to just innovative crude production methods, because the list in 205A2 begins with shall include. In other words, it is not an exhaustive list, and fuels other than those listed may be considered for alternative fuel pathways. This change would allow, for the first time in any regulatory program in any jurisdiction, conventional gasoline and diesel to qualify as clean fuels. This not only would make New Mexico an outlier compared to other clean fuel programs. In fact, other clean fuel programs have expressly stated their concern to NMED staff over the impacts of the board approving Oxy's proposal. No other state allows fossil fuels to apply for or obtain alternative fuel pathways. This includes California, where innovative crude pathways are a type of project credit with different requirements and credit calculations from fuel credits and alternative fuel pathways. Using fossil fuel pathways and liquid book and claim, it could be possible for a petroleum supplier to demonstrate compliance with CTFP without changing New Mexico's fuel mix or changing fossil fuel production or refining practices beyond what is already required by stringent New Mexico state regulations on the oil and gas industry. I'm going to jump a bit now to NMED's flexibility in administering the rule, flexibilities the department has added for the initial compliance period, and implementation preparedness. In the first 2 weeks of this hearing, we heard about how this type of program is not set and forget. While this is true, NMED has taken care throughout our proposed rules to strike a balance of integrity and flexibility. Areas of the rule that will help us avoid an onerous number of rulemakings include department authority to approve new temporary fuel pathways, approve new EERs, update electric distribution utility carbon intensities annually, update the Tier 1 and Tier 2 calculators as needed, produce guidance for project credits, and base fees on an annually updated budget. NMED recognizes industry concerns about program startup and tight timelines. NMED opposes the overly long program delays proposed by the petroleum industry. In NMED's rebuttal revised proposed new rule, we have added flexibility to the initial compliance period by shifting the effective date of the rules from February 1st to April 1st, extending the initial compliance period from 11 months to 21 months, adjusting when temporary fuel pathways may be used, and allowing parties with approved pathways in other states to use those certified carbon intensities as temporary fuel pathways in New Mexico's CTFP. NMED is and has been actively preparing to implement this program in conjunction with preparing draft rules and testimony for this hearing. To clarify the timeline of the department's proposal, I have prepared a spreadsheet entered as NMED Exhibit 130. This timeline exhibit shows that the department's proposal will allow for a smooth and incremental rollout of the requirements over the initial compliance period. The timeline also lays out the IT deliverables for the data management system and shows the timing between the deliverable dates and the go live dates required by NMED's proposed rule. Critically, the participant and FSE registration modules are going to be delivered by the contractor by the end of November, leaving plenty of time for testing, bug fixes, and staff training. Another area where I have spent a significant amount of my time preparing for implementing this program is hiring necessary staff. I have included the Climate Change Bureau organization chart as NMED Exhibit 131. I have also included 8 job listings for CTFP dedicated positions as NMED Exhibit 132. I anticipate that we will have these new staff on board and training by January to join other existing staff and already onboarding contractors in implementation. Next, I am going to address the American Petroleum Institute and New Mexico Oil and Gas Association's proposed framework for fuel pathway modeling in CTFP. Previous testimony has focused on how unmodified R&D GREET is not an appropriate model for this regulation. But I would like to make clear that NMED opposes the American Petroleum Institute and New Mexico Oil and Gas Association's framework as a whole, not just the use of unmodified R&D GREET. The proposal is unclear and inconsistent with other state clean fuel programs, but most importantly, it lacks sufficient regulatory oversight. Carbon intensity values are the backbone of the CTFP, and the petroleum industry proposal removes critical regulatory oversight by NMED. This could lead to inconsistent and unreliable carbon intensity values, influenced more by the choice of consultant than actual fuel inputs. Third-party verification alone is not sufficient. Removal of NMED's regulatory review authority has the potential to create a wild west of life cycle analysis modeling. Finally, with respect to rule changes proposed by other parties, including those from the American Petroleum Institute and New Mexico Oil and Gas Association that I address in my written testimony, I caution the board to be careful. Most of the parties in this rulemaking represent a particular type of fuels and often don't fully grasp how these rules apply to other fuel types. This leads to unintended consequences, like the petroleum industry, who represent liquid fuel producers, deleting sections of the rule that allow electricity as a transportation fuel to be appropriately reported in the program. I've included in my written testimony a list of changes that we would urge the board not to adopt. But my list is far from inclusive of all the proposed changes that would have adverse or unintended consequences. Now I'm going to talk specifically about CCAE's rebuttal testimony and concerns that avoided methane without restricting the methane source in conjunction with the definition of synthetic fuels combine to allow untold credit generation for fossil fuels. This is simply not true. Fossil methane will not be eligible to be credited as avoided methane under this program because of synergy between the department's proposal and New Mexico's strong upstream oil and gas regulations. 20.2.92, section 201E1F of the department's rebuttal revised proposed new rule requires that there be regulatory additionality. This means that any methane counted as avoided emissions must be collected voluntarily rather than because of a regulation. We have specified that for methane emissions to count as avoided, the capture must go above and beyond the most stringent requirements of federal laws, local laws, or New Mexico laws. This means that even for activities occurring outside of New Mexico, we will not count the emissions as avoided if they would have been required to install controls if operating in New Mexico. 19.15.27 NMAC and 19.15.28 NMAC, collectively the methane waste rule administered by the New Mexico Energy, Minerals, and Natural Resources Department Oil Conservation Division, and 20.2.50 NMAC, the Oil and Gas Sector Ozone Precursor Rule, passed by this board and administered by NMED's Air Quality Bureau, together make up some of the most stringent upstream and midstream oil and gas emission regulations in the country. MNRD, spelled EMNRD, methane waste rule works in two ways. First, it prohibits venting or flaring of natural gas during drilling, completion, production operations, or from a natural gas gathering system that constitutes waste, except in very specific circumstances. Second, it requires that upstream and midstream operators reduce the annual volume of vented and flared natural gas in order to capture no less than 98% of the natural gas produced by December 31st, 2026. The ozone precursor rule complements the methane waste rule. While this rule regulates air pollutants like nitrogen oxides, non-methane, non-ethane hydrocarbons, and volatile organic compounds, it has a strong co-benefit of further reducing methane emissions from the oil and gas industry by enumerating specific control requirements for 14 emission sources and activities, many of which cover the circumstances in which the methane waste rule does not prohibit venting or flaring. New Mexico's strong oil and gas regulations, with the regulatory additionality required by the department's revised rebuttal new rule, collectively make claiming avoided methane emissions from the oil and gas industry as a part of an alternative fuel pathway infeasible. I also do not agree that allowing synthetic fuels with fossil feedstocks to apply for or obtain Tier 2 alternative fuel pathways without avoided methane crediting is the same as allowing fuel pathways for the conventional fossil fuels listed in Section 201A of the department's proposal. Thank you.
Thank you, Dr. Russo. Do you mind flipping in your notes to the first sentence of where you turned to your SIR rebuttal regarding Dr. Laskowski's testimony and just noting that for the record so we can identify the transition?
The first sentence was, now I'm going to talk specifically about CCAE's SIR rebuttal testimony and concerns that avoided methane. Do you need me to continue? Okay.
That's good. Thank you. I just wanted to make that clear for everybody. Madam Hearing Officer, I would now like to move for admission of NMED Exhibit 1. Did I already do that? No. Okay. It's been a long week. I'd like to move for admission of NMED Exhibit 128, Dr. Rasso's rebuttal testimony, and the supporting NMED Exhibits 129 to 132.
Let me pause for a moment in the event there are objections. Okay, they're admitted. Thank you.
Thank you. I'd now like to move to Mr. Vaughn. Can you please state and spell your name for the record?
Hello, my name is Colt Vaughn, Koltvaugghn.
Mr. Vaughn, did you previously testify in this proceeding on September 22nd through September 24th, 2025?
I did.
I'd like the record to reflect that Mr. Vaughn's qualifications to testify were previously established on the record, and Exhibits 34 to 62 with his direct testimony, resume, and supporting exhibits were admitted. Mr. Vaughn, is NMED Exhibit 119 a written narrative of your rebuttal testimony?
It is.
Do you have any clarifications that you would like to make regarding that testimony before you begin?
Yes, my apologies to the board, but I do have a minor citation error to correct. On page 6 in the NMED Notice of Intent to Present Technical Testimony for Rebuttal, and throughout my written rebuttal testimony, I accidentally swapped all of the references between NMED Exhibits 120 and 121. This issue is particularly pervasive in section 1 of my rebuttal testimony. Just really in short, if you swap the 120 for 121, that will solve half the problem, and solving the other half of the problem is 121 should be corrected to 120. Exhibit 120 is in fact the discussion rule, and 121 is in fact the email communications surrounding the discussion session.
Just a reminder to go slow. Thank you.
Yes. And Mr. Vaughn, we received a question prior to proceeding into testimony from Mr. Maxwell seeking some clarification on a list that included his name. Just to briefly address that now, can you clarify what that is intended to mean?
Yeah, absolutely. In section 3 of my rebuttal testimony, starting on page 3, the parties that are listed there, those are in fact what I refer to as the hearing parties. And that is distinctly different from how I refer to the discussion parties. Discussion parties in that list are noted with an asterisk. So if there's not an asterisk, that is to say that they did not participate in our discussion sessions.
Thank you very much, Mr. Vaughn. If you could please proceed with slowly reading your oral summary.
I will try, thank you. Chair Sweeney and members of the board, thank you for allowing me to be here today. My name is Colt Heston Vaughn, and I am the Rulemaking and Strategic Initiative Specialist for the Climate Change Bureau. I present this rebuttal testimony on behalf of the New Mexico Environment Department regarding the proposed rule for the Clean Transportation Fuel Program, or CTFP. My direct testimony at the outset of this hearing demonstrated the extensive and robust engagement NMED staff undertook for this rulemaking. Almost no party has meaningfully contested that the department met and exceeded all legal notice requirements and went above and beyond the typical process for extensive public engagement opportunities. Notably, the department's rebuttal rule is grounded in public and interested party feedback. And this engagement did not stop once the hearing began. Now, my rebuttal testimony provides the board with facts regarding recent discussion sessions and offers counter arguments to a few contested issues that are raised by other parties. In October 2025, NMED organized 8 hours of discussion sessions over 2 days with 15 hearing parties to seek alignment on contested issues. These discussion sessions successfully created a space for open problem solving, which is distinct from the formal testimony or advocacy that we see in this hearing. And it allowed participants to speak freely about technical challenges, implementation concerns, and opportunities for improving the proposed rule. Importantly, I will respect the confidentiality rules that prevent me from attributing specific statements to specific discussion parties, but I will also report the aggregate outcomes here. The confidentiality safeguards were instrumental for fostering honest, forthright discussion that is not possible in a purely adversarial or public setting. We made substantial progress on 9 key topics, which informed our rebuttal revised proposed new rule in NMED Exhibit 112. Notably, that most recent version of the rule may ultimately be different from prior draft rules, especially the one that was presented in the discussion session. So next, I will highlight 5 topics here. For the program timeline, we shifted the implementation date from February 1st, 2026 to April 1, 2026. We've also extended the initial compliance period to 7 quarters, ending December 31st, 2027, to give all parties, NMED, regulated entities, and the credit market more time to prepare for everything from registration to price discovery. NMED did not change compliance requirements during the extended period, and regulated parties will generate both credits and deficits at the program's inception. Generally, parties have been understanding and supportive of the compliance period extension, but parties advocating for longer delays or deficit generating compliance have not eased their demands. As for project crediting, the department's discussion rule provided a more detailed process, including defining the term project credit, listing eligible project types, and adding specific process requirements for eligibility and application review. The department also added provisions regarding directions for project crediting protocols that will contain additional processes and details. Discussion parties generally supported the greater certainty that the additional regulatory language provides around project crediting. Then, for booking claim, NMAD proposed to remove the eligibility for liquid fuels to use booking claim accounting. This ensures the associated air quality benefits remain within New Mexico and aligns New Mexico with other successful clean fuel jurisdictions that do not permit liquid booking claim, which is complex. The discussion on this topic was meaningful. While parties continue to advocate their unique interests and concerns about booking claim provisions, NMAD believes it has crafted a balanced rule with safeguards appropriate to New Mexico. Next, for periodic review, NMAD's discussion rule proposed strengthening the provisions of the department's periodic review, changing a pivotal word from may to shall for evaluating specific program elements. Additionally, the department proposed language to mandate that the advisory committee convene at least once every 3 years, while adding requirements for diverse representation. In response to concerns raised about political manipulation, NMAD has also added the requirement for the advisory committee to convene if 2 consecutive deferrals are issued. Discussion parties generally supported NMAD's direction here. Finally, regarding registration fees, we proposed to standardize the annual registration fee at $3,000 for all credit and deficit generators. This lowers the cost for deficit generators and slightly increases it for credit generators, aligning the fee with the administrative work required for both. Of all the topics, this proposed change reached the most alignment among the discussion parties. To wrap up this portion of my testimony, there are 4 more topics we addressed at the discussion session, so I simply ask the board to review my written testimony for more information in detail. Moving on, now I must address several inaccurate claims made regarding the inaugural CTFP Advisory Committee. First, the New Mexico Oil and Gas Association and American Petroleum Institute have complained that the sole in-state refiner of petroleum fuel was excluded from the inaugural advisory committee. Yet the Secretary, in accordance with the statutory directive, appointed 5 self-identified in-state producers of transportation fuel. Accordingly, the NMOGA and API claim that the Secretary left out the state's only fuel refiner is misleading. Second, consensus was not the goal of the advisory committee, nor is it what the legislature required from the committee. The members did not reach a consensus on anything, nor was that the expectation. The purpose was to solicit input from 31 diverse stakeholders and to provide a roadmap and a technical report to streamline the rulemaking process, a purpose the committee successfully achieved and one that NMOGA and API has agreed with in oral testimony. Finally, on this matter, as it states itself, the technical report is clearly a compilation of statements and perspectives, not a consensus document. Third, and most importantly, in my opinion, the advisory committee was not required to review the proposed rule as a prerequisite for this hearing. As a rulemaking specialist, it is my job to understand that a rule and a proposed rule are legally distinct terms. Nothing in the Environmental Improvement Act mandates advisory committee review of a proposed rule. My written rebuttal testimony also highlights key problems with the proposals for amending the deferral process. The key points of NMED's positions here are: first, NMED's proposal ensures that a fuel forecast is produced by a neutral third party, and additional language was added to the rule to enhance these protections. NMED disagrees that a neutral third party to produce that fuel forecast cannot be another New Mexico government agency. In fact, the New Mexico Department of Transportation is well positioned to supply independent, unbiased, data-driven analyses for the forecast deferral process. Second, an automatic deferral mechanism that would trigger a suspension of deficit generation is inappropriate for the New Mexico CTFP. NMED opposes an automatic approach because no other jurisdiction uses an automatic deferral mechanism, including British Columbia, which Dr. Rinsing formerly oversaw. Also, experience indicates it is not necessary. No other state program has historically observed deficits exceeding generated credits by 50%, which is the benchmark suggested to activate such a mechanism. Finally, if such an auto deferral mechanism were in place, NMED is concerned that a small group of regulated parties could conceivably trigger an automatic deferral mechanism early in a compliance period by intentionally front-loading a supply of deficit-generating fuel transactions. This would relinquish department discretion to an exploitable math equation under their proposed framework. Instead, NMED has strengthened the rule's emergency deferral language to ensure the department can respond quickly to real market conditions. In conclusion, the evidence in my direct and rebuttal testimony, combined with the evidence from other NMED witnesses, demonstrates that the department has diligently addressed feedback and statutory requirements. As you all have observed, from day one and throughout this process, NMED continues carefully weighing requests from parties, but the department only accepts those suggestions it finds consistent with statutory goals, modeling, or experience from other jurisdictions. NMED's revisions have been responsive to competing and often mutually exclusive requests. We have made responsible revisions where feasible, and we have defended our position where necessary to ensure the cohesion, functionality, and success of New Mexico's CTFP. Again, I sincerely appreciate each board member's commitment to these matters, including the significant amount of time that each of you volunteered to protect New Mexicans' environmental and public health. I respectfully request that the EIB adopt the rebuttal revised proposed new rule. Thank you.
Thank you, Mr. Vaughn. We did skip one question in my introduction with you. Can you please let me know, do you adopt NMED Exhibit 119 under oath as your testimony?
I do, with the two corrections that we noted right at the top of that discussion.
Thank you. Madam Hearing Officer, I would now like to move for admission of NMED Exhibit 119, Mr. Vaughn's rebuttal testimony, and the supporting NMED Exhibits 120 through 123.
Thank you. I'll pause for a moment in the event there are objections. Thank you. They're admitted.
All right. NMED will now turn to its final witness. Bureau Chief Borchert, could you please state and spell your name for the record?
Claudia Borchert, Claudia Borchert.
And Bureau Chief Borchert, did you previously testify in this proceeding on September 22nd through 24th, 2025?
Yes.
I'd like the record to reflect that Bureau Chief Borchert's qualifications to testify were previously established on the record and Exhibits 63 to 66 with her direct testimony, resume, and supporting exhibits were admitted. Bureau Chief Borchert, is NMED Exhibit 124 a written narrative of your rebuttal testimony?
Yes.
Do you have any corrections that you need to make to that testimony?
No.
Do you adopt NMED Exhibit 124 under oath as your testimony?
Yes.
And have you prepared a summary and presentation for us?
Yes.
Okay. If you could please queue up your presentation and provide your summary. Screen. And then click it. And you can oh. Oh. Ms. Jones, is this panelist able to share, is the witness table able to share the screen?
Yes.
Strange. It shows she's sharing it, but not up there.
You're signing into the meeting, right?
Mm-hmm.
Is this the witness table computer or is it Miss Borchert's?
It's the witness table computer.
Gesundheit.
Connected
to the internet?
No.
Yeah, must have timed out.
No. The best of intentions.
Just let us share screen.
I was trying that link that far without being connected to the internet.
I know. Let us
Should-
click the entire thing.
Borchert. Pam, maybe, should Pam share it from the docketed?
We got it.
Oh, okay.
We just had to reconnect to the internet. Okay. Please go ahead when you're ready.
Okay. All right. I want to speak to you, Chair Sweeney, and members of the board on the strength of NMED rebuttal rule NMED Exhibit 113 and why NMED encourages you to adopt the rule provided by NMED as presented. The potency of the rebuttal rule lies in large part in how Team CTFP developed the rule. The compromise-focused settlement discussions that Mr. Vaughn described earlier and the impressive public engagement statistics in his direct testimony are just two elements that underlie the Team CTFP rule development process, which I want to highlight. For each policy, concept, or design element brought to the team since early summer last year, Team CTFP has asked probing questions on the merit and the implication, considered the pros and cons, challenged each other's assumptions, read the regulations and other programs, researched methodologies and scientific bases, considered economic implications, questioned how to embed the idea into the existing rule framework, deployed appropriate models, focused on benefits to New Mexicans, and sought counsel from regulators, subject matter experts in life cycle emissions, air pollution, transportation, academia, and legal counsel. As scientists and economists, the team is trained to identify the problems, analyze them, and find solutions. Team CTFP did not include dozens of suggestions into Part 92 because our team collectively, collaboratively, and grounded through detailed policy and scientific review decided against inclusion. This includes many proposals that have resurfaced during direct or rebuttal hearing. The basis for NMED's decisions are documented throughout the rulemaking record based on feasibility, implementability, rationality, and appropriateness. Documented are the red lines Team CTFP presents the changes in the rebuttal rule in NMED Exhibit 113. The changes are presented in the interest of providing additional clarity and expressing Team CTFP's willingness to reach compromise with parties in the hearing. The rebuttal rule includes these changes: allowing for stacking financial benefits earned in CTFP with other programs, such as the Federal Renewable Fuel Program and federal tax credits, tightening the conditions when avoided methane can be included into a CI calculation, no longer allowing liquid fuel to be eligible for book and claim accounting, describing the project crediting requirements in greater detail, equalizing registration fees for all parties, increasing annual fees for non-credit and deficit generating parties from $200 to $2,000, streamlining enforcement provisions, adding a provision for a regulatory party to appeal a decision, and updating the 2018 baseline and the ensuing CI standards in Table 1, 2, and Table 4 with the standard NMED GREET modeling assumptions and methodology. 4 additional changes in the rebuttal rule merit more discussion. On the program implementation timeline, as you've heard from Mr. Vaughn and Dr. Rosso, as a compromise to the initial timeline concerns raised by the petroleum industry parties, NMED is proposing 2 changes to the program timeline. First, that the program start date and the effective date be delayed to April 1, 2026. And second, that the first compliance period end December 31, 2027, incorporating the preceding 7 calendar quarters. The extended compliance period gives all CTF participants, NMED included, more time. I might note, I hope that means my team can get more sleep and actually only work 40 hours a week. Now the obligated parties will accrue credits and deficits during 7 reporting periods and have 21 months to transact exchanges in the credit market before deficit generating parties demonstrate compliance. This is analogous to the startup period in Washington, where quarter after quarter, parties generated almost 2 times more credits than deficits, as illustrated in my first demonstrative in the graph, which was produced by the Clean Fuel Program of Washington's Department of Ecology. Washington's program had a combined CI reduction for the first 2 years of 1.5%, which is comparable to CTFP's requirement of about 4% through the end of year 2. Note the buildup of the credits in the bank by July 2025, shown by the green line. It's kind of hard to see, but you can see it there, I believe. Similar to the testimony you've heard in this hearing, during the development of Washington's program in 2022, the petroleum industry catastrophized the inadequacy of clean fuel delivery infrastructure and predicted credit shortages. It's Groundhog Day for us as part of the low carbon fuel program rulemaker community, where the same asks and opinions put before and rejected by the rulemakers in other states are being asked of us. In response to listening to the direct testimony, the CTFP added other provisions to the rule rebuttal that complement the extended compliance period and makes it easier for clean fuel providers to participate in and generate credits during the first compliance period. Dr. Rosso spoke to this, but I also want to note this was also a suggestion we heard from other regulators from Washington and California and actually Oregon, recommending we do this here in New Mexico. The program will now accept carbon intensity values from approved alternative pathways in other states. That's for the first compliance period. Also, the program will accept the use of the temporary table in the CIs from the temporary table during the program's review of an alternative fuel pathway application. Previously, it was time limited. The program has also added the CI to Table 5 that was requested by the sorghum-based ethanol producers of 65 grams of CO2e per megajoule. On the concern that NMED is moving too fast, too quickly, the petroleum industries raised concern that New Mexico's program's timeline and associated CI reductions are too ambitious. This graph shows New Mexico's CI reductions in context with the CI reductions in low carbon fuel programs in all the other North American jurisdictions. I want to acknowledge Dr. Rensing's previous employer, the British Columbia's Ministry of Energy and Climate Solutions, specifically Sean Leroy, for this demonstrative. In this graph, the more the curve is to the left or the bottom, the stricter the carbon intensity. You can see California's carbon intensity reaching 90% by 2045 on the bottom. The graph clearly illustrates that regardless of the testimony presented, New Mexico's CI reduction targets, most top and right, is the least stringent of all the low carbon fuel programs shown. Another topic I want to cover is the alternative jet fuel change that we made to the rule. In recognition that the state of New Mexico does not have the authority to regulate interstate aviation fuel, in the rebuttal rule, Team CTFP no longer applies the carbon intensity reduction mandate to conventional fuel in Table 3. Table 3 now includes a single CI value as the conventional jet fuel crediting benchmark, against which all opt-in alternative jet fuel produced or imported for use in New Mexico will generate program credits. Based on the verifiable amount of greenhouse gas emissions reduced. This demonstrative shows the flatline conventional jet fuel crediting benchmark and the updated declining gasoline and diesel standard based on the corrections made to Table 1 and Table 2 in the rebuttal rule. On the advisory committee process. The rebuttal rule adds some specificity regarding the advisory committee process, including requiring that the advisory committee meet at least every 3 years, a list of category of members that are to be represented on it, and requiring the department's CTFP to provide specific information and analyses to the advisory committee when convened. This stature for an advisory committee is comparable to how other state advisory committees operate. NMED's position is that if the legislature had wanted the advisory committee to have more authority, as proposed by the petroleum industry, the legislature would have specified that in House Bill 41. The legislature has clearly given some state commissions and boards a great deal of authority, like this board, the Environmental Improvement Board, the State Transportation Commission, the Acequia Commission, the Civil Legal Services Commission, the Border Authority, just to name a few. As expressed in the 1995 State Joint Memorial 46, the legislature has expressed concern over the proliferation of boards and commissions in the executive branch and requires the Legislative Finance Committee to do an annual assessment of all the 282 boards, committees, commissions, and councils the state has established. What seems immensely important to the sound functioning of the New Mexico CTFP is NMED's team's interest and willingness to seek, digest, and incorporate ongoing feedback on key program elements. The CTFP team has demonstrated and commits to publicizing announcements on key components as prescribed throughout the rebuttal rule, holding open listening sessions as warranted, and of course, engaging with parties on a case-by-case basis as needed. Recognizing that communication and collaboration is a key to the success of this program, the CTFP looks forward to meaningful engagement with all parties here and others that engage with the program in the future. Chair Sweeney and members of the board, I want to leave you with a few final considerations on the CTFP rule. The rule is a product of a thorough, detailed, comprehensive work by Team CTFP. The rule provides the roadmap for the implementation of a feasible, unbiased, balanced New Mexico CTFP that provides significant benefits to New Mexicans. The rule implements the direction, as we understand it, of the enabling statute. It has undergone revisions to better fit the needs and asks of the petroleum industry and the clean fuel producers, while holding fast to the requirement that the CTFP achieve verifiable greenhouse gas emission reductions. The rule will require updates in the coming years. These updates will give the department, hearing participants, and other parties the opportunity to add elements appropriate and beneficial for the future needs of the program. And key, Team CTFP is ready to implement the rule and open up shop to reduce the carbon footprint of fuel consumed in New Mexico April 1, 2026. Going forward, the CTFP looks forward to a productive collaboration with all the program participants, demonstrating what we can achieve here in New Mexico. If the board approves Part 92, let's all roll up our sleeves and get to work. Thank you for your focused attention to this rulemaking.
Thank you.
Thank you, Bureau Chief Borchert. Madam Hearing Officer, I would now like to move for the remaining NMED exhibits to be admitted. This would be NMED Exhibit 124, Bureau Chief Borchert's rebuttal testimony, and the supporting NMED Exhibits 125 to 127.
I'll pause for a moment in the event there are objections. They're admitted. Thank you.
Thank you. I will now hand these witnesses over for questions from the other parties and the board.
All right. And I realize I should flip the order of cross from what I have been doing. So we'll start with Mr. Molenberg or Mr. Trujillo. But let's take a short break before we do that. 10 minutes. Come back at 4:13.
And Leroy, L, lowercase e, capital R-O-Y.
Thank you.
Thank you, Pam. We're coming back after a short break. Y'all remind me to greet your neighbor at church. Mr. Trujillo, would you like to begin the questioning of the second NMED panel?
Can you hear me now? Madam Hearing Officer, appreciate the opportunity to ask some questions here. I'll begin with in reverse order. So I'll start with the Bureau Chief Borchert. Is that the right way you say it? Okay, good. Bureau Chief Borchert, under the revised NMED implementation plan, full implementation begins April 1st of 2026, correct?
Yes.
And the revised NMED implementation plan would include both deficit and credit generations and reporting, correct?
Yes, yes. I just want to be clear that that doesn't start on April 1, but yes, to answer your question.
Okay. And tables 1 and 2 show a 1.8% CI reduction target for 2026, meaning that credits will need to be generated and retired sufficient to cover the 1.8% target reduction for 2026, correct?
Let me just make sure that I know what the numbers are. Could you repeat the question, please?
Certainly. Tables 1 and 2 show a 1.8% CI reduction target for 2026, meaning that credits will need to be generated and retired sufficient to cover that 1.8% target reduction for 2026, correct?
Yeah, I think I'm I'm pausing a little bit on your statement by 2026, because the extended compliance period now means actually that those credits need to be retired technically by April 30th of 2027 to meet the 1.8% reduction you're talking about in 2026.
Gotcha. My next question is this then. Immediate deficit generation would mean that there would be immediate demand for generation of credits to cover deficits, correct?
And I don't think that's correct. The immediate demand is again what I'm just pausing on, because the need to demonstrate compliance happens by April 30th, 2028. So while deficits are indeed generated in every quarter, because people are required to report deficit generating fuels, the regulated fuels, a regulated party with deficits could wait until April of 2028 to amass all of the credits they need to come into compliance.
And likewise, could they do the reverse of the scenario you just gave?
Yes, they can start demonstrating the credits they have either earned by bringing in clean fuels or by buying or acquiring in whatever way credits and bringing those into the system. They can do that anytime after April 1.
Thank you. Under the NMOGA API proposal to postpone generation of deficits, So let me start that over again. Under the NMOGA API proposal to postpone generation of deficits, that proposal would allow all credits generated in the initial phase of the program to be banked for future retirement to offset future deficits, correct?
Objection, Madam Hearing Officer. Specific analysis regarding perspective on what the NMOGA API proposal is intended to mean is outside the scope of Bureau Chief Borchardt's testimony. It would be outside the scope of her knowledge as well. She can only testify to what she thinks it means. And so I don't think the question carefully asked that.
All right. Would you rephrase that and limit it to her testimony?
So, Bureau Chief Borchardt, let me rephrase the question a little bit. And again, I'm calling for based on what you think, because you've testified correct on the different proposals at times of NMOGA and API, right?
Have I testified on the yet to the degree to which I've testified to the fact that our proposal, the rebuttal rule, has simultaneous credit and deficit generating over the first compliance period. I understand, if you look at, there's AFPM and yours all have different timeframes, different reporting. Some of them start the credits, some of them are reporting only, some of them, so I can't really speak to the differences between the various petroleum industries proposals.
So does that mean you're unfamiliar with NMOGA and API's proposed modifications to the rule?
Well, I think that I wouldn't quite say I'm unfamiliar, but if you ask me the details, I'm not sure I could distinguish between the one that you guys presented and the one that AFPM presented, because they shift by 6 months and shift in what happens during various periods.
Well, I'll go ahead and move on in that case. I'm going to switch over to Dr. Rosso.
Okay.
Dr. Rosso, and I believe you covered this, and I was trying to make sure my notes are correct on this. I got some clarification questions. First, how many positions did you say you expect that NMED will need to fill for the program at this point? I think it was 8, is that correct?
I filed 8 job listings.
Filed 8 job listings. And how many have you currently filled of those?
1 is currently filled, but all 8 of them have been interviewed for and are in the process of being hired.
And I believe you said January was the expected time frame. Is that correct?
By January.
By January. I know there's some unique requirements under the state law to hire folks, and at this point, have all the necessary approvals to hire those positions been met, including approvals from the Legislative Finance Committee?
I'm not quite sure how to answer your question. The positions have been created through the state personnel office, which is a process that happens before we can conduct interviews. Well, before we can advertise the positions. And we have to advertise the positions before we can conduct interviews.
And those are the only approvals you need is from the state personnel office?
Gosh, I'm sure there are more approvals needed than that. I would have to refer you to NMED's HR that takes care of most of those.
We won't do that because we're close to the end. Dr. Rosso, related to that, does NMED have sufficient funding in place at this point in time to cover all of the positions?
Verification of funding being in place is one of the requirements that we go through before we are allowed to advertise positions.
And you mentioned training earlier, and I didn't quite understand your answer. What are NMED's plans for training these new positions?
Yeah, that's an excellent question, because I think many of us have had to come up to speed rather rapidly on these types of rules. And while the people we find in our hiring pools are very smart, very capable people, they are not always people who have worked previously on this type of program, which is a pretty unique program for New Mexico. So my plans for training include, there are many good YouTube videos out there for this type of program, educational content. California's Clean Fuel program has been going at this point for 15 years, more than 15 years. So they have a lot of content about how their program works. In addition to that, I have set aside, I can't remember if I set aside 1 week or 2 weeks in January. It's on my calendar, for everyone who will be working on this program to sit down for 2 weeks and go through what I'm affectionately calling CTFP boot camp.
Let me ask the question a little bit differently to get to my point. How long of a training period do you expect?
I think we're all learning all the time. I'm not quite sure how to answer that question. I'm 7 years into my career here at NMED, and I have not stopped learning new things. So I'd expect that to also be true for my new staff.
Okay, thank you. Dr. Rosso, I'm going to switch topics on you here. What is the status of the development of the CTFP DMS program at this juncture?
It's in progress. The participant registration module and the fuel supply equipment registration module, which are the two components of that system that will be need to be ready first for registration to begin on April 1st, are undergoing user acceptance testing currently. So that what that means is that both NMED staff and a environmental contractor firm that we've hired are going through and testing the system by making sure the buttons work, making sure they can do all of the things that we specified to the IT contractor that the system needed to do.
Any other future developments for it?
There are many, many future developments for the data management system. I go through these pretty explicitly in Exhibit 130, which is my timeline spreadsheet. The next module that will need to be launched after the two registration pieces is the quarterly fuel reporting module, and that work is in progress currently.
Will the DMS system need to be on at the time for training of the new employees?
That is part of the timeline I've laid out in Exhibit 130, yes. I believe that timeline shows the training for the data management system in particular happening in February.
All right, thank you, Dr. Ross. So one last question for you here. When does NMAD expect the CTFP DMS system to be online for user registration and registrant use for testing and development of the computer system or of the company systems?
I'm sorry, could you repeat that question?
Yeah, I'll rephrase that for you. When does NMED expect the CTFP DMS system to be online for user registration and registrant use?
I expect it to be fully online and public April 1st of 2026. Prior to that, I believe we will likely have what I think I referred to in Exhibit 130 as a voluntary registration period. The intent for that period is not to do a full early launch, but rather to work with a number of select companies, which if you have suggestions, please let me know on who wants to work with us. To work with a number of select companies and get them into the system to do some company testing before we do a full launch and have all registrants in the system at once.
Appreciate the advice. That's part of the reason I'm asking these questions, to know what to expect in a little bit more detail. Thank you, Dr. Ross. I'm going to move on to Mr. Vaughn. Mr. Vaughn, I apologize for keeping you last.
That's okay.
Mr. Vaughn, the revised deferral language adds consideration of credit market to emergency deferral, correct?
Could you say that one more time?
Absolutely. The revised deferral language adds consideration of the credit market to emergency deferral. Is that correct?
Give me just one moment. I believe that's correct, but I do want to double check the language. I believe that's correct.
Well, you got that out and are taking a look at it. That language, though, does not provide specific criteria for when emergency deferral would take place due to credit market conditions, correct?
Could you point me to which subsection or paragraph you might be?
The same section that on the new revised portion you're looking at.
Apologies. I think I need a direct citation to what you're referring to.
Give me a second, Madam Mayor and Officer. We'll find the specific site for you here in a second. I'll move on.
Okay.
On that. Mr. Vaughn, with respect to forecasting, language in the newest NMED rule proposal indicates some changes to who would prepare forecast reports and how. Is that correct?
There are some rule language changes, but I don't agree with the premise of the question that somehow has changed the intent of the department, which I believe is documented in our NOI original direct testimony. Our intent has always been with the memorandum of agreement for the New Mexico Department of Transportation to conduct that independent, unbiased fuel forecasting. So the language that I think you're referring to just tries to respond to some of the comments we've heard in this hearing to make sure that the rule is clear, that it needs to be impartial.
Now, what would those changes be then? Let's take a moment and
So in Exhibit 113, so this would be subsection C, forecast deferral. Number 1 there says the department shall annually arrange for impartial preparation of a transportation fuel supply forecast of the compliance period that ends on December 31st of the next calendar year. The rest of that clause goes on to explain. I'm happy to read the rest of it if you like.
that'll be all right. Okay. That's sufficient. To finish off my questioning on that issue, so there are no specific criteria for deferral based on the forecast report, correct?
I'm not sure that I completely understand the question. The reason I say that is because in subsection D, those are methods of deferral. And subparagraph 2 goes on to describe the types of methods that could be used. So I'm not sure that I would agree with that characterization that there's not any criteria.
So there is specific criteria for deferral based on the forecast report?
So just to be clear, I think that the most important criterion in the forecast deferral occurs in paragraph 3, and it states that if a transportation fuel supply forecast concludes a credit shortage, meaning the amount of forecasted, generated, and banked credits available during the next compliance period is less than 100% of the credits projected as necessary for registered parties to comply with the CTFS, the department shall issue a forecast deferral declaration no later than December 1, the year of the transportation fuel supply forecast, concluding a credit shortage, and announce the action upon issuance. That is the absolute number 1 criterion.
And that is contained where?
This is section 601, authority to defer, subsection C, which is forecast deferral, paragraph 3.
But under the forecast isn't the trigger, correct?
The forecast,
the forecasted report?
The report, sorry, I don't.
The forecast report that is now included, is that a trigger? Any outcome from that, is that a trigger for deferral?
if a transportation fuel supply forecast concludes a credit shortage, which goes on, the rule goes on to explain what that means, then the department shall issue a forecast deferral declaration.
Okay, thank you. Let's go back to the previous one. You asked me for the side. It was 20.2.92.601B.
Okay.
Give me a
I'm
second
there.
to look at that. You there?
Yes, sir.
So I believe I was asking you about the specific, that language does not provide for specific criteria for when the emergency deferral would take place due to the credit market conditions, correct?
So under 601B1, the subparagraphs A through D essentially describe what the department shall consider and how much weight it would give to the appropriateness to make that decision.
So would you agree with me that basically it leaves it to NMAD's discretion?
I think in large part, yes, it is. The emergency deferral is about the department's discretion. And I think that's important because essentially setting up, some type of auto deferral mechanism would remove the department's discretion that may be necessary. If you can imagine a scenario in which the department wanted to take that type of action to issue an emergency deferral, I would think that it would be in really everyone's interest to make sure that the department has the discretion to act quickly and respond to those conditions. And really, the conditions we're talking about tend to be, natural disasters and force majeure events. So I think that it's important that the department especially retain more discretion over emergency deferral.
Thank you, Mr. Vaughn, for that answer. I'm going to go back to the beginning of the whole process, and you discussed the advisory committee. I'm going to ask you a couple questions on the advisory committee, Mr. Vaughn. More so to understand, I think I understood what you testified to and that was in it, but they're still a little bit confused, so bear with me. I believe you said, at least in your oral testimony, that consensus was not the goal of the advisory committee. Is that correct?
That's correct.
I think you are familiar because you've testified in a couple instances. You're familiar with the statutory requirement 74-1-18 B, dealing with the advisory committee?
Yes.
And you've interpreted as a regulator, I'm assuming, being consistent with the instructions given. So I'm not necessarily calling for a legal conclusion. I'm going to ask you some questions talking about your interpretation as a regulator. And I'm going to start by asking a question going forward. So is your intent?
Can I just highlight, it might be helpful if I had a copy of the statute.
I'm doing it online. You can have my computer. Thank you for grabbing that.
I might not have it. If anyone is else, you have.
You can have my computer.
Pull it up on this computer.
Oh, no, send it.
Oh, we got it. Yeah, we got it.
Are you with me now, Mr. Vaughn?
Yes, sir.
Before I delve a little bit more into there, since to get you thinking about it, I got another question for you regarding your testimony. Did I hear you right when you said that the advisory committee is not required to review the proposed rule? Am I mischaracterizing that in any way?
No, that is correct.
And you see paragraph B at the very end of paragraph B, it says the advisory committee, and I'm paraphrasing, and I'm going down to literally the last one, 2, 3, 4, 5 words. It says, and periodically review program rules. Do you see that?
I do.
How does that comport with your previous answer that the advisory committee is not required to review the proposed rules?
So to be clear, my answers have not changed from what I have testified to in my written rebuttal testimony. Specifically, in, I believe this is section 3 that begins on page 16 of my testimony. I walk through the exact process by which I believe that this is outside of the scope of what the statute calls for. And so really, I think that's the best that I can do in explaining my argument. So I would just refer you to that section of my testimony.
So each future, I believe in the revised proposed rule that, or the most recent version of the proposed rule by NMAC, meet every 3 years, right? So do you intend on never having every 3 years, or at least every 3 years, the advisory committee not review any proposed rule changes?
So I do believe that I've also stated in my testimony that there currently for this rulemaking and for future rulemakings, the department does not intend to seek some type of approval from the advisory committee on proposed rules. The statute, what it's calling for, and particularly in my opinion as a non-attorney, but as a regulator that you referred to at the end that says and periodically review program rules, I've gone into detail in my testimony to describe the difference between a proposed rule and a rule. Those are legally distinct terms. And so I believe what the statute here calls for is a review of the final promulgated rule. It does not otherwise call for the advisory committee to periodically review proposed rules. So that is distinctly different. And so it is our intent that we wouldn't take a proposed rule to the advisory committee. We would, in fact, bring it before the Environmental Improvement Board. But that's not to say that we would ignore the input of the advisory committee, and that's not to say that we would not allow the advisory committee to periodically review the final promulgated version.
Would you wrap up your questioning, Mr. Vaughn?
Absolutely. Mr. Vaughn, one or two quick final questions on that whole issue. So periodically review program rules in your interpretation does not include reviewing any type of proposed rules that 3 years from now the department may be looking to change different versions. You're not going to present that to the advisory committee. Is that correct?
Objection, Madam Hearing Officer. Asked and answered in many ways.
I think he has given you his best answer at this point.
I remain confused, but I'll proceed forward with the next question.
Thank you.
Mr. Vaughn, my final question would be, would you agree with me that words matter when it comes to providing input for particular rule provisions?
Section vague and potentially speculative.
If you have an answer, Mr. Vaughn, go ahead.
I mean, of course, words matter, and that couldn't be more true to someone like myself who is a rulemaker and takes pride and really making sure that we are considering the words that we're putting into the program.
And would you, one more final question along that line of questioning, would you agree with me that perhaps getting input on proposed rules from the advisory committee would be of benefit prior to actually petitioning the Environmental Improvement Board for any rule changes?
So I think for the reasons I've stated in my testimony, the short and simple answer to that question is no. But nonetheless, I have also stated that we do believe it is critically important to take input from the advisory committee on the final promulgated rule. That would include, I imagine, advisory committee members suggesting how the department should revise the rule language. And as I've stated many times before, the department would take that under consideration. That does not mean that we would introduce that in a proposed rule for the advisory committee to review.
Thank you, Mr. Vaughn.
Thank you, Mr. Trujillo. Ms. Olson, would you like to question one department witness or more than one if it's short?
Okay. In the interest of time, I realized I walked up here without my notebook, but I have page references, so if we run into trouble, I'll run back and grab it. Good evening to all of you. I know it's been a long day. Move forward with this, and then you tell me when to stop, hearing officer, and we'll pick up again tomorrow. Carrie Olson on behalf of American Fuel and Petrochemical Manufacturers. I'd like to start with you, Mr. Vaughn, but I recognize you're here as a panel, and I have no issue with you deferring to your fellow panelists or passing questions to them to provide further answers. So starting with your background, you're a rulemaking specialist, correct?
My full title is Rulemaking and Strategic Initiatives Specialist, yes.
Okay. And you testified on page 17 that you've led the development of the rule in question as directed by the New Mexico legislature. Do you recall that?
I do.
Based on that statement, is it fair to assume you considered the legislative authority granted to the board and to the department in developing the rule proposal presented by the department in this proceeding?
I think I followed. Maybe just a clarifying question. You're just asking if I have reviewed the statute that's related to this rule?
Not just the specific CTFP statute, but the legislative authority granted to both the Environmental Improvement Board and the New Mexico Environment Department under the Environmental Improvement Act.
Yes.
Can you turn to page 19 of your testimony?
Sure, I'm here.
And here you provide an analysis of the Environmental Improvement Act in the context of the advisory committee obligations. Is that accurate?
I don't know that I would necessarily call it analysis so much as purely logic.
Okay, I'm not sure what the difference is. I'm not trying to trap you or trick you. And so my question in your bulleted list on page 19, you state NMED is the agency prompted to conduct this rulemaking. Is that accurate?
Yes, that is what I've stated.
And is this statement based on any specific provision of the Environmental Improvement Act?
No, it's not based exclusively on any particular clause of the Environmental Improvement Act. I don't think it's any surprise that the Environmental Improvement Act largely applies to the New Mexico Environment Department. So when House Bill 41 passed, logically, I think the department is the agency prompted to conduct rulemaking.
Okay, but
Madam Hearing Officer, sorry, it's the end of the day. I'm trying to think how to phrase this.
I'm trying to get through this. I'd appreciate.
I just want the record to reflect that council's question asked for an absence of information. Mr. Vaughn's represented that he's a specialist, not a lawyer. And so to the extent there is legal analysis
I'm
not
asking
available.
about legal analysis. I'm asking him about his testimony, and I'm tired of these consistent interruptions.
All right, hold on, Ms. Olson. Ms. Sona, I think the question was to him as a regulator, not as a lawyer. Is that?
Okay, I'm just trying to make sure there's a clear record that I'm objecting if the answer is qualified as him having a legal analysis.
Thank you.
Thank you.
Okay, go ahead, Ms. Olson.
Thank you. I'm sorry, I've once again lost my flow and kind of train of thought on these. So we're talking about the statement in your bulleted list on page 19. And we've already established you're familiar with the department's powers and generally familiar with the Environmental Improvement Act. And are you aware that the Environment Improvement Act allows anybody to petition the Environmental Improvement Board for a new or modification to a regulation?
Yes, I'm aware of that.
And are you familiar with section 7416H of the Environmental Improvement Act, which specifically addresses the department's powers to recommend and propose rules?
Yeah, I'm generally familiar with the concept.
And you recognize that that provision expressly places the department on the same footing as any other person and does not give special status to the department in proposing a regulation?
Objection. This question calls for a legal conclusion that a regulator likely would not conclude.
Madam Hearing Officer, I'm asking him about his testimony based on his knowledge as a rulemaking specialist, which he's testified requires knowledge of the statutes.
All right, so same caution, Mr. Vaughn. If you can answer as regulator, that's great. If you can't, just say that.
Okay, I don't think I could answer that question.
Okay, so you can't answer whether or not that provision, based on the text of that, not a legal analysis, states that the department shall not be given special status. It looks like you have the statute in front of you.
Objection, Madam Hearing Officer. He just answered that question.
I think he said he cannot.
Okay. So do you know whether that provision is the authority under which the department is bringing this regulation?
Are you referring to specifically subsection H there?
Yeah.
I
Objection.
can't answer that question
Okay,
either.
I'll move on. So I want to turn to the enforcement testimony on page 10 of your rebuttal.
Okay.
And I believe both you and the bureau chief addressed enforcement. So if you're not the right person for this question, Ms. Borchard is also free to answer. Has the department identified legislative authority to issue an administrative compliance order, assess civil penalties that the department is asking the board to adopt?
Objection, Madam Hearing Officer. This is outside the scope of Mr. Vaughn's testimony.
Yes, I think it is.
Well, I believe Mr. Vaughn is supporting the proposal for enforcement. It's identified in his rebuttal testimony. So if he is not supporting the department's proposal and Ms. Borchert isn't supporting the department's proposal, I don't know who I can examine about that proposal.
All right, Mr. Vaughn?
Thank you. So just to add a little bit of clarity, these topics, specifically in this part of my testimony, are meant to educate the board about the discussion sessions we had and the topics we discussed and provide a little context. I do think the right person is not me. I imagine it's probably Ms. Borchert.
Do you want to ask the rest of your questions to Mr. Vaughn, though?
Okay, I guess they're presented as a panel, so I have my questions organized by topic, but I can skip around if I think it would be more beneficial to address the topic. But if you want me to skip to another topic and come back.
If you would, just let's finish up Mr. Vaughn and then we'll hopefully adjourn for the day.
Okay. So just so I'm clear, like when your testimony says NMED added a provision doing something, you're just simply reflecting what happened in the draft, but if I have substantive questions about those additions, I should direct them to the bureau chief. Is that accurate?
Yeah, yes, that's correct.
Okay. So I'm going to move on now to the program timeline. You testify on page 5 that April 1st, 2026 is a more feasible date given the current timeline and state rules requirements. Do I understand correctly that this is directed to satisfying state rules requirements and does not speak to the department's ability to have the elements in place by that deadline?
That's correct.
Okay. Do you agree the department needs extra time to prepare for implementation, registration, and reporting for the proposed program?
Beyond April 1, no, I do not.
Okay, on page 5 of your testimony, you also state the department's adjustments to the compliance period provides extra time to prepare for implementation, registration, and reporting. But is your testimony the department doesn't need that extra time?
Sorry, I'm not sure I followed the question. Could you restate it?
Yeah, I think after you talk about the feasibility of the April 1st date, you go on to explain the adjustments to the initial compliance period.
Yes.
And I understood your testimony as stating that adjustment provides the department additional time to prepare for implementation, registration, and reporting. Is that accurate?
Yes, that is what I've stated in my testimony there.
Okay. Do you agree with Dr. Murphy's statements that a role of the state regulation is to establish rules to ensure a stable and functional market?
Objection, Madam Hearing Officer. No foundation to connect this to the testimony of Mr. Vaughn, that it's within the scope of it. Implementation, he shared that these portions of his testimony are talking about the discussion sessions that occurred. So I don't see that it's within the scope.
I think that if he's the leader of this rulemaking effort, that asking him about the purpose of this rules is very much within the scope of his testimony.
Okay, and of his rebuttal?
Yeah, of his rebuttal.
Okay, just restate the question if you would.
Okay, do you agree that a role of the department is to establish rules to ensure a stable and functional market?
I mean, just generally, yes.
And you recognize that some industry participants have testified, based on their experience in other state programs, that the timeline proposed by the department does not allow sufficient time to establish a functional market?
Same objection, Madam Hearing Officer.
Overruled. Go ahead, Mr. Vaughn.
Yeah, I've heard many of the parties in this hearing through writing and orally, otherwise, make those arguments, yes.
Would a board finding that the department doesn't have administrative compliance authority for this program change the department's opposition to a proposed phased implementation?
Objection, Madam Hearing Officer. We're going to substantive positions on phased implementation. That's outside the scope of what Mr. Vaughn's presenting in rebuttal. Perhaps other witnesses would be better suited to answer these questions.
I think that is beyond the scope of his rebuttal.
Well, he is the person leading the charge of this rulemaking.
In terms of the drafting and organization, but that sounds more like a question for Ms. Borchert to me. About 2 minutes.
I'm just seeing, I think the rest of my questions are substantive, so I'm happy to reserve those for the bureau chief.
All right, thank you very much. It feels as though, correct me if I'm wrong, Ms. Sona, that we could break. And do you think we need to start at 8 tomorrow morning? These are our last witnesses. We have just cross-exam now.
No, Madam Hearing Officer, I think that we can start at 9 a.m.
All right. Any objection? Starting at 9? All right. Thank you all very much. Oh, wait. Put your hand down. All right. We'll start at 9 o'clock tomorrow morning and you can finish up this panel. Thank you.